rise. The court today in Michigan County, Washington, within Michigan Sound session. All those having business before the court draws near. The Honorable Judge Simpson.
You may be seated. Court does call the cases. The People versus Lori Anderson.
Ashley Long for the people. Good morning.
Good morning.
Good morning, Your Honor. Hugo J. McIntyre on behalf of Ms. Anderson, who is in the courtroom this morning.
All right. Very good. Thank you.
And the defendant is ready to proceed, Your Honor.
All right.
See.
We're ready as well.
All right. Very good.
Your Honor, I only have one witness. I understand defense may have more than one witness, and I would like sequestration.
All right.
No objection, Your Honor.
All right. Witnesses are hereby ordered sequestered. They must remain in the hallway. They are not to discuss their testimony until this matter has concluded.
Nor watch on YouTube, Your Honor.
Or watch on you.
Thank you, Your Honor.
Yes, Your Honor, there is one other matter I want to bring to the court's attention. One of the witnesses that we had subpoenaed today was Officer Olivia Boatwright from the Pittsfield Township Police Department.
Yes.
Subpoena was sent to her on June the 7th.
Okay.
And I've been in contact with her command officer, and she is on vacation. So we emailed it and we sent it to the police department. So I'm not quite sure what happened, but I don't know Officer Boatwright, but I hear she's very reliable and trustworthy. So something has happened.
But she's on vacation at this time?
Yes,
you're informed she is.
Yes. But she is not an officer that was directly involved in reporting this situation. She's an officer that my client spoke to later on relative to the situation. I would develop that once the trial starts. So she is not, I don't want to say not relevant, but not relevant.
Okay. So you don't know whether, I mean, obviously you subpoenaed her. Is her testimony then crucial to your defense of this case, or?
It is tangential, Your Honor. It is tangential.
Okay. So I guess when we get to that, we'll deal with it.
All right.
I guess it's probably the best way I can. All right. Let you make an assessment as to whether or not you would need her testimony or want it. Ms. Lundy.
And that is what Mr. Mack and I discussed as well. I let him know that I didn't anticipate that I'd have much for Officer Boatwright, if anything. So it would really be his witness. And if he felt he needed her to do the trial, that I was flexible with that. I understood that he may need her.
Okay. All right. Thank you. Have the witnesses been adequately sequestered?
Yes, sir. My sole witness is still in the courtroom.
Okay.
With his support person.
Got it. Okay. Then you may proceed.
Thank you, Your Honor. With defense's consent, I will waive opening.
Any objection, Mr. Mack, to?
No objection, Your Honor.
All right. Would you like to give an opening now, or would you like to reserve or waive your opening?
Your Honor, I would like to reserve our opening.
All right. Very good. Thank you. You may call your first witness.
Marcos Lascanos.
Please come forward and be sworn.
Before you sit down, raise your hand. Swear affirm the testimony you're about to give me, the truth, the truth, and nothing but the truth, as we have. Go ahead, have a seat, and state and spell your name.
It's Marcus Lascano, Marcos, last name Lascano, Lascano.
All right. You may inquire.
Sir, are you familiar with the address of 4259 Shandy Court?
There.
Sorry?
Yes, sorry. I just didn't live there long, so it's hard to remember.
That's a place you lived? Is that a yes?
Yes.
So we're making an audio recording of all of our proceedings today. And when we have the mms and the things, they don't show up great on the recording. So if I ask you for clarification, please don't be offended. It's just for the record. That 4259 Shandy Court, what township is that in?
Ypsilanti.
That's in Ypsilanti. Do you know if it's in Pittsfield Township, Ann Arbor Township? Do you recall?
No.
Do you know that it's in Washtenaw County?
Yeah.
Okay. And do you know it's in the state of Michigan?
Yes.
Your Honor, I ask the court to take judicial notice that 4529 Shandy Court, Ypsilanti 48197 is in Pittsfield Township.
Without objection, the
No
court will
objection.
take judicial notice that that is located in Pittsfield Township.
Thank you, Your Honor. You said you lived at that address, sir?
Yes.
When did you live there?
For about 2 months, November and September, I believe.
What year?
2024.
Did you live there with anyone else?
I lived there with a few other people. I remember, I lived there with Lori and I don't remember his name. I lived there with another roommate named Paul. And then I lived there with another roommate. Forgetting his name as well. And then I lived there with another roommate. That was only for a week. It was just a lot of people shifting in and out of this house.
You mentioned the name Lori Anderson. Who was that?
Was my,
Your tenant?
yes, the person who owned the house that I stayed at. And I rented a room at that house.
So the person that owned the property where you were living, you called that person a tenant. Have you ever heard that person called a landlord before?
Yeah, sorry, landlord.
Do you see the person you know to be Lori Anderson in the courtroom today?
Yes.
Can you please identify her by an article of clothing that she's wearing and where she's sitting?
It looks like she's wearing-
And where is she sitting?
she's sitting next to lawyer, wearing the blue suit coat.
Your Honor, may the record reflect the witness identify the defendant?
Without objection, record shall so reflect.
Do you recall having contact with Miss Anderson on November the 16th, 2024 at that address on Shandy in Pittsfield Township?
Yeah.
How did you first have contact with her on that day at that address?
We didn't really talk much. It was mostly just brief and curt, like saying hi, hello, not much. So I don't remember much from that day. If we did communicate first throughout that day, it must have been that. But the first solid interaction I remember throughout the day, must have been through that text that I sent. The text to everyone who lived in that house, which included her, which was just me saying that I needed to get my laundry done.
And did she live there?
No.
Would she stay there?
She spent multiple days there, spending the nights there.
How do you know she would spend the nights there?
Because she keep her car there, and she would sleep there in the spare room with her dog, and her dog would bark a lot, so that was also a lot of.
This property, can you describe kind of how it is set up, what it is? Is it like an apartment building or something else?
Regular type home. You have probably 1, 2, 3, 4 bedrooms upstairs. One of them was the office, but she just mostly not really much of it looked like on the inside. Maybe it was the couch. Sleep on better. The son's room, my room. It was my roommate's room, Paul. Then it also had the laundry room and a bathroom. And downstairs were the kitchen. And a basement, which Lori had eventually converted into another bedroom. Or another room.
Do you have permission to approach the witness with what's been marked as People's Proposed Exhibit 1?
No objection. No.
All right, yes.
I've shown it to defense counsel. Sir, I placed in front of you what's been marked People's Proposed Exhibit 1. What do you recognize that to be?
Looks like the second lease that we signed.
And is this the one that was applicable at the time of this incident, November the 16th, 2024?
Yes.
Have you had a chance to review that earlier this morning?
Mhm.
Is that a yes?
Yes, sorry.
Is this a fair and accurate copy of your lease?
Yes.
Move for the admission of one.
Any objection or voir dire?
No objection, Your Honor.
All right, exhibit 1 is admitted.
Permission to publish to the court?
Yes.
Can you go ahead and pass that up to Judge Simpson? He's going to take a look at that.
Thank you, sir.
So on November 16, 2024, after you had texted the group chat about needing to get your laundry done, did you ever see Miss Anderson?
No, all I kept hearing was the laundry machine going off.
Okay, so what laundry machines were there in this house that you recall?
There was 2 laundry machines. It was the washer and the dryer in the laundry room.
What time do you remember doing your laundry?
I must have tried starting at 9 o'clock, 10 o'clock.
9 or 10 o'clock at night? All right.
Yeah, I wasn't able to do my laundry throughout the whole day because the son had kept his laundry in the laundry machine all day.
When you say the son, whose son is that?
Florida's son.
Now, as you heard your laundry machines going off, what did you do?
I was hanging out in my bed waiting because I needed to do my laundry for work tomorrow. I kept hearing them go off. It wasn't like immediately like, oh, stop. It was like, oh, they're not going on anymore. So I get up, go in, turn them back on, and then I'd go and text and I'd say, can't I probably go back on my text, look at them. What I said was, hey, I need to do my laundry for work tomorrow. There was laundry stuck in here all day. It needs to get done.
Were the laundry facilities shared from everybody in the house?
Yeah.
When you went back in to check on your laundry, did you ever see anyone else in that room?
No, it seems like whoever was turning out, whether it was their son or Lori, it seemed they kept doing it as soon as I left. I turned it out and turned it back on.
At some time later that evening, did you ever see anyone else in that room?
It was only after maybe the third or second time that I had turned it back on. I eventually just stayed in that room because I felt like I had to guard my laundry.
What happened next?
What happened after that was eventually Lori had come in and saying that it was too loud and we don't do laundry after this time. And that it was time, we're not doing this anymore. She turned it off. And things just started escalating from there. I tried explaining that laundry stuck in the machine all day and that I had to do my laundry for work tomorrow.
At any time, did she ever start handling your clothes?
Yes,
What happened?
that's when I brought up my phone and started recording. That's when I started telling her, this is my property, these are my clothes, you're not allowed to be touching my stuff.
What happened after you started recording?
She just kept going. It didn't matter. She just started doing what she was doing. She didn't care about anything. She just said I started needing to get out of her house, that I'm done, that it doesn't matter. And then just things started escalating. She started grabbing my stuff. And then she wanted to get out of the room, started turning off the light on.
Okay, let's slow down.
Sorry.
It's okay. Let's just slow down, take it one question at a time. So when you said you started recording, is that right? Is that a yes?
Yes.
Have you had a chance to review one of your recordings this morning?
Yes.
And was it a fair and accurate copy of the recording that you made that day? Okay. Your Honor, I'm gonna move to the admission of Peoples 2, which is video titled IMG, and that's India Mango Golf 4676. This has been disclosed in discovery.
Objection, Your Honor.
All right, you may go ahead.
Thank you. And as always, Your Honor, I'll work on the sound balance, but it can be rather tricky. I'll see if my display settings are recognizing a second monitor. Yes, they are. I will duplicate and that will fix it, I think.
You're not gonna touch my property. You can't touch my property. Can you please not touch me? Can you please stop touching me? Can you please stop touching me? No, I can't live here. What the hell? No, you can't do that. How can you do that? Have you sent me an eviction notice? No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go for it. Please stop touching me. Please stop. You're grabbing your hand. Okay. She's not grabbing me. Look, I'm gonna keep this light on.
Mr. Loscano, what happened after the end of People's Exhibit 2, that video? Maybe, may I rephrase, Your Honor? Excuse me.
Yes.
Mr. Loscano, what happened as that video was ending?
Her son started getting involved.
And did anyone touch you? Who touched? Is that a yes?
Yes, sorry. I know two people entered the room, and I know that it was dark. I know my phone was taken away from me. That's why I stopped recording, and I know I got pushed up against the wall.
And who was the person that pushed you up against the wall? You don't know?
I know that as soon as I started feeling threatened, the lights were up, and I felt myself pushed against the wall. That's when I said, I had a pepper spray in my pocket. You go back off with me. I'm going to that myself. It felt like it was one person. I don't know. That's when the son stepped in as well. But yeah.
Mr. Loscano, did you consent to Miss Anderson grabbing your fingers on the light switch and touching you in that way?
No.
Did you give her permission to do that? At any time during this evening, did you grab her breast?
No.
Did you at any time grab anywhere else on her body?
No.
What happened after this all happened in the laundry room?
After I told them I had pepper spray, whoever was pushing me against the wall backed up. And the son threatened to then kick my ass if I did anything. And then that's when I called my roommate Paul for help.
Did Paul contact the police or did you? Okay. May I have one moment, Your Honor? It's okay.
I think I may have made a note because I believe he didn't want to get one involved. He was too scared about escalating.
Give me just 1 second, sir.
I'm sorry. He said something about he was too, I didn't hear was
Scared?
I object to that being admitted, Your Honor, as characterization as to what somebody else was feeling. Or matter of fact, where is Paul? Paul can testify for himself. Is he here?
Well, I understand that. I don't know that that has much bearing for the court. I mean, the question was who called 911. So I'll overrule your objection, but I can't see it having any consideration for the court.
Your Honor, I understand.
Pass the witness.
All right, cross-examination.
Your Honor, I confess to not being a slave to technology as the court's indulgence.
We are well aware, Mr.
Well, thank you, Judge.
We will do what we can to assist you through that part.
Okay.
You're gonna play something.
Yes, actually,
Oh. All right. I was gonna say you broke it, just to scare him. You're gonna blame me? Okay.
Your staff was so helpful. Well, Your Honor,
Did you need some assistance? It's okay. Did you need some assistance? I don't
she
know.
was so helpful. It was working just fine before.
It looks like,
Plug in the HDMI.
yep, you're
You
connected
did.
to the internet.
No, to this.
Yeah, but why isn't it coming up?
Click here to network access.
Why is it coming up? Amazing. Simply amazing. I'm sorry, what happened?
Oh, okay, so now you should be able to go back to your email, I believe.
The court closes now?
And now refresh your application.
Click on it, right?
Yep. And then once you plug into here, you should be good.
Okay.
Oh, yeah, I'm plugged in.
This is,
He needs to go.
see, this is why I count on my public servant route. No, seriously.
It's okay. I charge for her service. We'll send you the bill, Mr.
Okay.
Are you gonna be seeking the admission of this or is this the same video?
Judge, this is the, this is the same video. Oh, excuse me, I'm sorry, that's another case. Sorry, apologize. This is the same video, and I apologize to the.
No, it's okay. It's okay.
I don't understand how.
I just want to make, it's the same video as Exhibit 2.
It is.
All right.
It is. The,
Oh, no, you're touching my clothes now. That's not okay. You can't touch my property. You're not allowed to touch my property. So.
it's playing, but it's not on the screen.
Oh, there we go. Okay, now we got it.
Oh, I'm kind of sweet.
You can't touch my dog. Please don't stop it.
So I'm going to stop the video right there. Is that your voice on the video? And isn't it true that that is your phone that you're making the video with? Is that true?
Yes.
Now, the state had previously admitted People's Exhibit 1. We have the exact same lease. I can ask for it to be marked, Your Honor, if it's
Is
necessary.
it the exact same?
Exactly.
You're gonna question him on this?
Yes.
Okay, I'll just hand that back. to
So,
you,
I don't know if the necessity of me admitting this, unless the court feels I need to. It's the same
sir.
exhibit.
Same, no, that's fine. If you're gonna, you can question him on Exhibit 1 then.
Okay. Now, that is your signature at the bottom, correct, sir?
Yes.
Now, and look, in terms of house rules, doesn't it say must maintain quiet hours after 9 p.m.? And when you say that some laundry was in the laundry room 9 or 10, you didn't call the police till well after 12 midnight the next day, sir.
Objection is to form.
Yes, is that a question?
Well, isn't it true you didn't call the police till well after midnight?
Not sure what exact time I called the police.
I don't know what time it's called.
Well, do you remember talking to the police outside on the front porch that morning, sir? Okay. So is it your statement to this court that you don't know if it was well after midnight when you called the police?
The police were probably called to late tonight.
Okay, I'm not talking about late in the night, I'm talking about after midnight.
Yes, they were called late tonight, so I guess it was called after 9 p.m. quiet hours.
Okay, so when you tell the judge that 9 or 10, some vague time reference there, clothes were in there, this incident didn't happen at 9 or 10. This incident happened after midnight.
You check the police logs and check when the police were called and just after that time.
Okay. So now, isn't it true that where the laundry room is, which is where this video was taken, correct? Okay.
Yes.
The answer, yes.
Sorry.
Isn't it true there are at least 4 rooms right on that same floor where this laundry room is?
Yes.
There is your room. Yes. There was a room where the defendant was staying at, correct? Okay. There was a room where John was staying at, correct? And there's a room where Paul was staying at, correct?
Yeah.
Okay. And isn't it true that that laundry room there is within no more than 15 feet of any one of those rooms?
Yeah.
Okay, so they're right on the same floor in close proximity to each other, correct?
Yes.
And there is in fact a door on that laundry room, correct?
Yeah.
All right. So now, when you were in that laundry room, do you remember telling the police you could have gone to an all-night laundry, but you were fearful of doing so because they go through your stuff when you leave?
I remember telling the police that.
Right.
Yes.
Okay. So you knew you had an option, didn't you, sir? You knew you had an option to go to an all-night laundry instead of being in that laundry room after midnight. You knew that, didn't you?
I don't see how this pertains.
Oh, okay. Well, we have a very competent prosecuting attorney that can make those objections, but your job is to answer my questions. Got it?
Yes, but
Okay. No, sir. I asked you a yes or no question with a yes or no answer. You knew you had an option rather than excuse, sir. You had an option.
no.
You could. Can I finish my question?
Sure, I can answer.
You had an. Can I finish my question?
Did he answer the question? He asked if I had an option. I said
Sir,
no.
sir,
I don't have a.
sir, yes.
Okay.
You will wait for Mr. Mack to finish his question and then answer.
Okay.
Go ahead, Mr. Mack.
You knew, as reflected by what you just stated, that you mentioned to the police, that you could have gone to an all-night laundry, but chose not to because, according to you, when you leave, they go through your stuff. Is that correct?
Yes.
Okay. Now, when you say you put out a group chat, a group chat about laundry,
Yes, it's part of it. We have to protect.
okay, group text. Did you ever present that group text to the prosecutor? Why?
We talked about this group text a lot. Like it's this communication. It's not. Seems like I recorded. I brought it over to every single communication that was brought around. I'm glad to show it to you. It's not something I've been trying to hide.
So this group text, now in the group text, was the defendant part of the,
Yes.
okay, can I finish? Was the defendant part of the group text?
Yes.
Did the defendant give you permission to be in the laundry room after 9 p.m. in the group text?
No.
Okay. The answer to my question is yes or no.
Yes.
She did give you permission?
Previous question. Permission not. There was never permission not being people.
Well, you say there was never permission to not being there either, but there was a lease that said quiet hours after 9 p.m. Okay, correct, sir? All right. Now, in terms of you being in the laundry room, even though you knew you had options, you went to that laundry room armed with mace, did you not?
Yes.
Okay, so you went to a laundry room when you knew you had options, armed with mace, correct?
Yes.
At any point in time, did the defendant ever assault you or threaten you with mace?
No.
So when the video is playing and the clothes are being taken out, the whole nub of this entire situation is she wanted to turn the light switch off for you to be out of a place you had no right to be in the first place. And you want to keep the light switch on. Isn't that just the whole sum of this whole thing?
Object, this is speculation.
I'll sustain that. You'll need to
And
phrase your
compound.
question.
What, when you were, let's just say, finger tussling with the defendant, what was your goal, sir?
To
When you were finger tussling over a light switch to feel safe?
maintain my vision, yes.
Okay, so to maintain, so your goal wasn't to keep the light on?
Keep the light on to maintain vision.
Okay, so, but as a means of maintaining the vision, you wanted the light switch kept on, correct? Okay. So isn't it true that when she had turned the light switch on, you turned it off, you turned it back on? I know you got to say yes. I know it's cumbersome, but you got to say, got to answer. Correct?
Yes.
And isn't it true that the only contact that you and the defendant had was in the finger dynamic over the light switch?
No, in the video, you can see her grab my arm.
Okay, but when you say grab your arm and pull it away, it's relative to the control of the light switch.
It's more than finger tussling. She puts her hand on my arm.
Yes.
That's an increased aggression.
Okay, well, okay, like I said, that's why we have a judge. He will decide that. So,
You're just having your hand up. You said fingers.
Sir, he will ask a question and you'll answer. Understood?
Yeah.
All right. Go ahead, Mr. Mayor.
so when the defendant moved your hand away from the light switch, you moved your hand back up to the light switch. Isn't that true?
Yeah.
Why did you do that?
You put the light back on.
Why didn't you just simply leave the room?
Her son and her were standing in the doorway and I wanted to feel safe with my back against the wall to put the light on.
Okay, now her son, you say her son were standing in the doorway, right?
In the video, I said, hang on.
Oh, okay, no. You said her son was standing in the doorway, correct?
I'm being very journalistic. I apologize, but her son was standing in the hallway. The hallway leads down like this, and not trying to come.
Well,
Like he's a pretty big dude,
Well,
6 something. It's
okay.
like, yeah, he's imposing.
well, but excuse me, sir. When you are facing going out of the washroom, okay, her son's room is to the left, your room is to the right.
Left, right. And so I have to go past him, and then he's standing right there.
Okay, so,
I have to pass by him to get there, and he's standing right there.
Okay.
And these aren't my friends.
okay, so are you telling me, and we're gonna play the rest of this video, are you telling me you couldn't turn right when you got out of that door and go to your room?
I want no obstacles in my way before I went back.
Sir, I'm asking a very simple question. When you're exiting out of the washroom, okay,
Sure.
I'm asking you, isn't it true your room is to the right? You turn right to go to your room.
Not before I see both of their rooms, before both people are standing in the hallway.
Okay, sir, I'm asking you a simple matter of a structure of a house. Is it not true when you go out of the door from the washroom, your room is to the right and the son's room is to the left?
No, you're not. I can draw this out for you.
Okay. So what you're saying is you had to pass by John to get to your room is what you're saying.
It's all the way down the hall.
Okay, so now when you talk about the grabbing of the wrist, okay, after she moved your wrist to stop you from turning the light on again,
Yeah.
and you still try to turn the light on, correct? Wasn't there some more like finger dynamic between you and her trying to control the switch?
Yeah, after she left from, I turned the light off, she came back in to turn it on.
Okay.
She kept coming back.
Okay, Yes, but she wasn't coming back to your room. She come back to a washroom, which you were wrongfully in the first place.
Wrongfully in?
Yes.
Object is the characterization of wrongfully in the room.
I'll sustain that.
Okay. You were there after 9 p.m., correct?
That's just quiet. I was like, I'm not in the house.
Okay, sir, please. You were there after 9. Okay. Yeah, okay. You were there after 9 p.m. and you were being quiet?
Yeah, in the video, you hear me being quiet. I was
No, okay, sir. The washer and dryer weren't on when the video was being recorded, were
Exactly,
they?
so it was quiet.
No, but I'm talking about when you're using the washer and dryer.
Close her out. She had taken them out. She didn't have to come back in and turn the light.
Okay. So what you're saying is the washer and dryer were never on at all.
Objection, Your Honor, that mischaracterized.
That's sustained.
Okay, well, are you saying the washer and dryer were on ever?
What are you saying? I never even said that. I'm saying at this point, when she left the room, the washer and dryer were off. She was
Okay.
taking the clothes out and she's like, you know what? Now you're out of the room. Now I'm gonna shut the lights out.
Yes, okay.
Back in.
Okay, but before that, you were using the washer and dryer, correct?
Yes.
Okay.
Yes, I was never denied that.
Okay. And this was after 9 p.m.
Sure. Yes.
Okay. Now, when you and the defendant were finger maneuvering for control of the light switch, was it ever your intent to harm her? Was it ever your intent to intimidate her? Was it ever your intent to put her in threat of some kind of a physical harm? And you did have contact with her hand, correct?
Yeah.
And you were finger maneuvering against her for control of that switch, correct?
Yeah.
Just one more minute, Your Honor. Just one minute. For this witness,
All right.
I would ask that has the lease been marked as an exhibit and admitted, Your Honor?
Exhibit 1 is the
Yeah.
second lease.
Yes.
That's been marked and admitted. And I don't know if there was a formal motion to admit exhibit 2.
If there wasn't, I intended to, Your Honor, it would be an oversight on my part. I don't think there's any objection from defense counsel, so exhibit 2 should.
Any objection?
No.
Okay, exhibit 2 is admitted.
Thank you, Your Honor.
Thank you, Judge. I said, Your Honor, I have no
Further question. All right.
further questions.
Any redirect?
No, Your Honor.
All right, very good. Sir, you may step back. Well, I do have one clarification. Sir, the clothes that were taken out of the dryer, which I guess would have been machined to the right, that was the dryer? Well,
I don't remember if that clothes being taken out or what.
pardon?
I don't know if you're asking if the clothes were wet or not.
Well, I'm asking which machine was that?
Like those were my clothes that she was taking out. The rest.
Yes, were they dry or were they wet?
I know those are my clothes.
Okay. I get that. The question becomes, where, was that the dryer they were being taken out of or the washer?
I remember they weren't done. So I remember
Sir.
they're still wet. That's what I remember.
You recall the video, correct?
Yeah,
Okay, in looking at the video, if you come in the door, there's a machine that's to the left and a machine to the right. Is that a yes?
yes,
She is taking clothes out of the machine to the right. Is that correct?
yes.
Okay. My question to you is that the washer or is that the dryer?
Just when based off of working with washers and dryers, I assume that would be the dryer, but I don't remember exactly. So I feel like washers are usually put on top.
Well, I don't.
I don't remember, I'm sorry.
Okay. All right. Okay.
Maybe no follow-up based on the court's questioning.
Any follow-up based upon my?
No, Your Honor.
You may step down.
Your Honor, may this witness be excused?
Any objection?
No objection, Your Honor.
All right, this witness is excused.
Mr. Loscano, could you hand that back to the court, exhibit 1, please? Oh, I'm sorry. I apologize.
All right, you may step down.
The people rest, Your Honor.
All right, very good. For the defense.
Yes. Your Honor, first of all, I'd like to make a motion for a directed verdict in this matter. I would like to make a motion for a directed verdict. This court knows better than anyone else in the courtroom what the Michigan criminal jury instructions are, which obviously apply to a trier of fact, which is, in this case, Your Honor. There is absolutely nothing here to show anything other than people finger tussling on the control of a light switch. There is no indication here of the defendant trying to harm or threaten. There's no evidence here that she said, look, if you don't leave this room right away, I'm going to kick your blank, blank, blank. There's no balled fist. There's no punch. There's no kick. There's no I've got mace, contrary to what the alleged victim had. There is simply nothing here other than a landlord-tenant issue that is more suited for a civil matter than a criminal matter, Judge. And so even if looking at in the light most favorable to the state, I just don't see how any kind of intent can be induced from two people in a matter of 15 seconds trying to fiddle over a light switch. So that's my first statement, and depending on what the court says, I'll be making an opening statement.
Response.
Your Honor, I do believe that at this point, viewing all the evidence submitted in light most favorable to the people, a reasonable fact finder could conclude that the initial aggressor in the touching was the defendant. And I'll also further state that the defense counsel said there were no evidence of threats. The threat of you're out on the 22nd could be characterized as a threat. That statement about attempting to tell somebody that they can't leave, to leave their house when they're a tenant, that could be characterized as a threat. I'm not saying it is, but I do believe that there's enough evidence here for us to continue going and let the court be the finder of fact in this matter.
Anything else regarding your motion, sir?
No, Your Honor.
All right. With regard to a motion for a directed verdict in essence, the court does believe that a reasonable fact finder viewing this evidence in light most favorable to the non-moving party, that being the people of the state of Michigan, could conclude that an offense of assault and battery was committed. One thing is that the notion, and it was specifically asked during defense questioning, that the individual, Mr. Loscano, had the right to be where he was. That is clear from the leasing agreement. So he had the right to be where he was. Why, and also specifically, while that may have been the beginning of the assault, there is then the ultimate turning off of the light switch, testimony from Mr. Loscano that he is then put against a wall, certain threats about his residency being said and what was going to happen. He also testified that the defendant's son was in the hallway. So I'm not saying that would maintain itself, because I'll hear all the testimony, but certainly at this juncture, the court would deny the defendant's motion for a directed verdict. The court does believe that a reasonable fact finder could conclude that an assault and battery did take place.
Yes, Your Honor. Your Honor, this time we'd like to make an opening statement.
Go ahead.
Your Honor, in this case, we believe the evidence has shown and will continue to show that the defendant is a landlord. And at the time, the alleged victim was a tenant in the house. The evidence will show that a lease was entered into by both parties with a specific statement of quiet hours after 9 p.m. We believe the evidence has shown and will show that the washroom is on the same exact floor of 4 rooms where people live. and that the door was open from the video that the court has seen, and that the noise from the washer and dryer is something that is a direct breach of the lease in terms of quiet hours. We believe evidence has shown and will show that this was not an incident that occurred in terms of complaining witness being in the wash area before 9 o'clock. It was after midnight when this entire matter revolved. We believe the evidence has shown and will show that the defendant was simply trying to exert a lawful prerogative of hers as the landlord to have quiet hours, not only for her enjoyment, but for the enjoyment and security of the other residents of the home, whom she had a responsibility to maintain quiet hours. The evidence has shown and will show, and perhaps, excuse me if I've said this earlier, that the complaining witness knew full well that he had an option. And the evidence will show that he chose deliberately not to exercise the appropriate option in going to an all-night laundromat because he knew that it was improper for him to be there at the laundry room at that time. The evidence will show, Your Honor, that there is a motive that the complaining witness has for bringing forth this false allegation, because what is not caught on the quote unquote videos that the evidence will show has been really tailor-made for
Can we just pause for 1 second? I'm asking if Mr. Loscano can step out in case I do need to recall him in rebuttal.
All right, very good.
Thank you.
Okay, Judge, he's heard part of what I said already, and he was excused already, Judge.
Well, he was excused, but I think during your opening, there may have been something that raised, so
Yes.
he's now been sequestered.
Thank you, Your Honor.
We'll deal with it.
All right. That the evidence, we believe, Your Honor, will show that Mr. Loscano has a motive for bringing forth this false allegation. In his carefully edited videos, there is no video of him touching my client's breasts beforehand. I submit that the evidence will show that that in fact did happen, despite the defendant's, Mr. Loscano's denial. The defendant will testify herself as to the circumstances in the home and what her intent was. So, Your Honor, she will also testify as to contacting the Pittsfield Township Police Department. She will also testify as to mentioning this to a very close friend of hers. So, unfortunately, Officer Olivia Boatwright is not with us, but she was not an officer that was involved in this specific incident, but was someone that the defendant spoke to tangentially afterwards. And in conclusion here, Your Honor, the evidence will show that at no time did the defendant intend any kind of harm, harassment, physical injury, what have you. And the evidence has shown and will show that in terms of any pushing, first of all, the son, John, is not charged with a crime. So, and in terms of some pushing, the evidence has shown that this complaining witness says he doesn't know who pushed him. So how that is proof beyond a reasonable doubt that the defendant pushed him is somewhat stymieing. So, Your Honor, this is what we feel the evidence will show. And at the end of the hearing, Your Honor, we believe there certainly is not enough evidence of proof beyond any reasonable doubt that the defendant is in fact guilty of this matter. And we are ready to call the defendant to the stand at this time.
All right. Ma'am, please come forward and be sworn.
Solemnly swear affirm the testimony you're about to give to the truth, the truth, and nothing but the truth. Yes. Have a seat and then say and then spell your name.
Speak up.
My name is
All right. Go ahead, Counsel.
All right.
Remain quiet.
Ms. Anderson, you are the defendant in this matter, correct?
Yes.
Do you know a person with the last name, Mr. Lascano?
Yes.
And have you been sitting in the courtroom while he testified? Is he the individual that you entered into a lease agreement with in approximately August of 2024? The court has gotten its possession the lease agreement, and if the court maybe could let you look at that, appreciate it. Now, do you recognize that lease agreement, Ms. Anderson?
Yes.
And is that your signature at the bottom of it as the landlord?
Yes.
Now, is that Mr. Lascano's signature also as the tenant?
Yes.
Now, referring to House Rules item number 3, could you please read for the court, what does that state?
Must maintain quiet hours after night.
Now, in terms of the layout of this is a home that you were renting rooms in?
Yes.
Okay. Now, would you tell the court, in terms of the laundry room, and you've had an opportunity to see the video, correct? That was played? Okay. In terms of the laundry room, are there any other rooms in the vicinity of that laundry room on the same floor? Could you please tell the judge how that layout is?
My bedroom is across in the laundry room, and my son's bedroom is next to the laundry room. And Marco's room is, okay, then we have a bathroom, and then Marco's bedroom is further down the hall, and then Paul's bedroom is even further down the hall, and then garage is in the basement.
Okay. So in terms of these rooms, how many feet would you say separates a laundry room from these 4 rooms?
For my room, it's 2 feet. For my son's room, it's 0 feet, I mean, it's right next to my son. For Marcos's room, it's probably 10 feet.
I see.
From Paul's room, it's probably 15.
Now, can you please tell the judge relative to the laundry room, what role does the proximity of the laundry room to the other rooms on that floor plays a part in must maintain quiet hours after 9 p.m.?
The laundry machine makes a lot of noise, both the washer and the dryer, and I told Marcos and everyone that the washing machines should be used after 9 o'clock because everyone is going to work, studying interviews. My son was doing interviews for medicine. I was going to work. People were, the household, the whole idea of 9 hours at 8 o'clock was to maintain quiet.
So what is it on the date and time of this incident that drew your attention to Mr. Lascano in the laundry room?
I was sleeping. It seems like it was about midnight. And then I started hearing this. I didn't know.
Okay, ma'am, you've got to talk up.
Yeah.
Maybe it's me.
It was around midnight or after midnight when I heard the laundry machine running and it woke me up.
Okay, now you heard testimony from Mr. Lascano, I believe earlier, saying that at the time the machine, perhaps I'm wrong, but the machine wasn't running at that time or something?
I don't object as to mischaracterizing or at least a clarification. We've got several different timeframes here, somewhere the machine was running and somewhere it wasn't. So I
Yeah, why don't we clarify what time frame?
Okay, at the midnight hour when, okay.
It heard the noise and it woke me up.
Okay, so was there anybody else in the washroom doing laundry other than Mr. Lascano when you were woke up?
No.
And this wasn't at 9 o'clock. This is this after midnight.
Objection leading.
Sustained.
Now, the rooms that were there, the noise from the machine, was your testimony was loud enough to wake you up?
Yes.
Was anybody else awoken by the machine?
Was anybody else on there?
Awoken by the laundry machines?
I don't know. So I woke up.
Okay. Was there a person that was renting by the name of Paul?
Yes.
Okay. To best of your knowledge, was Paul woken up by the machine?
I don't believe so. I don't know. He's 15 feet down, so I didn't see Paul. I don't know if he was woken up or not.
Okay. Okay. So now you've seen the video, and I'd like you to tell the judge, does that video capture everything that happened between you and Mr. Lascano that night? Could you please tell the judge what happened between you and Mr. Lascano before the incident with the light switch and the finger tussling, whatever light switch?
I first turned the machine off and the light off, and I woke up, and I went back to bed hoping it was the end. And then maybe 5 minutes later, I heard the machine again, light was on, so I went out of my room, and when I was going into the room, Mr. Lascano grabbed me.
When you say he grabbed you, what part of your body did he grab you on?
He grabbed my arms.
Would like a Kleenex or something, ma'am? I think there's a box, ma'am. I think there's a box of Kleenexes there. Okay. So
Did she need time to compose herself?
do you need a moment, Ms. Anderson? Okay, because you have to compose yourself so the judge can hear you. Okay. So after this incident happened, where you say he touched your breast, what did you do? Okay, okay, ma'am, if we need to take a recess, we'll do that, but the judge has got to be able to hear clearly what you're saying.
I was in shock. I froze.
Okay, what happened after that?
I remember reaching over, turning off the light, and hoping he would just leave and go back to his room. And I went back to my room, and I thought it was the end. I was processing.
Okay. So did there ever come a time when you and he had some kind of a finger contact about the light switch?
Yes.
Okay, just that's a yes or no question, yes or no answer. Did there come a time when that happened?
Yes.
Okay, could you please tell the judge circumstances what led to that happening?
After several times, he would go in and start the laundry machine, turn the light on. It seems like there was a couple of times. I wasn't counting. I would go in and turn, so we keep back and forth with the light switch. That's what I remember. I don't remember how many times I turned it off and he turned it on. I don't remember how many times that, but it just was constant back and forth, and I was hoping it would just end.
Now, but was there a time when he was finger maneuvering with you for control of the switch?
Yes, he was touching. I mean, I was turning it off and he was turning it on, and it was back and forth with us. And I don't remember how many times, but it seemed like it almost seemed like a game to him. And I was just wanting to go to sleep. Just ended. I didn't want to escalate.
Okay, now when you turn the light switch off, okay, all right? Okay, did his hand come in contact with your hand trying to turn the light switch on?
Yes.
Okay. So I want to be sure that this is clear. He touched, at some point in time, touched your hand trying to turn the light switch on. Did you consent and voluntarily say, please touch my hand to turn the light switch on? Okay. Was that touching of your hand to turn the light switch on, was that against your will? Was that without your consent?
Yes.
Okay. Now, you heard testimony where the complaining witness said someone pushed him, the light was out and somebody pushed him like maybe into a wall or something. Did you hear that testimony?
Yes.
Okay. At any time, did you push Mr. Lascano into a wall?
No, sir.
Okay.
He's bigger than me. I would never.
Okay. Now, in terms of the touching of your breast, at some subsequent point in time, did you have an opportunity to report that to the police?
Yeah, but
Okay, ma'am, just yes or no? Okay. Do you remember the name of the police agency that you have reported that to?
Ms. Boatwright.
Okay, would that be the Pittsfield Township Police?
Yes.
Okay, did you see Miss Officer Boatwright in person?
Yes, sir.
And did you report this incident to her?
Yes, sir.
Okay. Now, in terms of weaponry, at any time, did you have any mace on you, Miss Anderson?
No, I don't have weapons in my house.
Okay. At any time, did you threaten Mr. Lascano with any kind of a weapon?
No, I don't have any. I don't believe in weapons.
Okay, ma'am, okay. At any time, were you threatened by Mr. Lascano with mace?
Yes, sir.
Okay, could you please tell the judge what happened then?
It's that once my son woke up from the back and forth, came out, then Mr. Lasano, he said, hey, I got mace, so back off. You know, it was, he said that, and I'm like,
Okay, but you never had any mace?
No.
Okay. Now, after this incident happened with him touching your breast, do you know a person by the name of Ivory Clinton?
yes, sir.
And who is Ivory Clinton?
He's my dear friend. I've known him for over 20 years. He's like family. I don't have any parents.
Okay. Did you report this incident in terms of the breast situation with Mr. Clinton?
Yes, I told him.
And I'm sorry, when?
Yes, sir. Yes, sir.
And when did you tell him that?
The morning, the next morning.
Okay. And isn't it true Mr. Clinton was subpoenaed to be here this morning?
Yes, he's been outside.
Okay. All right. Ms. Anderson, why did you wait and didn't report this incident with your breast to the police right away?
I didn't trust police. They were strangers, and if you knew my backstory, I suffered sexual abuse and racial abuse growing up as a child. My own mother threw me away because I was half black.
Okay.
And I had
Okay. So what is it that made you decide to report the matter to the police when you did?
time to process it.
All right.
And I didn't trust white authority because in my childhood, when I reported abuse, no one ever did anything.
Okay. All right. So, Ms. Anderson, in this situation, and this is coming to an end here, ma'am, was it ever your intent to harm or threaten or violate Mr. Lascano in any way? Okay. Tell the judge what was your intent in this entire situation.
I wanted to just have quiet peace in the house and make sure that all the tenants, including myself, were safe. That's what I wanted. I was hoping that he would just stop.
Okay. All right, Ms. Anderson, I have no other questions. Prosecutor may have some questions for you.
Cross-examination.
Thank you, Your Honor. Ms. Anderson, what day did this happen?
It was in November.
November 16th sound right?
Yeah.
You were sleeping and it was around midnight when you were woken up by the laundry machine?
Yeah.
And you said it makes a lot of noise, right? And you said your son was woken up by all the back and forth between you and Mr. Loscanos, right? But Mr. Loscanos and you, when you were in having your back and forth in the laundry room, that was after the machines were shut off, right?
I believe I had shut the machine off. And then shut it back on. So we were tussling with the light switch. So I believe, I don't recall if it was on.
So you're not sure what woke your son up, right?
I am not 100% sure.
Okay. And your son's room is closer to the laundry room than yours is, correct? And you were living at this house at the time?
Yeah, on again, off again.
On again, off again? And you saw People's Exhibit 1, correct? The video? I'm sorry, People's 2, excuse me. I misspoke. The video we looked at earlier?
Yes.
And you said that the victim was the only person in the laundry room, right?
Yes.
And you said that you turned off the machine and the light, and then the victim grabbed your breast.
No,
And-
no, when I walked in, he caught me by surprise, and that's when he grabbed my breast, when I first walked in, because that was the second time I had walked in and shut it off when he wasn't there. First time I walked in, he was already in his room, and I shut it off and turned off the light. Then I went back to bed, thought it was okay. Then, about 5 minutes later, I heard the machine again. And so I was gonna just go in and turn it off, turn the light off again. And when I walked in, he grabbed my breast and I froze.
And he grabbed your breast because he was standing at the doorway?
He was in the laundry room.
He was in the laundry room. And then grabbed your breast. And you froze.
I
I'm just asking, you said on direct you froze. I want to make sure I understand.
was just, it seems like all of my childhood stuff started coming out and I just froze.
But you turned off the machine and turned off the light and went back to your room, right?
I don't.
You don't remember? Okay,
I
fair.
You know, I know I shut off the light. I don't remember if I shut off, I don't think I shut off the laundry machine. I know I shut off the light and went back to my room and I hope, yeah, I was just in shock. I didn't.
And from the first time that you went in and shut off the machines and the lights till when we see the video we looked at today, that all happened within just a few minutes, right?
I mean, yeah, I mean, there was probably 5 minutes. There was he turned the machine on. I turned the machine, he went back to his room. I turned the machine off. I went back to my room. And then the second time when I went back in there, I thought I was just going to shut the machine and light off. And he was there and he grabbed it.
And you would agree with me, though, that from the first time that you went in there till the end of the video we watched, that was just a few minutes, right? No, not sure about time. Wasn't counting. So when you went back in again to turn the machine off, that's when you started taking the clothes out in the video?
I think I started taking the clothes out. I mean, he had the video, but yeah, I think I started the third time when he turned it on and I went back in. I think I started taking the clothes out.
Okay, so I'm gonna ask you a really, really simple question. Well, the video that we watched, that's the third time that you went in there to shut off the lights and turn off the machines?
These are the third or the fourth.
After, that video happens after he had grabbed your breast, right?
No, he grabbed my breast in the beginning.
So the video we watched,
Before he did any video, that happened.
so let me ask you a question,
Oh, I think we're saying the same thing. So just listen really closely. The video we watched today in court happened after he grabbed your breast.
Correct.
Okay. And in fact, you went back and forth into that room more than one time on that video that we watched, right?
I think the video showed the lights going on and off a couple of times.
And before the lights go on and off, it shows you going back and forth for some of the laundry, right?
I think I did at least one time.
One time. And you told him that he had to leave your house, didn't you?
I said I was, you know, I was gonna give him an eviction notice.
Is that what you said?
Well, that's what I meant.
But what did you say? You said you need to leave my house, right?
Well, I mean, if he doesn't want to abide by the rules of quiet hours after 9, I thought maybe it would be better if he would leave my house.
Man, my question's very simple. But didn't you tell him to get out of your house?
I think I may have, yes.
You may have. And didn't you tell him he was going to be out on the 22nd?
I think he had paid, it was a month-to-month lease. I think he had paid through the 27th. I think.
No, but focus. Didn't you tell him he was going to be out on the 22nd and maybe 27th? It's hard to hear, but you told him that, right?
I was, what date I meant was the date that he had paid through.
So you told him that he had to be out on the 22nd or the 27th, right?
I don't remember the date.
Okay. You would agree with me because it's captured on the video that the first time we see you turn the lights off in that video, Marcos's hand is nowhere near that switch, right?
Yeah, but
And then you would agree with me.
Excuse me, can she?
She said, yeah.
She answered the question. So go ahead, Ms. Blondie.
And then you would agree that he turns the lights back on, right?
I don't remember every single step. You're asking me to recall everything. I don't remember. I wasn't taking video. I just remember some key points.
You've had a chance to review that video before today? Is that a yes?
Yes.
Sorry, same thing. Like we just have to have the recording.
But the video didn't capture everything. It didn't capture before and it didn't capture after.
Which is the nature of all videos, right?
Yeah, but it didn't capture me supposedly pushing him or anything like that. It just stopped.
So ma'am, my question is, do you recall that he turns the light back on after you turn it off?
Yes,
And you turn it off again,
yes.
and he turned it on again?
I'm trying, you're asking, I don't remember everything.
Okay.
You're asking me to say something, I don't remember everything. I remember we were going on and off and on and on. That's all I remember.
And at some point, he had his hand on the light switch holding it on, right?
Yeah, just like I had before that.
And you pulled his fingers away to turn it off?
Yes, but yes. And he had touched me before.
Oh, ma'am, I didn't ask you any questions about that. My question was just about the light switch. Do you recall appearing for court here on February the 5th, 2025?
Yeah,
And do you recall that's the date that this case got set for final settlement conference? Does that sound about right? And is that in fact the day that you went to Pittsfield Township Police Department to talk to Officer Boatwright about your breast being touched? And isn't it true that you told Officer Boatwright that you were discussing the case with your attorney and decided that the updated version of events needed to be reported?
I mentioned it to the lady at the counter and she said, I told her and she said I should go report it.
So on February 2nd of 25 is when you went to Pittsfield and you were able to chat with Officer Olivia Boatwright, correct?
At that point, I had the courage.
What lady at what counter?
And Your Honor, the court asked a question which I was going to ask. I don't understand what What is this all about? Who is the lady? Where?
I'm assuming it's about the date that the report, but I'm trying to figure out what lady at what counter.
Here in the court, I was going there asking her why, how I could include some other information, and because no one ever called me, and she told me to go to the Pittsfield Township Police and put the report there, and
It was one of the court clerks that told you that?
yes, I was telling her that no one called me to, I said I had some more information.
Okay, all right.
She told me to go.
You answered my question. Go ahead, Ms. Londa.
And that was the date that you were able to go to Pittsfield Police Department and make that report?
Yeah, I had.
It's just a yes or no. So that's the day you went, correct? On February 2nd, 2025?
February 2nd or February 5th?
I said this, I meant the 5th. I apologize, Your Honor. I misspoke. I read the 2. I meant February the 5th. Didn't you in fact tell the police officers though, that that your breast was grabbed when you were removing the clothing from the dryer?
Well, excuse me, Your Honor. She's saying tell the police officers. She spoke to one police officer, Officer Boatwright. Who are these officers?
I don't know.
Is she-
Well, hold on. At what point are you talking about?
I'll rephrase.
All right. thank
When you went to Pittsfield Township Police Department on February the 5th, and you spoke with Officer Boatwright, isn't it true you told her that this happened while you were removing the clothing from the dryer, this being the touching of your breast?
No,
That's not true. So if that's in a police report or if that's captured on Officer Boatwright's body camera, that's not true?
yeah, I told her I walked in and he grabbed my dress.
All right. So if we are able to get Officer Boatwright here or review her body camera and we find out that that was what you told her, that would not be true.
I told her exactly what happened.
So if it's different than what you're saying now, which one's true?
Well, Your Honor, first of all, she's asking
It's
speculation.
cross-examination, Mr. Mack. I'm gonna let the questions go. Go ahead, Ms. Lundy.
Please answer the question, ma'am. My question was, if we review Officer Boatwright's body camera, or we have her testify, and she testifies or her body camera indicates that you told her that your breast was grabbed while you were removing the clothing, right? Would that be true?
I did not tell her I was removing it. I told her we were arguing over laundry machine.
Okay, and if the body camera or the testimony from the officer indicates that you said it happened while you were removing the clothing, that would be different than what you said today, right?
I did not tell her that, so she would be lying.
She would be lying,
Yes.
and her body camera recording would be lying if it captures you saying that.
I did not say, you're putting words in my mouth.
I'm just asking a question. If those two things happen to be, okay.
Ma'am, are you gonna answer the question, please?
I told her.
So if Officer Boatwright says something different, she's lying.
Yes.
Your Honor, I was
And-
asking-
All right. Well, not really, but okay, we have the answer.
And if the body camera captures you saying that it happened while the clothes are being removed from the dryer,
No. Why are you, I didn't say that.
All right.
may I have a moment, Your Honor?
Yeah.
Nothing further, Your Honor.
Ma'am, what were the hours that constituted the quiet hours?
9 PM,
Until when?
9 AM,
The agreement doesn't say that though, is that
Well-
right?
waking hours.
Well, ma'am, the agreement doesn't say that, correct?
Correct.
All right. Um, because I'm a bit confused about the whole arrangement and disagreement. But is this property registered for rental with Pittsfield Township?
At the time, it wasn't because I was owner occupant, and I was told when you're an owner occupant,
Okay, so that's a no?
no.
All right.
Because I even asked,
Why? Why was it important to you that the light switch be turned off?
because I was hoping that we would stop doing the laundry, light switch off and the laundry machine off. So when I went in there, I turned the laundry machine off and turned the light switch off.
Okay, but when you went back in, you also turned the light switch off, right?
I mean, I'm paying utilities, so I'm,
Well, no, you're not, according to, look at your lease agreement. Doesn't his rent include utilities?
yes.
So he's paying utilities.
Yeah, but part of the rules that I put on the refrigerator is everyone should try to conserve energy and keeping them.
Ma'am, why were you turning off the light?
Because it was midnight. I thought it should be shut off and everyone should be asleep.
But that agreement doesn't say that though, does it?
I thought it was assumed at 9 p.m. quiet hours. That's what I explained to him when he signed the lease, that it was to be quiet hours. After 9 p.m.
Ma'am, would he be violating the quiet hours if he had gone into that room, did no laundry, but just stood there with the light on?
No,
So what was the purpose in turning the light off?
just that have him maybe go to just stop doing the laundry.
Okay. So at some point, and you saw the video, you're removing his clothing from the machines, correct?
Yes,
Was that from the dryer?
I believe it was from the washer.
So the clothes were wet?
Yes.
Where did you take those clothes?
To the room.
And when you took them to his room, what did you do with them?
I think there was a laundry basket or something, or maybe I put him on the floor in his room.
Pardon?
I think I put him in his room. I think I recall putting him on the floor in his room, or maybe there's a laundry basket right there by the door.
So you recall the clothes being wet and you put them on the floor?
Yeah, or in a laundry basket. I can't recall if it was a floor or the laundry basket.
Okay. When you walk into that room, is the dryer to the left or to the right of the machines?
Oh, you know what? Now just saying it, I actually pulled them out of the dryer because
Is the dryer to the left or to the right when you walk in the room?
when we walk in, dryer's to the right, so I was pulling out of the dryer, washers to the left.
Okay,
So they were in the dryer and not quite dry.
all right. So what was your purpose in removing the clothing from the dryer?
To have him, observe quiet hours and just not do laundry at midnight.
Okay, so let me ask you this. Once you had accomplished that, had you not then at that point restored, I guess, this quiet hours?
I kept this whole situation, when the laundry was, I took the laundry out. Quiet hours were restored, but then when you would go back, if I went back in, it was because the laundry machine, the washer was being used. I don't recall exact details, but it was just either one machine or the other was being used. I don't recall, but I just wanted to go to bed and have it in. And
So are you claiming they were closing the washer now?
I think there were.
Then why didn't you remove those clothes?
I just was trying to get him to stop using the laundry. I wasn't taking notes.
I'm not asking if you're taking notes. I'm saying, why didn't you? You're now saying that there were clothes in the washer.
There were clothes in the washer and in the dryer.
So if it were trying to get him to stop, why did you only remove the clothes from the dryer?
The washing machine was, I believe, was off, and I was just trying to get him to stop. I wasn't thinking, oh, remove him from the washer and the dryer.
Ma'am, I'm trying to figure out why you did what you did.
I was just trying to get him to stop, sir. I was just trying to.
And in doing that, I'm also trying to figure out why you removed the clothing from the dryer.
Just trying to get him to stop, sir.
Okay. So once though you had removed the clothing from the dryer, put them in his room, either in a basket or on the floor. At that point, there was no longer noise coming from that room, correct? And when you came back into the room after you removed the items from on top of the dryer and went down the hallway, you came back into the room, right?
I think I tried to turn the light off.
Okay, but if you had turned the washer on, why would you turn the light off?
I thought it was time for everyone to go to bed. I just wanted that, normally what I would do is turn the washer off, or, you know.
Did you turn the washer off?
I believe, I don't want to misstate things, but I believe both the washer and dryer were on at some point, and I don't know what order I turned them off.
Ma'am, at some point when you removed his clothing, did you want to see the video? I'm not trying to trick you. I'm just trying to yes, can we put exhibit back up?
I just do.
Could we play the whole video? Would that be okay? Good?
I don't want to.
I don't care if we play the whole video. That's fine. We can play the whole video.
It's only about 2 minutes long. Judge, I have to interrupt. Can I just have a bathroom break just for a moment? Whenever it's appropriate.
Okay, yes, just momentarily. I don't have many questions, but I'm just trying to figure something out here.
So you're touching it close enough. That's not okay. You can't touch my property. You're not allowed to touch my property.
No.
You can't touch my property.
No, I'm trying to sleep.
You can't touch my property. Please tell me stop it. All the time you're gone.
Those are my towels, the last set of towels.
Okay.
Can you please not touch me? Can you please stop touching me?
Hear that?
Can you please stop touching me?
Okay.
No, I can't live here. What the hell? No, you can't do that. I don't need that. But have you sent me an eviction notice?
You're out on one side.
No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop. You're grabbing my hand. Okay. She's not grabbing me. Look, I'm gonna keep this light up, right?
Okay, man, you've seen that, you just saw the video. After you just now, not through a question, but you said the items that were on the top were your items.
Yeah. Did you hear the little bell?
Okay, ma'am, yes, I heard the little bell that told me that was the dryer. So, when you took the items that you now say are yours off and are leaving the room, at that point, the washer's not running, is it?
No, but I thought I heard the bell.
Well, ma'am,
Yeah.
the washer's not running, right? And at the point at which the dryer door shuts, and that's when you hear the little bells,
Right.
and you grab the stuff ultimately off the top, the dryer's not running either, is it?
Correct.
Okay, so at that point, safely we can assume there's no noise coming from either of those machines.
Correct.
When you walk out of the room, then what is your purpose in turning out the light?
I was just thinking that if I turned on the light, he would leave the room and go back to his room. And not use the washer or the dryer.
But to be clear, the turning off of the light had nothing to do with the quiet out. Is that correct?
Well, in my opinion, it did. But,
Why?
I mean, I know you may, I just thought the lights out, you know, it's quiet hours. In fact, the light from the living room actually shows through my door.
Yeah, but that's not a violation of anything, is it?
I can't personally sleep with light. I have to have darkness. So, I mean, maybe it's not a violation, but I was just hoping to stop him from doing one.
All right,
And
okay. I think it might be a good point to take a recess and you can put it back up and then you can re-question. Court's gonna stay in recess.
Bond will be forfeited in each case and reset at 100,000, and if we get proof of, what you tell me, I'll recall that. Cafetta Jones. Good morning, sir. You're Cafetta Jones, and Mr. Jones, were you able to get someone hired?
No, ma'am. I've talked to 3 people
Who'd you talk to?
though. I talked to Marshall Norman, Christy Carton, and Benjamin Jeffrey.
Okay,
Against Kelly Norman.
okay. And where are you on being able to get someone hired, do you think?
Well, I lost 2 jobs dealing with this case. So
Okay.
I'm not working right now.
Okay, so what I'm going to do, thank you for taking care of what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Be sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk over there, she'll give you that. Why is my, look at my, I understand how it moves, why it moves.
And so, take it to your seat, because we already on this section, it doesn't apply, that is a part of the information. Sign that, let them know that when you're done, don't leave and don't come back without permission, okay? Thank you. I had to move the camera, and I told myself to make it taller, and I forgot, and I'm sorry. I didn't know. Thank you.
Samuel Cadena? I'm learning. Good morning, you're Samuel Cadena. And Mr. Cadena, this is your initial appearance in cause number 25 DCCR 0557. And in that case, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from March 13th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am, I still haven't, I'm trying to get one that's kind of affordable to me, but
Sure.
I'm close to doing that.
So what I'm going to do, Mr. Cadena, is reset your case for about 30 days or so to give you some time to try to get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me the names of the people that you've talked to so I know you're trying, and we'll discuss your options. And if you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you your reset notice. Diamond James. Good morning, ma'am. You're Diamond James. And Miss James, did you get someone hired?
But I did speak to two different,
Who'd you talk to?
Thomas Burbank and Douglas.
Okay. Where are you on being able to get someone hired?
Right now, I am a single parent with 2 kids in school, so I'm trying to get that situated. I do want to hire one of them.
Okay, and are you working?
Yes.
Okay, so you think you'll be able to get someone hired if I give you one more reset? Okay, let's see. Where are you working full-time?
Well, yeah, this, I do house.
Okay. All right, so I'm going to reset you one more time. Talk to at least, if you need to talk to more than that. If you want to hire one of them, that's fine. You can start working towards saving for that. If you make any payments, bring me a receipt. If it's not going to work out with either of them, then you need to talk to at least 3 more. You can tell they all charge different amounts and have different payment plans, so make sure you talk to at least 3 more. Don't wait till right before court. Bring me that information. We'll discuss your options. Okay, step in front of the clerk. Diamond Ollie? She is, okay. Derek Mouton? Good morning, are you Derek Mouton?
Yes, ma'am.
And Mr. Mouton, this is your initial appearance in cause number 25 DCCR 0748. You're charged with the 2nd-degree felony offense of assault on a peace officer. from May 18th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I've been looking at numbers like that.
Okay, so what I'll do, Mr. Mouton, is reset your case about 30 days to give you some time to see if you can get someone hired. If you do get someone hired before that next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would have to go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she'll give you your reset notice.
Sign one.
Eliza Riley. Eliza Riley. Take off your glasses so I can see, please, sir. All right, so you're Eliza Riley. Please answer out loud. Thank you. And Mr. Riley, this is your initial appearance in cause number 25 DCCR 0380. You're charged with the 3rd-degree felony offense of deadly conduct, discharging a firearm from December 21st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay, so what I'm going to do, sir, is reset your case for about 30 days to give you some time to try to get someone hired. If you get someone hired before the next court date, then just you can put them back on, then just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice.
Sign one. Oh, that's okay.
Dalton Friege. Dalton Friege.
Thank you.
Dalton, Tuesday.
Good morning.
No response, Your Honor.
This bond will be forfeited for non-appearance and reset at 100,000. Christopher Holman. Christopher Holman.
Someone called last week and said that they were going to be sending over an AFRS because he had already forfeited on another case that they had him on in a different county.
Oh,
And we didn't get it till this morning, so we haven't even done this morning.
Okay.
The bond forfeiture would
override it anyway. Okay.
So,
No response, Your Honor.
All right, this bond will be forfeited for non-appearance and reset at 100,000.
yes, she did.
And next week, the only thing, oh wait, do I have trial next week? It's the week after, the 28th. We don't have it next week. Okay.
This is what.
Is there a, is it set at 8:30 or 9? 9, okay.
Mr. Jackson?
Is Jacaria Dudley here? Jacaria Dudley.
Mr. Samuel?
Sunshine?
All right, Mr. Price, this is a non-disclosure 25 CCCV 0305. Ms. Dudley filed a petition for non-disclosure. It looks like you have opposed that because she completed the probation, but there was fees still owing at the end. Is that correct?
That's correct.
And the law provides that if she did not pay the fees, that's,
We look at it as it's not completed your probation, because you didn't pay the fees. Now, while you may get discharged from the probation for purposes of indigency or whatever, it doesn't allow you for non-disclosure.
does it not allow it, or is it discretionary?
It says you have to complete your community supervision. It's 411.074.
Right, but they did, so she, I guess, she did complete it,
Well, yeah, it was discharged, yes.
right?
But I've taken the position that it's not completed for purposes of non-disclosure until the fees are paid. I mean,
Is there
some of the statutes, and I don't have which one it is, but some of the statutes specifically mention the fees being paid and some do not. So that's why I go with the consistency of if fees aren't paid. Let me see, what section did she go under? She went under 411.075.
Oh, 74. So it was a criminal criminal trespass misdemeanor. I guess I would like to, if you to direct me to somewhere, whichever code section that talks about the fine needing to be paid in full, even if you're
I
discharged.
think if you look at 411.073B,
07 what?
3B, that one I believe that one specifically says that the fees must be paid. And I walked off without my book, and I apologize.
I'm looking at it.
Ms. Henry?
Okay. I think you're right. Any person whose community supervision is not revoked and who completes the period of community supervision, including any term of confinement and payment of all fines, costs, and restitution imposed, may petition the court. Okay. Then I'm going to, based on or 11073B, deny the petition for a non-disclosure in this case.
Thank you, Your Honor.
Thank you,
May I be
sir.
excused?
Yes, sir.
Thank you.
Just get with Kim. I need a denial, please. Who? Okay. Mr. Samuel? No, okay. Yeah. And then I'll come right back in and then I'll come right back in and get my. Mr. Jackson,
Yes, Your Honor.
are you ready on Leroy Smith's sentencing?
We are.
Leroy Smith?
Judge,
Good morning, sir.
Mr. Coleman's on his way. He got hung up a little bit this morning. We just hold it for a couple minutes.
Sure.
Mr. Jackson's here and ready, but
Okay, as soon as Mr. Coleman comes in, I'll take care of that.
And Judge, I anticipated taking a little bit of time. I don't know if he had some other issues.
On,
Yes, ma'am, because I was gonna call Mr. Smith to the stand and then one more witness, so.
what, let me see, Leroy Smith. Okay, I'll hold it.
Okay,
Thanks.
thank you.
See, Mr. Peraza, are you ready on Juan Martinez?
Judge, basically, it's our first appearance. I just requested discovery, so we have not received anything.
Okay, let me get, is Juan Martinez?
He is also,
We'll just get him in and we'll put that on the record.
and my apologies, Your Honor, he is a Spanish speaker.
Okay,
I can translate if the court allows it.
that's fine. Yeah, for purposes of this hearing, that would be great. Thank you. Morning, Mr. Smith.
Diamond Ollie. Diamond Ollie.
Good morning, sir. Are you Juan Martinez?
Yes.
And Mr. Martinez is charged with assault on a peace officer. And what is the announcement?
We not guilty, Judge, waive arraignments and request time to obtain discovery from the state.
Okay, any issues? All right, typical reset is about 30 days, so we'll send you that reset notice and give you some time to get signed into the portal and make any requests that you need to for videos. And Mr. Smith will let you know what you need to do to be able to get all of that. And we'll see you back in about 30 days. Yes, sir. Mr. Samuel and Daisha Mark.
Yes, sir.
Good morning. Mr. Smith, this is your sentencing. Sentencing. Good morning, ma'am. You're Daisha Mark. And Ms. Mark was previously in court, entered a plea of guilty to the third-degree felony of injury to a child, elderly, or disabled individual. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, sir.
Are there any additions or corrections?
Not from the state. No, from the transfer.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 8 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. What is the status of CPS involvement in this? It has? Okay. So you will be required to take certain classes, again, follow all of the rules and conditions. And if you do all of that while you're on probation, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side to that is if you violate any condition of probation, You can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could be sentenced to prison anywhere in the range of punishment, which is up to 10 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all your paperwork. Good luck to you, ma'am. Thank you, Mr.
Thank you, Your
Senior.
Honor.
See, Mr. Rojas, you have Carly Davis.
Carly David. Carly David.
Good morning. Thank you.
I need to renegotiate that with him.
I know.
Max plus one. Standard offer. You're there. Death penalty to do like today.
Good morning. Are you Carly Davis? And Ms. Davis, in clause number 241385, you're charged with the third-degree felony offense of driving while intoxicated, and that's from May 6th of 2023. Your indictment alleges you were previously convicted of driving while intoxicated June 19th of 2014, and then June 25th of 2014 as well. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a tablet that plea bargain rejection that has your signature on it with Mr. Rojas's. Actually, yours didn't show up.
Did I sign it?
I don't think you did. When it gets back over to Andy, you can sign it. This shows that the district attorney's office has made offer if you wanted to enter a plea of guilty for a 6-year term in prison, but that would be probated for 6 years. So you'd be on probation for 6 years. You would be ordered to pay a $500 fine, follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to enter a plea. Do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Give me just a second. Was this, do you have an auto ignition interlock device on your vehicle?
I do not drive.
You don't drive?
No, ma'am.
Okay.
Uber everywhere, get rides from everywhere.
Can you tell what the, was it alcohol?
I think it was drunk.
And it looks like they smelled, there was some alcohol in the car and a THC, some marijuana. If I test you this morning, will you have anything in your system?
Just my prescription medication.
Okay, have a seat in the jury box. I'm going to make sure about that and get you tested first, and then we'll discuss what your options are for that. Okay.
Judge, I also have Anthony Williams, who's having difficulties getting here. His flight was canceled. He's in Tulsa, Oklahoma. But he sent all that stuff to the bondsman.
I'm kind of over that.
Bondsman sent all the information.
Have you talked to him? Are y'all getting anywhere on the resolution of the case?
I talked to him, I think we were, let me see, this is, yeah, so I do have an offer. I talked to him about the offer. He was fine with that offer. I was gonna talk with Mr. Smith about maybe making that a different.
I'm going to reset it 1 week. He needs to be here next Monday. He needs to get a flight the day before or do whatever he can. Now, if he gets on some flight and gets here, we'll be here this week. If he's on his way now and something was canceled, or is he not even on his way?
The message says the flight was canceled.
Canceled. I'd like also some proof of that.
I've got what he sent.
What do you have?
This is looks like a message from the airline showing that the flight was canceled. And this is his ticket. Which I hope has the same flight number.
In the words of Don Williams, who's living on the coast.
This is from Chicago to New Orleans.
I think she said they did already flight.
He's got a red car. It's not that far of a drive.
Sunday, July, what's today?
Yes.
So this was yesterday.
The prosecutor seeking justice.
Would seek.
They called on about 5:30
What's in there?
yesterday.
Uh-huh.
What's in the county airport?
We take care of all that.
That's right.
Since Chicago, until we called a flight at 7:40.
Oh, well, he got to Tulsa apparently, or was supposed to get to Tulsa. All right, looks like he was really trying to get somewhere and ended up a bunch of places he wasn't supposed to be other than here.
Picture of O'Hara's map if you want to see that.
Okay. All right, I'm just gonna reset it again for 1 week, and when he needs to be here next Monday.
Yes, ma'am.
Mr. Rojas, you have Nicholas Gilmore Jones on a sentencing.
Nicholas,
I guess that's not the first time he had trouble with him.
Just he's,
This is my first time.
yeah, it's just, he, I'll tell you. Good morning, Mr. Hopper. Trying to remember how he said it last time. He was living the dream or chasing the dream. No doubt. Good morning, sir. You are Nicholas Gilmore Jones.
Yes, ma'am.
And Mr. Jones was previously in court, entered a plea of guilty in 24-1441 and received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
Not.
All right, Mr. Jones, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, I'm going to follow the agreement that you made and find you guilty of solicitation of prostitution. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but that'll be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Now, I have some concerns because you were already given a probation not that long ago that you did not successfully complete. So this is a huge opportunity that you're being given today that some people don't get when they've already been revoked. So you know what to do and what you're not supposed to do while you're on probation. If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court, and you could be facing that 2-year sentence that you've already agreed to. Do you understand? All right, you're welcome. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over all of your paperwork. All right, good luck to you, sir. Anthony Whitmire, Mr. Rojas?
I haven't seen him this morning.
And
Anthony Whitmire.
if you'll look in the case, we received information that he was in Mount Hardin County Jail as of Friday.
Oh,
And the bondsman hadn't filed anything.
okay.
Your microphone's on.
Yes. All right. Court does recall the case of the People versus Lori Anderson.
Pass along to the people.
Your Honor, Hugo J. McInerney with on behalf of Ms. Anderson, who is in the courtroom today.
All right.
Your Honor, it is my understanding the defendant has decided to plead to assault and battery, and in exchange will receive consideration and a prosecutor's deferred sentence with 12 months of probation.
Got a correct statement?
Yes, Your Honor, we have proffered an advisory rights form signed duly to the court, Your Honor.
All right. Ms. Anderson, could you step to the podium, please? She had been sworn as a witness, but could I have her sworn?
You were swearing. Solemnly swear affirm the testimony you're about to give be the truth, the whole truth, and nothing. Yes. Go ahead and state and spell your name again. Lori Anderson.
All right. And Ms. Anderson, just so that we're clear, we were in the middle of a bench trial in this case. The court had not made its finding. You've had an opportunity to speak with your attorney and you wish to now plead guilty to this charge.
Yes.
All right. The offense of assault and or assault and battery is a misdemeanor punishable by up to 93 days in jail and a $500 fine plus court costs. There is a sentence agreement that the parties have, which the court, after probation, the court would, however, indicate that I don't see a reason why this, I'm not making an agreement, but I don't see a reason why this court would not follow that. Okay. Given what I've heard in this case, you understand that, Ms. Anderson?
Yes.
And understanding the maximum penalties on this, how do you wish to plead to this case?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium there and it's highlighted. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
Just get the date right. I think it was November 16th, 2024 at the location of, it's not on that one, of Chandy Court, Pittsfield Township, Washington County, State of Michigan. On that date, there was, I'm going to just ask you to acknowledge this, there was a dispute regarding the use of a laundry room. Is that correct, ma'am?
Yes, sir.
And during the course of that dispute, there was then an issue regarding the turning off of the light, correct?
Yes, sir.
Between you and the other individual. And at some point during the turning on and off of the light, there were no longer just fingers coming into contact with each other. At some point, you grabbed the hand and or arm of the other individual. Is that correct?
Yes, sir.
All right. And when you did that intentionally.
Yes, sir.
And Ms. Anderson, you would agree that given all of the circumstances at that time, that the grabbing of that would reasonably or potentially place somebody in fear. If they had some fear at that point, you would agree that that fear of some harm would be reasonable.
Yes, sir.
All right. Counsel, have I complied with the court ruling? Would it be proper to, well, I won't ask you that. Ms., I do also have to advise you before I get to that, Ms. Anderson, that if you commit misconduct as defined by the Michigan court rules from the date I accept your plea to the time of sentencing, that any sentence evaluation or agreement, this court would no longer be bound by. You understand that?
Yes, sir.
You also understand that you would not then also be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Defense not aware of any, Judge.
All right. And now, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
The court will accept the defendant's plea of guilty to this charge. Today is the what?
14.
I've been in a room with Hugo Mack, it seems like the 20th. No, I'm sorry.
Oh, no, Judge.
I just thought I'd throw that out
Oh,
there.
of course, why not?
All right. Court having accepted defendant's plea, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 13th, 2025 at 9 a.m.
August 13th, 2025, 9 a.m. Bond with its conditions will continue. All right. So ma'am, I would only suggest that as you exit the building, probation will be on your left-hand side down the hallway. You may want to stop in there and at least start the process. All right. Does that date work for you, mister? I see you looking.
Yeah. Your Honor, that date is just fine, sir.
All right. Fantastic.
Thank you, Your Honor.
Thank you.
Judge. So we can just go to probation right now?
Yeah, you can go down and they'll probably set an appointment with her.
Okay.
Down there. All right. That's it till what?
But, so I just need to do at large. Okay.
And I forgot to tell you about that.
No response, Your Honor?
So I did receive from Professional Bail Bond a memo that at least as of Friday, Mr. Whitmire was in the Hardin County Jail. So based on that, he attached the jail bookend sheet. I'm going to find in each of these cases that he is at large without proper bond, raise those bonds in each case to $100,000. And then we'll see when we can get them back over here. I'm just waiting on, oh yeah, I'm waiting still for the test. Eric Fornells, Mr. Rojas?
He's right up there.
This is also Mr. Coleman's. Eric Fornells. Good morning, sir. And good morning, you're Eric Fornells?
Yes, ma'am.
And Mr. Fornells in 250267 is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I think this is our first announcement. Mr. Forno brought some paperwork with him this morning. He'd like to get to me. I'm asking for another recess so I can, or a recess so I can look at that.
State time apologies.
All right, so I'll just do a normal reset. Mr. Fornells, make sure you stay in touch and keep in touch with Mr. Rojas. He'll present whatever you have, discuss it with Mr. Coleman, and we'll see if we can get an announcement at the next court date. Thank you, sir. Mr. Parker, you have a sentencing on Gustavo Vasquez.
Silence here as well.
Thank you, ma'am. Good morning, sir. You are Gustavo Vasquez. And Mr. Vasquez was previously in court and entered a plea of true to count 2 in a motion to revoke his probation. It looks like Mr. Vasquez is on probation for a 10-year deferred term for indecency with a child by sexual contact. That new allegation was failure to register as a sex offender. And I've received the updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor.
Are there any additions or corrections to that report?
No, no.
And this is unagreed, correct?
Correct.
I'd like to know, Mr. Vasquez, is Mr. Vasquez here? Are you here legally?
Yes, ma'am.
You are?
Yes, I have a residence.
Okay.
Residency.
Okay, and it's up to date and there's no issues with regard to that. Mr. Parker, you may proceed.
Your Honor, starting off, the court maybe remembers, he had health issues earlier on, and that was part of my issue, getting to talk to him initially, and he's still has health issues, but he has consistently had the same story of trying to register the Port Arthur Police Department, calling. And I think he truly has, and I believe the probation officer or somebody looked at his phone to see the record, and he did try to call in May of this year. I mean, I'm sure we don't have any kind of proof of when he tried to call in the past, but and it falls on him that he didn't do it. And if he's calling and having issues, I think what he should have done was talk to the probation officer and said, hey, I'm calling, but they put me off. There's no voicemail. And I'm very familiar with the Port Arthur Police Department. I know that there's a lot of times you cannot leave voicemails to some of these people, and they do not call you back. But he wants to address the court regarding his things he's done to try to report. He wants to stay on probation. He doesn't have any new offenses. He's trying to comply, and he wants to prove to the court he can complete probation. He wants to address the court, Your Honor.
Okay, we'll get to that in just a second. I have some, so this talks about sex offender treatment and what Dr. Asteris described as progress is below average, needing improvement. Since this time, is there anything that's changed that you need to let me know of, Ms. Simon?
No, ma'am, that was the June report that you said it was below average.
There's also some things Ms. Simon is going to ask her a few questions, Judge.
Yes, sir.
Ms. Simon, would you explain to the court?
Real quick, before you do that, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Simon, you've been the probation officer for Mr. Vasquez for the entire time he's been on probation?
Yes.
Okay, has he been compliant?
In regards to reporting and issues.
Okay, but he's on for indecency with a child.
Yes.
And that's an important charge for him to be supervised also as a sex offender suspect.
Yes.
And he fails to register or fails to report with Port Arthur PD, which is his reporting agency, is that right?
Yes.
Now, between the time of the last time we were here, when he pled true tonight, to make sure I'm being clear on allegation number 2, correct, register with the sex offender tracking program, he has not done that yet.
Correct.
Okay, and have you tried, meaning like you talked to him in regards to reporting with Port Arthur PD?
Yes, I'm giving him several phone numbers to contact him.
And to your knowledge, has he ever done that?
He showed me call logs, but that's all.
Okay, now, have you had trouble before with other clients not being able to report Port Arthur PD?
Not this long.
Okay, and yet this defendant somehow cannot report, and that's part of his probation. And this is, I guess would argue that's the most important part of his probation.
Yes.
Okay. I have no further questions, John.
So you're still not registered?
No, ma'am. I spoke to him Thursday. I went up there Thursday and I waited for him to show up. And I talked to him and he told me the same thing. Call me, leave a message, and I'll get back to you. And like,
who's
George Clark.
What's his name?
George Clark.
Clark? Clark.
I know him.
Judge, Ms. Simon, and we spoke prior to this, she has, every time she's called Mr. Clark in regards to this, she receives, leaves him a voicemail, she gets a call back. However, the defendant somehow doesn't get one.
Well, here's what I'm going to do. With everyone's permission, I'm going to make that phone call myself. We can do it later in my office when y'all are both here, or I can let you know how that goes. I just want to find out from him his records on what, if any, messages have been left and what their process is and if there's something different about this case than any others.
I'd like to ask her a couple of questions, Judge. So I think you said the most important thing is reporting. I think the most important thing is probably him reporting to you. Would you agree?
Correct.
Okay. And you said you've never had anybody took this long as far as, registering, but you've had people that didn't register at all, correct?
I have not.
You've not? Have you ever had anybody, so you never had anybody that just failed to register at all?
I mean, yes, we left them registered, not while I've been supervising them.
Okay, I don't know if I understand. You've had people that failed to register.
Prior to me supervising them.
Okay. Have you ever had anybody that tried to register and said they couldn't get a hold of anybody at all?
Yes, but eventually they did.
Was it George Clark?
Yes.
It was? Okay. No further questions,
I
Judge?
got a few. How many years has this been trying to register? Because he was put on in 2024.
2024, yes. He told me in 2024 he had appointments to register. They were scheduled, which isn't very common to happen. And just every month it was rescheduled. Oh, I have it on 15th. I'm going tomorrow. I'm doing this action, whatever. And it never moved.
Now, in the report that you have, it's not like you got a low score on the report in regards to whether or not he's cooperating with probation.
Right.
The one that we just showed to judge in regards to.
Oh, his progress report treatment?
Right.
It was below average and needed improvement.
Is that consistent with the person who hasn't fully registered to be a sex offender?
Yes.
That actually follows right in line with somebody who's not following through. No more questions.
Couple more. You stated you looked at his call log on multiple occasions, correct?
I asked him to show me, yes. I was telling him to call every day and it was like once a month. It was not consistent as I instructed him to do
Okay.
so.
So, but you saw that previously in the past, and you did see where he had made attempts to call, correct? Okay, so it's not like he's not lying to you, he's attempted to call. Maybe he hadn't called every day like he should have. It hadn't been perfect, but he has called.
Yes.
Okay.
Okay.
Briefly, Judge.
Oh.
Just an argument. Your Honor, in this.
Well, here's the thing, we're not going to do argument today because I want to find out from Mr. Clark or Officer, whoever that is, whatever's rank is over there, what's going on. Because I just find it hard to believe from March of 2024 to July of 2025, if you were really working on that like you should have been and like you were told that it would not have taken place. Even if there's some issues getting calls back. If you're required by law to do something, then you can go to prison for it. I'd be making that phone call every day. And especially if I was going to court for sentencing on a felony, I would have been up there every single day since you pled on this case to make sure when I walked in today that I was registered. And you haven't done that. And so that's a big concern of mine. But I want to talk to Officer Clark first. I'm going to reset the case 1 week. I want everybody back here next week, and I'll let y'all know before we can either get together and y'all can be a part of that if you want to. All right, we'll see you next week.
Just asked the court to confirm that he went down there and was told to call.
I'm going to confirm everything I possibly can. Any notes or records that he has, that's what I want to try to find out, messages or anything like that. Okay?
Thank you.
You're free to go.
Thank you.
Mr. Lewis, you have Anthony Vidal. Good morning.
Anthony Vidal.
Good morning.
Good morning, Mr. Nichols. Everybody have a good weekend? Good. If you do, nobody wants to listen to it anyway, right? Good morning, you're Anthony Vidal, and Mr. Vidal is charged with criminal mischief in 24-2062, and what is the announcement?
Judge, Mr. Vidal, we have been reset to verify the restitution and Mr. Nichols he did talk to the complainant, so we can get all that straight. He's made a new offer to us that involves getting that restitution paid. Mr. Vidal, he's actually here with some representatives from Spindletop. We're gonna be doing a conference call, like a team meeting, basically to see what he can afford, because all of his income comes through a
Right.
pay.
Okay.
And the restitution's about $3,000, Your Honor.
Okay.
So, they just need to get that straight, see if it's something he can do.
Sure, so we'll just do normal reset to give you some time to see if that's something that can get taken care of. Mr. Vidal, make sure you stay in touch with Mr. Lewis so y'all can figure out how you'll go forward when we come back.
Thank you, Judge.
Thank you, you're free to go. Naquindon Acleese, Mr. Lewis, and Mr. Nichols. Saving you some steps.
Easy, I'll need it. But that's easier.
Did you pick that shirt special for today? Do you even know what it says? Probably should have thought about that a little bit before you came to court, right? Oh, all right. You're Naquindon Acleese, and Mr. Acleese is charged with burglary of a habitation in 240478. And what is the announcement?
Judge, Mr. Cleese, recently had made bond again and requalified. He was supposed to be hiring Mr. Kimmler, and he had been hospitalized for a few weeks. I think he was staying at the actual judge, and but he's gotten the money together where he's gonna meet with him this Friday.
Okay.
And take care of it.
All right. So you'll be able to hire Mr. Kimmler this Friday? Okay. I'm going to reset your case in normal reset, which is about 30 days. Until you hire Mr. Kimmler, Mr. Lewis is your attorney. Stay in touch with him. If you get Mr. Kimmler hired, he'll let us know, and then we'll go forward that way. Okay? All right. You're free to go. Pay attention to what you wear to court next time.
Thank you.
I mean, did you see it? I mean, I guess so. We just, Mr. Kevin Lane, are you doing paperwork? I'll hold it until you're ready. Mr. Parker, you have Benjamin Barker.
We're trying to work out some paperwork on that, Judge.
Okay. What about Jimmy Hart?
He's here. I'm hired on that case. I'm asking for a reset. Prosecutor and I are discussions on the case. He's out.
Jimmy Hart? Look, I tried not to go too far in saying all the words so that I don't end up on the
We have a
Gut-filled show
Benjamin
again.
Barker. He's charged with harassing a public servant. He agreed to give me a misdemeanor, but is terroristic threat a lesser included?
I don't know. I'd have to look it up.
I don't know.
I don't know. Yeah.
It is if it's
I'll let y'all
assault.
figure that out. Good morning, sir. You're Jimmy Hart.
Yes, ma'am.
And Mr. Hart, in cause number 250186, is charged with aggravated assault with a deadly weapon. And what is the announcement?
No, we're asking for one more reset. I'm in discussion with the prosecutor about a couple things in the case that I need to make my client aware of some things I've learned today.
Any issues, Mr. Nichols?
None that I'm aware of, Your Honor.
All right, so I'm going to reset your case about 30 days or so. Make sure you stay in touch with Mr. Parker and your bondsman. They'll let you know when you need to be back. You're free to go, sir. Lamira Henry, Mr. Parker? Or Lamira Henry? Good morning, ma'am. Are you Lamira Henry?
Yes, ma'am. Good morning.
Good morning. Miss Henry, don't wear tights or leggings to court next time. Okay, it's not appropriate. All right, this is 24-1668. Will your client waive the formal reading of the indictment?
Will, Your Honor.
Ms. Henry, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 25th of 2024. Since you've made, going back to, how do you plead at that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Henry is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there, okay? All right, we'll see you back at sentencing.
Discovery.
I've got it right here. That's it.
Mr. Rojas on Carly Davis. Ms. Davis, you tested positive for THC, amphetamines, and benzodiazepine. Speak up, I can't hear you.
Yes, ma'am. After you asked me if there was anything that I could be considered, I thought about, I take a combination of melatonin, ashwagandha, and CBD, and then my prescription medications. And I thought about if that could possibly show up as THC. But I buy it from all these tobacco store, I buy prescriptions or.
Well, I guess my concern, Ms. Davis, is that in the probable cause for your case, at least allegedly, there was actual marijuana that was found in your car, not just CBD or gummies or anything like that, but actual marijuana. And so the fact that you're waiting on court on a DWI third and you're testing positive obviously gives me a lot of concern.
Yeah, I understand, and I am trying to find a job adequately in the next week or so.
Do you think you're going to find a job if you test positive for marijuana?
I understand, and it's with ExxonMobil.
Well, you're not going to get hired with ExxonMobil if you're using things that make you test positive.
I understand, and I've gone through a divorce, had a baby, had a miscarriage, and have been suffering from severe anxiety, living with my 92-year-old grandmother and primary caretaker.
So here's the thing. While I appreciate that you've gone through a lot, none of it matters at this point because self-medicating is not going to get you anywhere. So here's what we're going to do. I'm going to order as a condition of your probation that you wear a drug patch. You have to pay for it. You have to get it. Hopefully you'll be able to get a job because you won't test positive. I assume it's going to test positive, so nothing over the counter, nothing from a tobacco shop, period, nothing. I don't care if it's legal or not. Anything that will possibly test positive, you cannot take. If you have a prescription that's going to make you test positive for benzodiazepine or something like that, I want you to bring the prescription. I want you to bring the printout also from the pharmacy. Get that to Mr. Rojas because that will show me that you are in fact taking things as prescribed and not any other way. Do you understand? You have 24 hours to get that drug patch put on. Your bondsman, Mr. Rojas, also could probably tell you where you can get that done. You need to get proof that you've gotten that to Mr. Rojas by tomorrow. And then what I'm going to do before I move your case to the trial docket, I'm going to reset it one more time. I want to know right at this point that you are clean before I leave you out to be waiting for trial. So if you're not clean by your next court date and you test positive, it's going to be a violation of your bond condition. You'll go into custody and you can wait there for your trial. Do you understand? There's no excuses. All right, we'll see you at your next court date.
And I did provide you with that printout, but I will get it again from the pharmacy.
And if you'll make a note that there was a rejection, but that I just kind of put it on, maybe just a note that I didn't go through with the rejection yet because of the drug I want to test her or something like that. So I'm gonna, hey, Mr. Rojas, I'm gonna go ahead and just delete the rejection this time. Y'all will have to do it again, but I just want to make sure where we are before we go through that. Let's see. Mr. Parker, what were y'all doing on Benjamin Barker?
Doing plea papers, Judge.
Okay, oh, perfect. And then Charlie didn't have anything else. Mr. Lane's doing plea papers. You don't have any of those yet. So we're waiting on Mr. Burbank, Mr. Crenshaw. Mr. Jackson?
Yes, Your Honor.
Are you ready on your sentencing?
We are.
On Leroy Smith?
And Judge, I do plan on calling Ms. George briefly as a witness, so I'm sure the state would like to invoke the rule on that and have her wait outside.
You're gonna, let me, before we, let's, I may or may not. Good morning, are you Leroy Smith Jr.? And Mr. Smith was previously in court, entered a plea of guilty to criminal mischief. There was no agreement. I received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
The state has yours.
Are there any additions or corrections?
No, Your Honor.
No, the state.
And so I guess what I'm going to do before we go any further, see, Mr. Coleman, obviously the victim's wishes are that Mr. Smith not be incarcerated, that he's paid the car repair, and that she really doesn't want to go forward with the case. Based on that, I'm sorry?
I'm sorry, Judge. I was just going to clarify that the state amended their indictment. Ms. George is no longer legally the complaining witness. It's enterprise because it was a rental car.
Okay. Thank you for that. What's your position? I mean, obviously, there's a lot of criminal history. It's old, but what's your position on that?
Oh, Judge, I laid it out in the sentencing memo. I mean, he, with that criminal history, all people should know to stay far away from criminal behavior. That with his history, that any future criminal behavior would result in, or could result in prison time. And I also laid out the nature of the offense. While it's a criminal mischief, it sounds a little innocuous, criminal mischief. This defendant, there was damage to body panels, the windows, the fuel tank, the engine, the wiring. It's a level of rage that concerns me. What if, I know it's speculation, what if the victim or someone would have confronted him during this fit of rage, Judge? It just concerns me. And it's not your typical, domestic situation where somebody just keys a car or deflates somebody's tires. I think it's worthy of given the situation, the nature of it, it's worth it for the time.
Thank you. All right, you may call any witnesses you wish to call, Mr.
Okay.
Jackson.
The state calls Leroy Smith.
Mr. Smith, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. All right, go ahead.
Okay, Mr. Smith, state your name for the record. Okay, obviously the elephant in the room here is your criminal history. You've got a significant amount of criminal history, right?
I need you to speak up when you're answering so I can hear you and so the court reporter can hear you, please, sir.
Okay, so you've got juvenile criminal history, you've got adult misdemeanors, you've got adult felonies, right? Okay, and in several of those adult cases, you were originally given probation and then you were later revoked from that probation, right?
Yes, I'm sorry.
Yeah, and in some of those cases, you were revoked because you committed a new offense, right? Okay, so listen, you've been to TDC twice, I believe. Once, okay, and then state jail. Okay, and then you were sentenced to federal prison in 2001. Okay, and how long were you sentenced to serve in federal prison? 92 months. Okay, and so at some point you were paroled out of federal prison, right? Approximately when was that?
And February 04.
Okay, so you got out of federal prison in 2004, you're on parole. How did the parole go? Did you successfully complete it? Okay, so once you got out in 2004, when was your next conviction after that?
I'm not that late.
Okay, so you have not been convicted of any crime since 2001. Okay, aside from this, the arrest that brings us here today, when was your next arrest once you were released from federal prison? Okay, so you're representing to the court under oath that since your release from federal prison in 2005, 2006, you have not had any trouble with the law. Okay, so obviously, I mean, you were, dare I say, you were on a bad path before this. So what changed from your release in federal prison to date that kind of just kept you out of trouble?
Well, you know, I had a bad accident, and I had a bad accident, and I had a son, and I just basically just didn't want to go through this again, ever again. And I just started working and getting everything, my life situated, because like what he said, what happened earlier was when I was really young, I'm 52. So at the time right now, I'm just to the point where this is like, I'm too old for this, basically, you know.
Okay, so since you got out of federal prison, what have you been doing to keep yourself occupied?
I've been working at the Examiner since 2005, and I still work there to this day. And I work 8 hours a week for them, and I work for Zumos from 5 a.m. to 6 a.m. every Monday through Friday. And I just started, I started driving last Monday, so I just got upgraded.
So you actually got promoted as Zumos recently. Okay, and so between your two jobs, how many hours a week would you estimate that you work?
Like maybe 60 hours a week for all Zumos and like 8 hours a week for the Examiner.
Okay. So when you're not working or obviously sleeping for this crazy amount of hours that you work, what do you do to keep yourself occupied?
I have a son at home, and he just got a job too last month, so he works at CC's. So I help him, and I get him to work, and I get him back and forth to work.
Okay. Does your son live with you?
Yeah.
Okay. Is he in any trouble?
No.
Ever been arrested? Okay, obviously you've been in some trouble, so are you open with him about that?
Yeah.
What do you tell him about keeping his nose clean?
Basically that you gotta, to do the right thing, you gotta work hard to get what you need instead of trying to do other things to get it. Cause I explained to him I got in trouble before and that what happened to me. So he's aware of what happened to me, but he's like the man that's in front of him now, he's impressed.
Okay, so when you're not working, when you're not parenting, do you drink? When was the last time you had to drink? Okay. What about drugs? Do you use any kind of drugs? And when I ask about drugs, I'm including marijuana in that. Okay. And is it true that you, on July 1st, you went and took a urinary analysis on your own accord?
Yeah, and I paid
Okay. And do you know what the results of that are?
Yeah.
What?
She told me I was negative on everything.
Okay. And we do have a copy of that, Your Honor. Okay, so let's talk about this incident on September 3rd of 2023. What brought about this incident?
My family was going through like, how can I say it? Like my son and his mom was going, his mom's brother was going through some things that they didn't really what's my me, but we were all getting threatened. And 3 days after this happened, my son got killed. And me and my wife was going through some things, and I just got emotional.
No, so more specifically, on September 3rd of 2023, what led to you going to this address on?
I had got a call that my wife was at this guy's house, and I went over there and I saw it. And
So when you say you saw it, what did you see? You arrive at this address, what do you see?
I see her car.
Okay, so what do you do when you see her car? First of all, how did you find out, who told you that she was at this house?
His husband, his wife told me.
Okay, so just for clarity, the man who your wife is allegedly over there seeing, his wife called you and said, your wife is over here with my husband. Okay, so you drive over to this address. What do you do when you get there? Please answer out loud.
I basically like everybody outside, and me and the guy's sons, we started arguing outside, and I was trying to get them to get her to come outside, and the guy had her barricaded in the back room, she said, and she couldn't come outside. And I just got upset because I couldn't get her outside, and I messed the car up. And
Okay, hold on. So you arrive at the scene, you're calling her, asking Ms. George to come outside. She's not coming outside, so you kind of direct your anger at this car and you do some damage to the car, right? Why did you smash up the car? Okay, so okay. But, okay, so you went there with the intention of just kind of confronting your wife, having a conversation with her, and you ended up smashing the car. Did you bring any kind of weapon with you? No. And you mentioned that the husband, some of his sons were outside, and you're arguing back and forth with them. Is there any type of confrontation with them?
Yeah, they was threatening me, and we was arguing back and forth.
But there was no physical retaliation, and you had an opportunity to retaliate against them if you wanted to. You stayed in the streets. Okay. Okay, so at some point, the police are called, right? Mm-hmm. And how do you know that did anybody tell you that the police were called?
The guy's sons told me that the police was called, and...
Okay, so where did the police end up arresting you?
Right there.
So you stayed and waited on the police?
Yeah.
Why?
Because I knew what I had done. I didn't want to run or get caught later or whatever. I just knew I had done it, so it wasn't no sense to run.
Okay. And so what was that conversation like with the police? Did you make any type of admission to them?
Yeah, when they came, they asked what happened. I told them, and I told them that I had did it. And he told me that he was just going to hold me in the car until he talked to everybody else. And when he came back, and he told me that he was arrested.
Got it. Okay, and so you get arrested. You spend overnight in jail. So you get out. And approximately when is your next conversation with Ms. George?
The day I get out.
Okay, and I'm sure there were several topics in that conversation, but was there any conversation about the damage to the vehicle that had been done?
Yeah, we talked about that, and I told her that I would help her pay for the car because I know I can do it. And like I said, like 3 days later, my son got killed. So I had gave her like $500 that day when we talked, and then I gave her another $500 like that weekend.
Okay, so all told, she had a $1,000 deductible on the car, right?
Yeah.
And you either paid or reimbursed her for that deductible, right?
Yeah.
And this was almost immediately after your release from jail.
Yeah, like the day I got out, I gave her $500, and that weekend I gave her another $500.
Okay, and this is in September of 2023, right? And you didn't get indicted on that original charge until April of 2024, correct? So this was months before you knew the storm that was brewing.
I really just like didn't want her to bear that by herself because she got 3 kids too, so I didn't want her to bear that on her own.
Okay, so are you aware that the total damage to the vehicle was approximately $13,000? Yeah. Well, yeah, according to the estimate, that is the total, between the physical damage, the loss of use, that is what Enterprise is estimating their damages at. So, because you are aware that this was a rental car, right? Okay, do you think it's fair that Enterprise should have to bear that loss for damage that you did to the vehicle?
No, I'm willing to pay the damage.
Okay, so first of all, can you afford to pay if the judge were to order you to pay $12,000 $12,000 approximately restitution today, is that something you're in a position to do?
I can make payments towards it. I have 2 jobs, so I get paid twice a week.
Okay, so you do have you don't have the money available right now, but you do have employment and you're willing to pay that restitution. And so hypothetically, if the judge were to sentence you to 5 years of probation, you would be paying approximately $200 a month just towards restitution. That's not including any probation fees, UA fees. Is that something you're in a financial position to bear? Okay, so obviously the state's concern is you've been sentenced to probation before, you've been revoked several times from probation before, and yet here you are asking the judge to give you probation today. So what is different about your life, your lifestyle, as you stand here today from the life you were living the last time you were in trouble?
In 1995, I probably was like 19. I was like really young, and I was really looking for another way to coexist as far as like to take care of my family, take care of myself. And in 2001, I was still on that path, but when I got out of prison, 5 years later, I just decided that that wasn't the path that I was trying to take because I was actually becoming an older man. I was like 31 when I got out.
Okay, so if the judge were to sentence you to probation today, are you confident that you'd be able to comply with the conditions of probation?
Yes, I can.
Okay, so obviously there's some mention in the PSI of you having physical limitations. And on that note, you do qualify for disability, don't you?
Yeah.
And do you receive disability?
No, I turned the disability down because it was like $981 a month, and I feel like I can still work. I can actually find employment to still work regardless of my.
But so you have the opportunity to sit at home and collect a check, and instead you're out there working 2 jobs. Okay, so.
Let me stop you. I understand your position, Mr. Coleman. I don't think there's a whole lot more that I need to hear. Mr. Coleman, you want to make any final argument?
No.
I'm inclined, Mr. Smith, to give you an opportunity today. On paper, I don't disagree with Mr. Coleman at all. Your criminal history is obviously terrible, but it was also 22 something years ago when you were quite a bit younger. It appears that this type of offense and this offense are something very different than anything you've ever done before. It looks like what you were doing was probably stealing for drugs and delivering drugs and things like that. That doesn't appear to be an issue anymore in your life. So I'm also taking into consideration what Ms. George said in the pre-sentence report with regard to this being very out of character for you.
And I apologize, since we're gonna go, since you brought it up, I have documentation in my file that Ms. George contacted my office and indicated that she was being pressured to sign an affidavit of non-prosecution by the defendant and her defense attorney. If she's here, I'm willing to call her up and put her under oath. But since you mentioned that, I thought in the interest of full disclosure to the court, that's what she told me.
Just for the sake of clarity, that wouldn't have been me, right? Because I was.
Must have been the previous defense counsel.
Okay.
Like the second.
Yeah, I'm the second attorney on this, so I don't know anything about that, and that has not been disclosed. As far as I can tell from the discovery, that has not been disclosed to us. But yeah, we're happy to call her to the stand, Judge.
If you want to hear from her, Judge. But that's what I proffer, that's what I represent to the court. She told me that she was being pressured not to sign an affidavit.
Are y'all are still together?
Yes, ma'am. We live together.
I think the issue is if we bring her up here, it's not gonna change anything. I can't imagine putting her in front if there's pressure that's something that she'd feel comfortable. All right, I'm still gonna do what I think is appropriate, and I appreciate Mr. Coleman, you filling me in on that. The fact that Mr. Smith's had the same job for almost 20 years since he got out. What I'm gonna do, Mr. Smith, is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of criminal mischief. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that, place you on probation for 10 years. You're ordered to pay a $1,000. Well, so I didn't see this. Has Enterprise turned in anything?
Yes.
Because it's not in the pre-sentence report.
It was provided in discovery. The total balance, and I tried to call and get some clarity on this. The estimate shows the total balance.
What's the amount exactly?
$13,114.93 according to this letter from Enterprise dated October the 5th, 2023.
Thank you, Mr. Coleman. So, Mr. Mr. Smith, I'm not going to order a fine in your case, but I am going to order that you pay restitution in the amount of $13,114.93. You will be required to follow, obviously, all of the rules and conditions of probation. I guess the only thing I'm reconsidering is the type of probation, only for my benefit. If, Mr. Coleman, do you have a preference one way or the other?
I prefer a final conviction, a post-conviction.
Okay.
Or other words, straight probation.
Okay, all right, then I'll stick with what I did. I am going to order that at least at the beginning of your probation, you're going to be on the high medium caseload, which means you're going to have to report more often, make sure you get off on the right track. If you do everything that you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side to that, though, is if you violate any condition of probation, I've just given you a 10-year sentence. You'll be back in here with the motion to revoke your probation, and you will be looking at that 10-year sentence that I gave you. Do you understand? That's a lot of restitution to pay. And understand you're working. I want at least half of what he pays every month to go towards restitution to get that paid. Work out a budget with probation. Don't think, a lot of people think, well, I'm going to wait. Next year when I get my tax refund, I'll put that towards it, but I'm not going to make regular payments. Do both. Make regular payments, and if you get a tax refund, it's going to go to that so that gets paid in full. It's very important to me.
One question on that, Judge, and I hate to quibble about that because we're through with this result, but my understanding is that Mr. Smith did pay $1,000 towards the balance, in the form of a deductible that's not reflected there. So if we are able at some point to produce documentation that the balance has dropped accordingly, is that something that, the probation department will have discussion?
Yeah, because that $1,000 was for the deductible to the insurance company.
Correct.
So and it sounds like.
But I don't think that $13,000 figure incorporates.
So the restitution will be no more than, make it that, no more than 13,100, whatever the number was. And then if you get documentation to probation that has been paid, then it would obviously be $1,000 less.
We'll talk about that.
But the insurance company should be able to verify if that happened. So that'll get that information through if she should be able to get that as well, and get that to probation. So if you do everything again that you're supposed to on this probation, great opportunity. Obviously, if you don't, you know what you're looking at. I'm handing you the trial court certification. It shows that this was not an agreement, so you do have some limited rights to appeal. Also, I've handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right, if you need I need you to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over all of your paperwork. Thank you, Mr. Coleman. Thank you, Mr. Jackson. Mr. Lane on Aaron Roberts.
Ready.
Good morning.
Good morning.
How are you? He did.
If there's a first for everything. We do have unagreed plea is 2 strike.
Okay.
It is. I can't find Roberts.
Aaron Roberts. All right, so are you Aaron Roberts? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Roberts, in 250250, you're charged with the state jail felony offense of theft of property from December 18th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year probation. There wouldn't be a fine. There would be restitution ordered in the amount of $33,204. And the type of probation would be left up to me when we come back for sentencing. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Roberts is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so we can get a pre-sentence report done. That'll give me more information about you, your case, any history, and we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see y'all back at sentencing. Mr. Kimler, Mr. Burbank, Renisha Chason.
She's outside.
Renisha Chason. Morning.
Good morning.
How are you?
I'm ready to battle with Mr. Ham on collective.
Oh, good times, like old times.
So if I go running down the hall back there.
Good morning, ma'am. You're Renisha Chason?
Yes, sir.
And Ms. Chason has 2 cases, 24-2351 and 19-33107, a motion to revoke probation, and then a new case. And what is the announcement?
Your Honor, I've been talking to the district attorney. There's a co-defendant that may be somewhat culpable. And
That is the case, Judge. We brought this over from CDC. That's why it shows that the MTRP is so old. This is the allegation underlying that MTRP. It's my understanding we have some favorable discussions amongst
Okay.
us. That co-defendant was Kendrick Williams. You'll recall he was set last week, and we realized that Ms. Holmes, who was appointed to
Oh, that was,
represents
yeah.
her on the
Mhm.
CPS side. So
Okay.
that became a conflict. So we kind of have to start over on that
Gotcha.
discovery, if we may.
Sure. So I'll just do a normal reset about 30 days or so, so that the other attorney can get up to speed on his case, and that y'all can have the discussions you need to with Ms. Malfino, and we'll see where we get at the next court date. Stay in touch with Mr. Burbank. He'll let you know when you need to be back.
Yes, ma'am.
Thank you, ma'am.
I'll call you with the court date.
Okay.
I'd be excused, Your Honor.
Yes, sir. Thank you. Let's see. Is there a Ms. Hawkins?
Yes, I have not spoken to her. I gave her my email last time we were here. She was here, very nice.
Okay.
I haven't heard from her to sign her up on the discovery.
Okay. Is Devin Spites? Just, I guess, see if he's here and if he's, Mr. Spites, have you heard from your attorney?
No, ma'am, I was just gonna ask you on the job.
No, sir. Do you have a way to try to get in touch with her?
Yes, but my phone just died.
Okay, that's okay. Just stay here. You can sit right outside the courtroom. We'll try to contact her. Don't leave, okay? Mr. Kimler, on Joshua Mays at the sentencing.
Yes, ma'am. That's because you drew it. Okay.
Well, at least focus on serious.
I need y'all both to sign that too. All right, so you're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation, was placed on a deferred probation back in September of 2021, and that was a 10-year, no, it wasn't, it was a 3-year deferred probation. There was a motion to adjudicate filed. We were here before. Mr. Mays pled true to failure to report and a failure to pay court-assessed fees. Let's see, hold on a second, let me go back and find what the other counts were. So it looks like, do you want to put on any evidence with regard to counts 2 and 3, the education program and the MRT?
Yes, I do, Your Honor.
All right, you can call your first witness, Mr. Nichols.
You swear me?
Yes, would you please raise your right hand, ma'am? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Joseph, how long have you been supervising Mr. Mays?
Since April of 2022.
And during that time, was he ordered to participate in the GED program?
Yes,
Has he completed that?
no, sir.
Did he provide you the verification that he was participating in that?
No, sir.
Are you aware of the issue he outlined in the letter to the court that he claimed he made progress while at ISF, but those credits would be accepted by the program, or do you know what that issue is?
I read it in his letter.
Do you know anything else about that, whether or not they would take those credits or not?
No, sir.
Okay, but did he give you the verification that he's been participating in that GED program? Okay, and moving on, was he also ordered to participate in the moral recognition therapy program?
Yes, sir.
And has he participated in that?
No, sir.
What level of participation has he done in the MRT program?
He has not even begun to start it. However, while we were waiting to come to court for this, they have since discontinued for a period of time until they can hire someone to offer the class. And we will again, but it's just worthwhile to note that while we were waiting, somebody retired, and so they had to hire someone else to.
At what point did they suspend the MRT program?
March of this year,
Okay.
March or April.
But during the years he's been on probation, he had not made
Prior
any
to
progress?
that, no, sir.
Okay. And so should he be, that program you believe will be available in the future?
It will.
Is there anything else contained in your pre-sentence investigation that you want to bring to the court's attention?
Stated what I needed to say.
Okay, thank you. Now I'll pass the witness around.
Thank you, ma'am. Mr. Kimler?
Have you checked with the ISF facility to see if they have a GED program or?
They for a fact do, sir.
Did you check to see if he participated in it? Did you check to see if he participated in it?
He didn't mention anything about it until after his release from the facility.
And my question is, did you try to
No, I
check?
didn't have a reason to, Mr. Kimber. He didn't say that he had participated in that until after his release.
No, I'm not trying to put you in a defensive posture. I'm just wondering if there's been any kind of independent attempt by the probation department to corroborate what he said about participating in the program while in ISF.
He didn't present any documentation.
So my
and
question-
I didn't check with ISF to verify what he said.
But just to be clear, ISF does in fact have a GED program.
They do.
Okay. Has he maintained employment while he's been on probation?
He has.
So lack of a GED, and again, the GED is worthwhile on its own merits, but it doesn't seem to have impacted his ability to maintain employment, the lack of the GED. He's been able to maintain employment without a
Yes.
GED. So you would say he has worked faithfully at suitable employment? You would
He
agree with
has.
that? What is the moral recognition class? Is that how you say it, recognition?
Yes, sir. That's how you say it.
How many sessions is that?
8.
Over a week, once a week or once a month?
They present one lesson each week until they have finished the course.
And it's a progression, then they're different classes, like a progression of 1 through 8.
There
So you
is
would
a
have to-
book that they have to purchase, and they do each chapter in the book until they have completed the book.
In sequence, right?
Yes,
In
sir.
sequence. So he would need at least 8 weeks to complete that if he took one session per week, is that right?
Yes, sir.
Has he maintained proper demeanor with you?
Yes, sir.
And as far as his reporting, he certainly hasn't become an absconder, is that right?
He's been an absconder 3 times.
Well, as far as what she's concerned, has he maintained contact with you or has he become an
Since his
absconder?
release from custody, yes.
He's maintained contact
Yes.
with you and reported this directly.
Yes.
In your report, you seem to indicate a willingness, a reluctant willingness perhaps, to have him continued on probation. Would you agree with that?
I hesitated to recommend that he be continued.
Did you recommend that or not?
My statement was that I hesitate to recommend, should the court decide. So I'm really leaving it up to the court, because I don't want to make a recommendation.
Because you don't have a recommendation, then. So you're not recommending that he be revoked, but you're not recommending that he be continued. Is that fair? But if the court were to see fit to continue him, then you would suggest extending him a year to give him an opportunity to complete the GED, pay his fees, and I guess at this point, once you all get somebody hired to do the moral recognition therapy class. Is that right?
Right, and I also recommend you come back to verify.
Every 6 months?
Yes.
Sure.
Because he has a habit of not reporting.
And of course, you could notify the court in that event, and we could schedule a hearing and holding this in advance, right, these allegations.
I'm not
Yes.
holding, yeah, okay, go ahead.
I was just, if that's what,
Yeah.
What's the purpose of the moral recognition therapy class? What's that directed to achieve with the probationers?
It's to teach them moral standards, have a sense of ethics and values, as well as other life skills.
To what end? To keep them from reoffending, would you agree?
Yes, sir.
Be a good citizen.
Yes, sir.
Has he reoffended since he's been on probation? Do you know?
No, well, no, sir, he has not.
That's what.
I have another question concerning those allegations, Your Honor.
Thank you. So concerning those allegations, number 2 and number 3, I am going to find those true, that there's sufficient evidence to find counts 2 and 3 true. And so what, the ISF that he went to, it doesn't say if it was cognitive or, do you know, Mr.?
It would have been a combination of both at the time. It was substance abuse, cognitive intervention, tracks because he tested positive for THC.
So he went, back then, you could do both. You can't do that now. I don't think.
Based on what they're offering at this point. But yes, he went for cognitive as well as substance abuse.
Okay.
And we're referring to the admin hearing from January 15th of 25, Your Honor.
Thank you.
Indicates that on January 12th of 2024, that it was recommended and approved that he, or on the 23rd, sorry, that he was successfully complete ISF, cognitive, and substance abuse tracks.
So was that a 6-month program or a 3-month?
It is a 90-day program.
90, so it wasn't both static.
I think they changed what they offer now, but it's a substance abuse now, and then it's a cognitive, and then relapse at this time. They combined substance abuse and cognitive tracks.
Okay.
I think he wanted to address the court to your honor at the appropriate time. He has written a letter.
I've read the letter as well. Mr. Mays?
With the transcripts, I have them in my folder. When I went up to the GD, the workforce center, the lady said that she couldn't take them, so I started doing the GD on my own, like on my phone. When I get off work, I complete the classes on my own. I just never brought it to her attention, but I have been doing the different classes and stuff on my own.
Why didn't you bring it to her like you're supposed to?
No excuse.
Okay. Mr. Nichols?
Judge, I know that this is a tough call for the court. These aren't the worst allegations we've ever seen, but he's also in zero tolerance and has been several times sanctioned, both in jail and with the ISF programs. And still, after only 3 years on, not even 4 years on probation, Judge, we're back yet again. It's really a test of zero tolerance at this point, because that's what he was ordered, was no problems whatsoever. And missing 3 months of reporting is a pretty big red flag to me, Judge.
Let me look back at something real quick. Also, before I want to make sure everything is saying that it was burglary of a habitation, but at some point, it looks like, at least on the old PSI, it was attempted burglary of a habitation, a 3rd degree. I want to make sure all the administrative hearings, the motion to revoke, everything says burglary of a habitation. I want to get that cleared up.
Your Honor, actually, I think the indictment is attempted. At least I'm looking at the indictment that's captioned attempted burglary of a habitation.
Okay, so the burglary of a habitation, do you want to make an oral motion to amend at least this motion that we're talking about today?
Yes, Your Honor, I will change burglary of habitation to attempted burglary of a habitation, comma, a 3rd degree felony.
All right. So we're talking about a 3rd degree felony. So, Mr. Mays, the problem is that you just like to do what you want to do when you want to do it.
Yeah, Matt.
And
could I argue? If you're, the thing I just wanted to say is, it's kind of a glass half full, glass half empty thing. If you want to look at somebody that we're trying to return to the community as a productive citizen, which is the goal, versus sending another person to the penitentiary, he has maintained employment. And he's had some, I guess, hiccups on probation as far as reporting, but he hasn't reoffended and he's employed. He seems like he is making a positive contribution to society at this stage. I don't really see where the interest, me personally, as the interest of the community would be served is to send another person to the penitentiary where they are making enough progress. And again, it's marginal, but looking at the totality of the circumstances to keep working with him, to hopefully keep him out of prison where he can keep employed.
well, here's my thoughts, Mr. Mays. You're not going home today. That's not happening. You're not going to walk out of here today. You're either going to get revoked and go to prison, or you're going to go to the cognitive track of ISF. Because somewhere along the path, you did not pay attention and you haven't learned from whatever treatment you've had before to make better decisions. You've been put on zero tolerance. You've been told don't miss another appointment. You have now 3 different times been given these opportunities and have not taken advantage of them. I don't disagree with Mr. Kimler. You haven't reoffended. You're not testing positive all the time. You're not doing those things, but you don't get to choose when you go to probation, when you don't, and you don't get to all of a sudden be really good at it when you have a court date coming up. Because that's something that is really frustrating to me, is that all of a sudden people start doing what they're supposed to be doing when they know they could go to prison. So my thought, I mean, you think it's ridiculous. You have hardly any criminal history. You got into some trouble as a juvenile. You haven't been in much trouble at all. And you're not taking advantage of keeping this conviction off your record. And that's going to be on you, not on me, if this happens again. Because I have no doubt if I do what I'm thinking about doing and we're back in here again, Mr. Nichols is going to point out to me how many times I've given you an opportunity. Do you understand? There will not be another opportunity. I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Again, find that there was sufficient evidence to find counts 2 and 3 true and find those true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to add an additional 3 years to your probation. So you could have already been done, but instead you have 3 more years. And that's the 1 year for every time that you've been an absconder. So that's what you're going to have to do at this point. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. You need to take advantage of that program, learn to follow the rules, all the rules, get out, and you still have an excellent opportunity. But if you're back in front of me again, I'll see all of this. I'll probably wonder at the time what I was thinking today, but you will not get this opportunity again. Do you understand? 1 missed meeting. We're not going to do 2 or 3 missed meetings. We're not going to get to absconder status again. You miss a meeting, I want to hear about it in an administrative hearing. There's going to be a motion to revoke, and you're going to go to jail.
Your Honor, since she's going to cognitive track on ISF, could we rescind the moral recognition therapy? It seemed to be redundant.
Nope. Kind of seems like he needs some redundancy. Might help if he gets out and then has more to reinforce what he learned. So no, I'm not going to do that. All right, I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Mr. Kimler, you have Richard Robb.
Your Honor, I think we've agreed to reset that one.
Can y'all come up, please? Richard Robb.
Richard Robb.
That's right here. Put your hands up here.
Good morning, sir. You're Richard Robb. And this is 242170. Mr. Robb's charged with theft of property. And what is the announcement?
We could have one more setting on this.
Judge, if I may just confirm that the property was returned to the owner. It reads as if it was, but if I may make confirmation of that, I think the disposal.
All right, we'll just do a normal reset. Mr. Robb, make sure you stay in touch with Mr. Kimler and your bondsman. They'll let you know when your next court date is. You're free to go. And then Juan Torres Lopez. Thank you. Good morning, ma'am.
Good morning.
Would you please state your name for the record? I'm sorry, I can't.
It's Mighty Young, Real Benavides.
And would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. Sir, are you Juan Torres Lopez?
Yes.
And Mr. Lopez is charged with solicitation of prostitution in cause number 25-0211. And what is the announcement?
Yeah, we filed a plea rejection of 3 years deferred and a $500 fine.
Let me go. Sorry, hold on.
And that was explained to Mr. Torres in Spanish.
And Mr. Torres Lopez, I want to make sure you understand, if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. And I have a plea bargain rejection that has your signature with Mr. Kimmler's that shows that the district attorney's office has offered, if you wanted to enter a plea of guilty, a 3-year deferred probation, $500 fine, and you would be required to follow all of the rules of probation. Do you understand?
Answer.
Yes.
You have every right to reject that offer and have your case set for trial. I want to make sure you understand what your options are and what the possible consequences are if you go to trial. And do you want to reject that offer and have your case set for trial?
Yes.
Is there any reason to believe that this offer would change?
No.
Mr. Torres, I want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind and want to enter a plea of guilty, it would either be open to the court or to some different plea agreement. Do you understand?
Yes.
Okay, we'll set it on the trial docket, and Mr. Kimmler will begin preparation for trial. Thank you. Thank you, ma'am.
Thank you.
Okay. Okay. Ms. Malfino, I'm going to reset Mr. Spites. She's responded, having some health issues this morning. And so we're going to email her back to make sure that she does what she needs to get in touch with you immediately. If you'll let Devin Spites know his case is getting reset. And just do a normal reset, and would you make sure that you put in there that she needs to contact the DA immediately so that she has all the discovery before her next court date?
Yes, ma'am.
Okay.
And Burbank's client, Anna just got an email that she's not wearing her drug patch, and so Anna texted Burbank to see if he could come back so we could deal with it, but he hasn't texted her back, so I just wanted to let you know.
Where, and she's already gone though, huh?
Probably, yeah. I mean, she just got the email a few minutes ago. So.
Okay. Well, it doesn't, yeah, tell him he doesn't need to worry about coming back if we can't get her back.
Right.
Set it for next Monday, if you would. Let's reset it for next Monday for a bond condition review.
Yes,
It's just going to be normal reset, so about 30 days or so. So stay in touch with her and your bondsman. They'll let you know when you need to be back. Yes, sir. Mr. Crenshaw on Timoteo Castaneda.
Yes, Your
Good morning.
He is good to go.
Good morning, sir. Are you Timoteo Castaneda?
Yes, ma'am. Good morning.
And this is 250360. Mr. Castaneda is charged with indecency with a child by sexual contact. Mr. Crenshaw, what is the announcement?
This is our very first setting, Your Honor. Mr. Hoffbauer and I have been in discussions about a resolution. If we could please just have a standing reset.
Is there any issues, Mr. Hoffbauer?
Judge, that's correct. I spoke with Mr. Crenshaw about it. He's got, I think he's confirmed he has everything we need in regards to discovery.
Okay.
Discussing.
All right, so I'll just do a normal reset to give you some time to get with your client, go over all the discovery. Make sure you stay in touch with Mr. Crenshaw so you guys can visit. And maybe we'll get an announcement at that next court date. All right, thank you. And then you have Justin Chapa sentencing, Mr. Crenshaw?
Yes, Your Honor.
That's good.
And Mr. Nichols and I have something to add regarding the memo that you got, Your Honor.
Okay. Good morning. Are you Justin Chapa?
Yes, ma'am.
And Mr. Chapa was previously in court, entered a plea of guilty to aggravated robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Judge, I'll go ahead. Judge, I received the addendum memo from the store manager concerning his thoughts on this. I think there must be some mistake there, Judge. I've seen no reports of additional robberies, no indication that he was a suspect in anything else.
Okay.
I understand his concerns and appreciate him giving his opinion, but I don't think that matches what the police reports and everything else indicates.
Okay.
As well as the gang affiliation, Judge. There's no history of any gang affiliation.
Okay.
I know of none, Judge. So it's concerning, I know on its face, but after looking at it, I don't think it matches the evidence in this case, Judge.
Okay. What is this? So there's a misdemeanor driving while intoxicated, an MTRP.
I was going to ask the misdemeanor prosecutor to dispose of that as part of this deal, Your Honor.
Okay.
So it'd still be on his DWI probation.
Okay. Anything else?
No, Judge. My client was, I believe, actually employed at the time of this at Motiva, if you can imagine. Since then, he now works at this family roofing business. Has been doing great on that. I sent him to a professional counselor on his alcohol issues, and he's been in treatment for that and has done well and will do anything the probation department wants him to do on alcohol treatment. And I know it's hard to imagine, but this really just was a terrible drunk error in judgment that he made while highly intoxicated, and I do not believe we will have, with treatment for his alcohol problems, we will not have any problems with him in the future. He is, other than what we saw in that incident, a very hardworking, respectful young man, and he is greatly sorry about what has happened.
All right. Anything else?
No, Your Honor.
All right, Mr. Chapa, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include that you enter and successfully complete the JCDI program, which is an intensive outpatient treatment program. As well, I am going to order that you wear a scram device, at least for some amount of time while you're on probation. That's a device that you put on that will tell me if you are drinking any alcohol. We'll get those updates on it. If it's tampered with, If it tests positive for alcohol, then that could be a reason for you to come back in on a motion to revoke your probation. I want you to get that scram device within 24 hours. So by tomorrow afternoon, you need to have that done. Mr. Crenshaw and your bondsman and actually probation can give you a list of places where you can get that scram device put on.
Judge, if I may, on the scram device, just because I tried to put one on a client 2 weeks ago, they not only require the court order, so we'll have to have a copy of that, but they only come to Beaumont once a week and it's on Tuesdays.
Okay.
And I just don't think that we can make that happen today, so I'd ask that he at least. have it
Tomorrow's
by-
Tuesday.
Well, I know, Judge, but we would have to get them the order and schedule the appointment. And I just, it's a company that comes out of Houston and they're very difficult to deal with.
Is that the only company that does it?
I would have to look into it, Judge.
Are
you talking about Recovery Gold?
Yes, that's who probation has sent my other clients to.
Yeah.
And they require all the paperwork, payment, everything to be done before they will schedule you for
Okay.
an appointment. I would just ask if we could please have until next Tuesday.
Okay.
To get that done.
All right, we'll do this by next Tuesday, end of business day. Should give you plenty of time to get that taken care of. So make sure Mr. Crenshaw obviously knows where to get that information. You need to make sure and get that done, get it paid for, wear it, and then not test positive. You cannot drink any alcohol at all, even though it's legal while you're on this probation. Do you understand? Also, a condition of your probation is that you are not allowed to be in possession of a firearm. That means on your person, it means in a vehicle, and it means wherever you're living. You cannot have any type of firearm. Do you understand that as well? Any other conditions?
I think that will cover it, Your Honor.
All right, then I'm going to hand you, well, first of all, Mr. Chapa, this is an excellent opportunity. And if you do everything that you're supposed to while you're on this probation, you do not have a conviction on your record. And at the end of the probation, if you are successful, the case gets dismissed. You're never a convicted felon. The other side of that, in this case, is extremely serious, because if you violate any condition of probation, you can be brought back into court, found guilty, so then you're a convicted felon, and go to prison for anywhere in the range of punishment, which is a minimum 5 years in prison, up to 99 years of the rest of your life in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Let's see, you have a Jacob Graves.
Yes, sir.
You go off real quick. I just want to tell you something about that.
Jacob Graves.
Yes, ma'am.
And will your client waive the formal reading of the motion, Mr. Crenshaw?
Yes, sir.
Let me get that pulled up properly.
I think we're just proceeding on violation one.
Count one. Mr. Graves, in cause number 22-40761, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation April 10th of 2023 for the first-degree felony offense of arson, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count one alleges that you committed the new offense of driving while intoxicated October 20th of 2024. And is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for you to plead guilty to that DWI with a 2-year probation on that down in misdemeanor court. And then your probation here would be modified to include an alcohol assessment and any treatment as required as a result of that assessment. Is that your understanding?
Yes, ma'am, it is.
State tender's number 1.
No objection.
It's admitted. Is there any evidence that Mr. Graves is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty and revoke your probation. However, I'm not going to do that. I'm going to continue you on probation. I am going to order that you submit to alcohol and drug screening. Any treatment that they say you need, whether you think you need it or not, you're going to be required to do that. Obviously, follow all of the rules and conditions of probation. This is a great opportunity because just based on that one allegation, you could be revoked and go into prison today. So I want to make sure you understand that you need to do everything you need to get your life on track, to not make these kinds of mistakes, be successful in the probation. Again, you still don't have that conviction, but it would be very different if you are back in here. Do you understand?
Yes, ma'am.
Probation's here. Is there anything else that you need to recommend or think that I should do?
No, ma'am, I was agree with the alcohol and assessment. We do have somebody in our office that does substance abuse assessments, but I know they found somebody else, which is perfectly fine as long as I'm updated.
Okay, sounds good. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Are y'all going down there to take care of that misdemeanor today, or is that?
We're not, Judge, but at the next time it's set, I'm waiting to be paid.
Okay.
And next time it's set, it will be done.
Perfect.
We will plea and take the 2 years probation.
Okay, sounds good. All right, stay in touch with Mr. Crenshaw so you make sure and get that misdemeanor taken care of as well.
Yes, ma'am.
All right, you're free to go. Thank you, ma'am.
All right, thank you.
Mr. Macon, are you ready on Matthew Baxter? That's a sentencing.
Yes, sir.
Good morning. Are you Matthew Baxter? And Mr. Baxter was previously in court and entered a plea of guilty to the first-degree felony offense of aggravated assault against a public servant. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. State has, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state, Judge.
So, based on obviously the nature of this offense and looks like underlying issues with regard to drug issues and mental health issues, I am inclined, Officer Norsworthy has some very strong opinions, and I don't blame him for having those opinions. I don't know that there might be some type of upfront so they didn't do a full substance abuse assessment, just the when did you go to La Hacienda?
That was quite a few years ago when I was in my 20s.
Okay. And then you went to another place, Seacliff.
Yeah, I think maybe when I was around 23 to 25.
Okay, so this says that you have a medical marijuana card, but you're not using it. Is that correct?
That's correct.
When's the last time you used marijuana?
It's been months and months.
Okay, so what I'm going to do, Mr. Baxter, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you've made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you are not allowed to use any type of marijuana, medical or otherwise, without my specific permission. So if you test positive for marijuana, it's going to be a violation of your probation. There are other things you can do to get the help you need for any underlying issues that you have. You're going to be required to do a substance abuse assessment. And if that assessment says, you know what, Safe P is warranted, or ISF, or something outpatient, you will be required to do whatever it is that that assessment says. I want that assessment done. What's the quickest something like that can be taken care of?
Get it done within a week or two.
Okay, so you need to get that scheduled within 2 weeks, so don't put it off. You have to go to the appointment and get it done, and then follow any recommendations of that assessment. And if you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you'll never be a convicted felon. You have no criminal history. You have one, this is it. This is your criminal history, is this case. And so there's every reason why you're getting this opportunity, but you need to understand, again, if you take advantage of it, it's great. At the end, the case gets dismissed. If you don't take advantage of this and you violate in any way, you can be back in court, found guilty of the offense, which gives you that felony conviction, and sentenced anywhere in the range of punishment, which is between minimum 5 years up to 99 years or the rest of your life in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Thank you, sir. Thank you, Mr. Coleman. Let's see. Mr. Parker on Benjamin Barker.
It's kind of weird the way we fill the paper out, Judge. It's a 3rd degree, but to a state jail, sentenced under 1244.
Okay. Let me get that pulled up. Good morning. Are you Benjamin Barker?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And I am going to take judicial notice of the court's file in 242194. May have already done this, but Mr. Barker was assessed for competency and initially found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration, received a packet April 1st of this year from them that stated that Mr. Barker had achieved competency. Is there any other issues with regard to competency?
No, Your Honor.
No, Judge.
Then I'm going to find again that Mr. Barker is competent to stand trial at this time. And will he waive the formal reading of the indictment?
You will, Your Honor.
Mr. Barker, the state's elected to proceed on the lesser included offense of the state jail felony attempted harassment of a public servant from October 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
You gotta speak up.
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? The attempted harassment of a public servant.
You gotta speak up.
You have to say yes or no so I can hear you, and also the court reporter can take everything down, okay? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Mm-hmm.
Yes or no?
Sign this again.
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State attendance number 1.
No objection.
It's admitted. So it looks like the agreement is for that 1244 for 180 days.
And he has credit for 199.
But I think because it's a state jail, does he have to go?
Even if you punish it as a misdemeanor under 1244?
Because it's a state jail felony conviction. I'm not sure about that. Because he's been in jail, so he was booked in on it before. So they have a TRN, they have a thumbprint. If it's county jail time, okay, I'm just gonna do this. All right, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of attempted harassment of a public servant, sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. It is my understanding that it's been verified that you have more than that amount of credit, and so you will receive credit on that sentence for all of that time as well. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a Hey, let me read this out to you. I'm required to. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker about that. Probation is going to call you up to her desk when she's ready to talk to you, so don't leave the courtroom until you visit with her. Actually, no, she's not. I'm sorry. Never mind. You're done. Goodness. To me. All right, you're good. You're free to go.
Thank you, Judge.
I do. I feel like it's been a long, too many words. Thank you. Yes, sir.
Judge, can we please talk very briefly?
Yeah. On who?
Mr. Joppa.
Mr. Macon, are you ready on William Patterson to sentencing? It's a sentencing on William Patterson. Good morning, sir. Are you William Patterson? And Mr. Patterson was previously here in cause number 24-1270, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Are there any additions or corrections?
No, nothing to add, Your Honor.
All right, Mr. Patterson, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program. Also, you are required to serve 10 days upfront time. Let's see. So you're unemployed at this time, so there's no request, I guess, to do weekends if there's no job?
He's gonna go in and do the 10 days.
Okay, so you'll be ordered today to start those 10 days, and then as soon as you're finished with those, you'll get out of jail and go straight to probation, do what they tell you to do. If you do everything you're supposed to while you're on this probation, then this is an excellent opportunity because you'll serve that 10-year sentence while you're out on probation. The other side to that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've agreed to already. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. And, I'm sorry,
Mr. Patterson asked, can he do the 10 days starting tomorrow?
No.
I have nobody pick the car up. I'm gonna pick it by myself. Okay, yeah. 'Cause I had to, then my granddaughter's gonna take care of me, so.
All right, the bailiff will get that stuff and let you make, yeah, and if you'll let him, you can let him make that call when he needs to. Thank you. And then, Mr. Macon, you have two others, Cedric Fontenot and Glenn Hicks.
Your Honor, Mr. Fontenot's an announcement, and that asks for 30 days for Plea.
Cedric Fontenot, 24-1665. Good morning. Are you Cedric Fontenot?
Sorry.
That's okay. And Mr. Fontenot is charged with solicitation of prostitution in cause number 24-1665. You all right? What is the announcement?
Your Honor, I'd ask for 30 more days. I believe that will be a plea at that time.
Any issue, Mr. Hoffpower?
No.
All right, we'll do a normal reset. Mr. Fontenot, make sure you stay in touch with Mr. Macon. He'll let you know when you need to be back and get your case taken care of. All right, you're free to go.
Tomorrow, call my office.
And then on Glenn Hicks,
Your Honor,
Mr.
I'm working on the plea papers now.
I'll hold that until it's ready, and that's
Judge, you will find time to tell them.
Yes, ma'am. That's where we were, that's where we were. Since we are on a new day, if you'll raise your right hand, let's place you under oath again.
Ms. Johnson, I'm Dora Salinas. I'm going to ask you some questions. You and Mr. Johnson, you were married on September 12th of 98. Is that right?
You might move up just as close as you can, but
Oh, no. All right. And you were asked by your attorney about, well, actually, Mr. Johnson was asked about some problems he had with an employer where there maybe were some accusations made against him. Were those accusations made in 1998? Do you remember when those accusations were made? About theft from an employer. Okay, when were those? 2000. So you were just married at that point in time a couple of years, is that right? And none of your children had been born, is that right? And you stayed married to him, is that right? All right. And in fact, you stayed married to him till 2024. Is that true? All right. So you could have divorced him then, but you chose not to. Okay. And when was your first child born? And then you went on to have a second child, is that right? And you went on to have a third child, and you went on to have a fourth child. And in fact, your fourth child was born in 2007, is that right? So there were plenty of good times between you and Mr. Johnson, is that true? Okay. And there were some questions made to him regarding Community Bank and Trust in 2012. You didn't divorce him in 2012, did you? In fact, you stayed married to him for another 12 years. Is that right? All right. And you were asked by Ms. Roberts about your employment history. Where were you employed when you and Mr. Johnson married? And what did you do for the credit union? All right. And how long had you worked there? Okay. And did you stop working then, or did you go on to work somewhere else? Okay. And when did you stop working? Okay. When your second child was born, and that was in 2004, is that right? Okay. And how long did you stay home when your second child was born? All right. So you worked as a tech. Where did you work? What hospital? St. Thomas. Were you getting paid then? All right. And from 2014, is it accurate to say that you worked, you either were working and going to school or you were working? Is that right? Okay. And when did you graduate from nursing school? 2000 what? You graduated in 2014. All right. And have you worked as a nurse going forward? I believe you said since 2015? All right. So it's not like you had just re-entered the workforce a year or two before you filed for divorce, did you? You had been working for,
Okay, all right. And when did you start working full-time? In 2014. Okay. So 10 years prior to the divorce becoming final, you had been working full-time. All right. So again, it's not like you just re-entered the workforce. And when did you work for the state of Tennessee? You worked for the state. And what did you do for the state of Tennessee? All right.
Let me check. Tap that microphone.
Yeah.
I know, but that, we're not working on that. I don't know why that was not working anywhere we can check. I didn't think it's in. When you get to be my age, it's hard to hear in a building like this.
I understand. That's better. I can hear myself.
I needed to make sure we were picking it up. Thank you.
All right. So Ms. Johnson, it sounds like you worked, you had periods of time where you had children, you took some time off, and then you worked, and then ultimately you went to school, but you were back in the workforce full-time since 2014.
That's correct.
And since 2014, that would have been as a nurse, but you had prior work history with the state of Tennessee, with the credit union and such. Is that correct?
That's correct.
Okay. And what were you earning as a nurse when you and Mr. Johnson separated?
I was actually a travel nurse, was unable to complete the contract with the travel agency. I am not sure of specific amounts.
Well, when you separated, so where were you traveling to as a travel nurse?
Louisiana.
Okay. And were you required to stay in Louisiana?
I was.
Okay. And had you received any paychecks as a travel nurse?
When we separated?
Yes, ma'am. Or let's just go back 6 months prior to the separation. Were you working as a travel nurse then?
No, I was not.
Okay. Where were you working 6 months prior to the
St. Thomas
separation?
Midtown.
St. Thomas. And what were you earning at St. Thomas?
I would say, I don't really know I would have to have that, at least $35 an hour.
Okay. And you're an RN, is that correct?
That's correct.
Which means you're a registered nurse.
Mhm.
Okay. And as a travel nurse, would have you been making more money than you would have?
Yes.
Okay. And then when you were unable to fulfill your contract, where did you go back to work? Or where did you go to work?
I went back to St. Thomas
To
Midtown.
St. Thomas. And do you remember when that was?
May of 2022.
May of 2022. So just the month after you and Mr. Johnson separated.
Yeah, it might have been June 2022. I had to have a full-time job.
Okay. And you separated in April of 2022.
Mhm.
Is that right?
That's correct.
Okay. And again, you don't remember what you were earning in May or June of 22, or do you?
No.
No. Probably at least $35 an hour.
Yes.
And were you working full-time at that point?
In May of 2022, yes, I went back to a full-time job, and I'm still currently working that job.
You still work at St. Thomas Midtown?
I do.
What are you earning now?
I have my current pay stub if you would like it.
Well, do you know what it is?
42.
42 an hour?
That's correct.
And do you recall what you were earning in April of 2024 when the divorce became final?
It would be, I do not know.
Would have it been close to $42 an hour?
Yes.
Okay. Now, when you were asked about certain expenses that you paid by Ms. Roberts, you said that you paid the utilities each month after you separated for Mr. Johnson. What did the utilities average?
I paid the electric, the water, the cell phones, the car insurance,
Well, let's talk about
Just
utilities. first.
utilities.
Yes, ma'am.
Utilities would be, I mean, you want to average,
Yes, ma'am.
I would say $600 or $700 a month.
$600 or $700. And how much was the car insurance?
The car insurance was around $800 for all 6 of us.
$800 a month.
Yes, ma'am.
Were you paying all 4 girls in car insurance?
Yes, and his as well.
Okay. And who is the insurance with?
Allstate.
And cell phone bill, how much did you pay?
It was around $650. It was for all 6 of us as well, and that's including his.
Did the girls assist with any of their own expenses such as car insurance or cell phone?
My oldest did pay. She paid around $150 just to help out with, but nobody else, no.
All right, but you didn't pay one house payment, did you, from the date of separation?
I've never paid a house payment.
Well, but sometimes things change after divorce. I mean, would you think that would be an accurate statement?
Sure.
Okay. You were living in the house, is
I
that
was.
right?
I was.
Did you ask Mr. Johnson to leave?
I did.
Okay. So you were living in the house from what date to the time it sold? Would have that been April of 2022?
When we separated?
Yes,
The
ma'am.
children and I lived there.
Okay. All right. And you didn't pay one car payment from that date forward, is that right?
I paid my own car payment, yes.
Okay. Let me back up before I forget. How was your nursing school paid for?
Student loans.
Okay. And ultimately, was there a home equity loan that was taken out against the home?
There was
Okay.
several years ago.
And were your student loans paid off?
No, ma'am.
They weren't paid off.
No, I still have $30,000 in student loans.
All right. So you didn't pay any house payment. You didn't pay one pool payment. Is that right?
That's correct.
Okay. Do you enjoy the pool in
I
the
did.
summer?
I did. I paid to open and close it and the chemicals to go in it.
Okay. Do you even know how much the pool payments were?
Yes, because they started calling me when they were not being paid.
How much were they?
$551.
All right. And do you know how much the house payment was?
I do not.
All right. And the car payment that Mr. Johnson was paying, was that your car at one point in time?
I did drive it, yes.
Okay. And what kind of car was that?
Honda Accord.
Did you pay any of those car payments?
No, I did not.
No. And ultimately, did it get transferred to your daughter? Did she start driving it?
She did when she
Okay.
turned 16.
Okay. And which daughter was that?
Lauren Johnson.
Was there still money owing on the car when that car became her car?
Her father told her it was paid off.
All right. So you're
And it was
not
not.
sure.
It was not, because
Okay.
it was in an accident, so I found out that it was not paid for.
All right. And what happened with that insurance check?
They sent it to me,
Mhm. Whose name was on it?
mine.
Yours?
Yes.
Okay.
Would you like a copy of it?
No, I've not asked for a copy
I
of it.
have-
I'm just asking you.
Yeah, my name.
Okay.
Yes.
And whose name was on the title?
Troy's.
Okay. And did you sign that title?
Title, no.
No. What happened to the title? Where'd it go?
I'm assuming it was a total loss. The insurance took it. I'm pretty sure they sent the information to him.
Okay. But you never signed that title?
No,
Okay. All right. What'd you do with the insurance check?
I put it into my account.
And how much was the insurance check?
Can I get it? 3,960 maybe? I have it over there.
$3,960. Yeah, if you have it, if I can see. Your Honor, did she get the insurance check for the Ford?
Yes.
Nothing payable to you.
Yes, ma'am.
Okay, but the car was titled to Troy Johnson, is that right?
That's correct.
Okay, and those proceeds were deposited into your bank account?
That's correct. I notified him that they sent me the check,
Okay,
and they sent him the information to take care of the title.
are you sure about that? I mean, you're presuming, right?
I'm presuming, yes, because
Okay.
I don't,
Okay,
the car was totaled.
but you received the benefit of the proceeds, is that right?
That's correct.
Okay, and Mr. Johnson had been paying all the payments, is that right?
That's correct.
Okay, all right, you were separated for how long before you filed for divorce? Almost 18 months?
That's correct.
Okay, and during that time period, Mr. Johnson paid for the uncovered medicals for you and the children, is that right? Or you paid for them through a health savings account that belonged to him, is
Yes,
that
most
right?
of them were set up on reoccurring monthly payments.
Okay, but again, he bore that expense, is that right?
Yeah, yes, it was, credit card. They just came out of that account.
That he deposited money into,
Sure.
correct?
Mhm.
You didn't deposit any money
No.
into it, right?
Mhm.
All right, so you agree the house payments that were paid, they were paid by Mr. Johnson,
That's
is that
correct.
right? The pool payments that were paid, they were paid by Mr. Johnson,
Mhm.
okay? The Honda Accord car payments that were paid by Mr. Johnson, is that
Mhm.
correct? And if you would answer maybe yes
Yeah,
or no,
yeah.
it's easier for the court reporter. All right, and the uncovered medicals for you and the children were paid by the HSA account. Is that correct?
Some of them came out of the HSA, yes, I would say.
Where'd the others come out of?
I paid.
You paid some? Do you know
Yes.
how much you paid?
I do not.
Okay. All right. And in fact, Mr. Johnson paid for your health, vision, and dental insurance from the date of separation through October of 2023. Is that right?
He's always had my health insurance.
Do you have health insurance available through work?
Not as a PRN employee.
How long have you been? Are you a PRN employee right now?
No, I'm full-time.
When did you go full-time for St. Thomas?
When I went back in June of 2022.
So you've been full-time since June of 2022 and not PRN, is that right?
Yes, that's correct. And I had health insurance in June of 2022.
In June of 2022. You had your own health
No,
insurance?
I did not. It was through him. He's always had our health insurance.
Okay, but you separated in April of 2022
Mm-hmm.
and you waited to file for divorce until October of 2023, is that right?
Yes.
And Mr. Johnson wasn't served with that divorce complaint until November 21 of 2023, is that right?
I'm unsure of, I think there was some speculation of when he was served, but.
Well, the file would reflect when he was
Okay.
served, is that
Okay.
right?
Yes, sure.
And you never took any action during that time to get your own health insurance?
No, I did not.
All right.
I did get my insurance when I discovered it was canceled. But so yes, I got insurance. It began January of 2024.
Of 24. Okay.
My insurance was canceled. I found out when I went to get a prescription filled. He did not notify me. My insurance was canceled.
You never had any conversation with him at all about insurance?
Health insurance?
Yes,
No.
ma'am. No. Did you just expect that you would be on his health insurance for the next however many, 10 years? 5 years?
No, we had kept things the way it was when we separated. I had his automobile insurance. We had things exactly the way it was when we separated.
Okay. The 401k money that's somewhat in controversy as far as whether or not you should receive a portion of it.
Mhm.
That money was withdrawn more than a year prior to you even filing for divorce. Is that right?
Yes, 2022.
In 2022, that's correct. When you were in court in front of the judge on the motion for default, did you notify the judge that that had been removed? Oh goodness, 18 months or 2 years prior to you coming in front of the judge?
That was not asked of me.
But you didn't notify the court that, did you?
No.
And you didn't mention that Mr. Johnson would have had to pay taxes on those sums, did you?
No.
And do you disagree that but for he should have disclosed something that his name is. Your Honor, the 1099 reflects that taxes were withheld.
I'm sorry.
The 1099 that Mr. Johnson received, and I believe is in evidence, reflect that taxes had been withheld. So when that money was given to him, taxes had already been withheld.
And your question to her was?
Did she testify in court on the date of the default that sum, that Mr. Johnson did not receive that total sum, that he received a lesser amount due to taxes being withheld?
We're talking about what she knew at the time of the default judgment.
Well, I was asking her, when she asked the judge for half of the whole, did she notify the court that there had been taxes withheld?
Overrule the objection. Cross-examination.
All right. Ma'am, did you realize that those proceeds had been taxed?
No.
You didn't know. Do you believe that if those proceeds had in fact been taxed as reflected by the 1099, that you should receive half of the whole? Or do you believe at best you should receive half of what Mr. Johnson received?
The judgment was entered for half of the whole amount.
Well, I understand what the judgment was entered for. I'm asking you, what do you believe is fair?
The whole amount.
Half of the whole amount, even though he didn't receive half of the whole amount.
Sure.
Okay. And do you have a 401k?
I do not.
You don't have any retirement whatsoever?
I do not.
You could pay into a 401k, is that right?
That is correct.
But you've elected not to.
I have not.
And you could have paid into a 401k since 2014, am I correct?
Through my current employer?
Well, just through whatever employer you had since
Sure, yes.
2014. But you elected not to, is that right?
That's correct.
Okay. When you were in court on the motion for default, you didn't tell the court that you had been living in the house since April of 2022, and that Mr. Johnson had been paying the house payments that were paid. And I'm not asserting that he paid each and every one, but any house payment that was paid, he paid it. Is that right?
That is correct. Yes.
Okay. Did you tell the court that?
That's why he was ordered to continue to pay it.
My question is, did you explicitly tell the court Mr. Johnson had been paying the house payments that had been paid since the date of separation?
No.
Okay.
I'm not sure I understand. I've never paid the house note. He's always paid the house note. So
I understand
yeah.
that, but you didn't say, Your Honor, I've been living in the house since 2022. Mr. Johnson has not been, and I haven't paid any house payments, but I'm asking you to order that he keep paying the payments.
There was trouble with the payments, foreclosure, default, things like that were happening. So,
but you didn't tell the court that any payments had been made, that you hadn't made them.
no,
had you?
I was not asked that.
Okay. And do you think that it was fair for Mr. Johnson to have to keep paying house payments after the divorce, even though you were the one living in the house?
Joy and I had a verbal agreement that we were going to keep the children in the house until the youngest graduated, so that she could graduate from the home she had lived in.
Okay, so is that a yes or is that a no?
What was your?
My question was, do you think that it was fair?
Yes, I do.
You
We
think
were
that
trying to
was
keep
fair?
the children in our home.
You could have paid part of the house payment, couldn't you?
Not at the time. I didn't make the money.
You were making 40-some dollars an hour, is that right?
I also paid all the utilities.
Well, Mr. Johnson also had to pay for another place to live, is that right? You asked him to leave the marital residence, correct?
I did.
Okay, so he had to pay for another place to live or live on the street, is that right?
I don't know that he would have to live on the street.
Well, he had to live somewhere,
That's
correct?
That's correct.
Do you believe he had the right to have an apartment?
He chose that, yes.
He had to pay for it, wouldn't you anticipate?
That's correct.
Okay. You didn't tell the court the day of the default hearing that Mr. Johnson had paid you numerous payments through Venmo, did you?
No,
And you didn't tell the court that Mr. Johnson had paid numerous payments to the children through Venmo, did you?
was not aware of what he paid the children.
Well, you could have prepared for your hearing and had those amounts available to give to the court, is that right?
There was no hearing. We walked up here.
Well, there was
at-
a hearing. You were put under oath, correct?
Okay. Well, those questions were not asked of me.
Well, did you tell your attorney that
Yes.
You did?
Mhm.
Okay. And you didn't think that it was pertinent to make sure the court knew that Mr. Johnson had paid $6,297.50 in Venmo payments to you and the children?
I was not aware of what he had sent to the children.
Well, you're asking for the back child support judgment and over $26,000
Mhm.
that stand, right?
Yes.
So you don't think that would have been pertinent information to provide to the court when you were in front of the court?
Yes.
All right. And again, you didn't tell the judge that Mr. Johnson had paid over $34,000 in house payments, right?
I was unaware of how much he had paid because I was getting notes on the door, and default letters and foreclosure letters.
Again, that would have been pertinent information for the court to have had, though. Would you agree?
Yes.
And you didn't tell the court that he paid over $11,148 in car payments for a car that you drove and then your daughter drove.
No, I did not. That was my car since he bought it. He bought it for me. He drove a truck that I had paid for.
Okay. But again, you were asking for judgments to be entered against him. Is that right?
Sure. I had asked that Lauren, the Honda Accord be put in my name. We thought at that time it was paid for so that I could insure it for her.
Okay. And you didn't tell the court that he'd made over $8,400 in full payments, did you?
No.
Had paid over $5,513 in medical bills, did you?
No.
Sports fees for the children in the amount of $5,157. Did you tell the court
No.
that?
No.
You didn't tell the court that he had paid some fees for your older daughter, even though he wasn't obligated to do so legally, for school, did you?
I were not aware of those.
So do you think, ma'am, that it's fair for Mr. Johnson to not only have paid those amounts, but to have a child support arrearage judgment in the amount of $26,000 plus? And then to have had to bring the house payments current, even though you were the one living there?
Yes.
You think that's fair?
We were trying to keep our children in the home.
When did you put the house on the market?
October 29th.
And when you were divorced in April, is that right? So 6 months it took you to put the house on the market. Why did it take you so long to put the house on the market?
I had multiple people come and look at it. It needed work, multiple things.
What work did you do to the house?
I had to have a water heater. I had to clean the carpets.
You had to do that?
Oh, I didn't have to.
You chose to?
Yes.
Okay, all right. So you were ordered in April to put the house on the market.
Mm-hmm.
Okay, the house was to be sold and the proceeds split. Is that right?
He also had filed the motion to
Set
set
aside.
aside the divorce, so I was unsure of what was going to happen.
So you lived there from April till the house sold in December.
Sold in
Like
January
it
of
closed in
2025.
January.
Uh-huh.
Okay. So if you put it on the market in October, you had a contract within 60 days. Is that right?
No, our contract closed. It was in December.
You put the house on the market in October.
Mhm.
All right. So it sat there from April to October. You're living in it. Mr. Johnson's ordered to pay the payments. You had the benefit of living there an additional 6 months before you even put the house on the market. Is that right?
I was unsure of what was going to happen in the motion to set aside.
Okay. All right. You don't disagree that your husband's name was incorrect on the court papers, do you? His middle name?
No,
What's your husband's middle name?
Bruce.
Bruce. What was in the divorce paperwork? Is it Bryce?
In a couple of places.
Okay. And you don't dispute that the address was wrong, do you?
It was right in a couple of places and wrong in a couple of.
Right in a couple of places and wrong in a couple of places. All right. And you don't dispute that postage was insufficient on at least one occasion, do you?
That's what was provided. I am unsure of. I was not there.
All right. Would you agree that there had been some problems with the name and with the address?
Yes. But I also know that he contacted me on April 27th to let me know he would come get his things on April 28th.
Well, let's talk about that.
Okay.
So, you were in court on April 3rd, right?
That's correct.
So he contacted you on April 27th.
I'm not sure who contacted who first. We had set up a date for him to come get his things.
Testify that it took about 3 weeks for him to get the final decree, right?
I
So
did.
those dates would coincide. That would be
Okay.
accurate, right?
He had 30 days to get his things. Yes.
Well, do you think that it would have been fair for him to like be out of luck if he didn't get the paperwork for 3 weeks? Do you think the 30 days should have started running when he got the paperwork, or should have it started running on April 4th? What would have been fair?
I mean, he knew on April 27th that his things were ready for him to pick up.
Well, didn't you tell him that you hadn't packed up the tools yet?
He had asked for that later. I talked to him April 27th and then April 28th. He said it was going to rain. He would come back later. I never heard from him about the later. His things sat packed up in my home, in our home for months.
Mhm. And when we were in court in October, did you tell us that you would give the code, the realtor code, so he could go get his things?
I'm not sure that we said that we would set up a time. The realtor code, he had called and asked the realtor for that as well.
Okay. Now,
his things were packed up.
Okay.
So I wanted to make sure that what was packed is what he was going, what his things he would get.
but, okay, you made sure and you made sure that he would get what you wanted him to get. Is that right?
That is, I had packed his things up, and then when we cleaned the house up and out, because we had to move out, his other things that I had and that I moved, I brought to your office.
Well, you had insisted that he not come to the house without a civil assist. Is that right?
I had asked for, yes,
I
and
mean,
so
you were pretty insistent that there be a civil assist. Is that correct?
that's correct.
Okay. And then you were going to meet him at the house with the civil assist. Is that right?
Yes.
But you didn't do that, did you? You
No.
didn't follow your own terms, did you?
I was unable to. I sent my children. I was just trying to get him his things to him.
Why didn't you notify your lawyer so she could notify me?
It was the day before.
Okay. Again, why didn't you notify
I'm
your
pretty
lawyer?
sure it was a weekend. I'm not sure. I think it was over the weekend.
So you just sent his girls.
I sent, yes.
You don't think that would be uncomfortable for your girls and for him?
No.
What
They're
if
his
they're,
children.
you wanted your girls to be in a situation where if something was missing, you want him to ask the girls where it was?
No.
And you had agreed to be there, right? In fact, you had said you would be there. I'll be there, bring a civil assist. And
Okay.
that's what he did, right?
That's correct. He was there.
Okay,
And so were my children for him to get his things on the back porch.
okay. Your children or your children?
Our children.
Okay. All right. So he left.
He
You
didn't,
heard-
he didn't even know his things were on the back
Yep.
porch. He left in anger because I wasn't there.
You heard him testify that he felt uncomfortable.
Hmm.
He felt like that it wasn't complying with what the agreement was that Ms. Roberts and I had worked out.
Okay.
All right. So ultimately, you did bring some things to the office and.
That is correct.
And
My children brought them. Our children brought them.
why didn't you bring them?
I was at work.
How many days a week do you work?
3 is full time and I can work up to 5.
Okay. All right. Now, we provided a list last week. You don't have any idea where Mr. Johnson's class ring is?
I do not.
You said it was like the tie rack.
I didn't say that. I believe he did.
What happened to the tie rack?
It was taken down and when we moved, we had to have the house cleaned out. The
Have you
house
looked-
sold.
Have you looked in the tie rack?
I do not have the tie rack. No,
What happened to the tie rack?
I am unsure. There's lots of, we had to get the house empty.
Did it get thrown away?
I'm not sure.
Okay, the DeWalt ratchet and socket set. Did you buy that?
I do not recall.
You heard Mr. Johnson testify that that was a gift. Do you deny that it was a gift to him?
I do not.
And do you not think he should get it if it was a gift to him?
Those things were there at the home. I used some of the tools. I do not know if it was a gift to him.
So you don't know, but he testified it was.
Okay.
So are you opposed to him getting the DeWalt ratchet and socket set?
No,
The drill, the DeWalt 20-volt drill. Did you buy that?
I do not recall who bought that.
Well, do you go to Lowe's, Home Depot,
Sure.
Ace Hardware?
Sure.
Do you buy tools?
I have.
Okay.
I purchased the lawnmower that's on the list.
Okay.
I purchased the weed eater that's on the list.
But you don't know about the drill.
I do not.
What about the saw cell?
The what?
Saw cell? Saw cell. Sawzall.
The DeWalt, I purchased that.
You purchased.
I did.
What does that do? What kind of tool is that? Oh.
It's just a little, when you.
I'm not as
put-
handy
Put the things off and on.
Okay. And the work light, did you purchase that?
I don't know where that, I'm not sure.
Do you have it?
I don't know.
If you do, are you opposed to Mr. Johnson getting it?
I don't know if I have that. I would not,
Well, my question is if you do, are you opposed to him getting it?
no.
And then the personalized, the Nakona personalized glove and the Nakona black leather.
I do not have any baseball, softball items in my home. I have returned everything that I had to your office.
Okay. And the cast iron skillet that was his grandmother's, I think you said you have a couple of cast irons.
They are mine. I do not know which one. I do not know what he is talking about with that.
All right. And just for clarification, you're not opposed to him getting the orange kayak and paddle.
I do have the orange kayak, his bicycle,
Okay.
and the 2
then
ladders. Yeah.
Where can he get those?
Uh,
How would you like for him to get those?
I guess he can pick them up.
Where can he pick those up from?
I don't have a way to transport them is the only issue. That's why I haven't gotten them to you yet.
Okay. Where would you like for him to pick those up from?
I don't. If I can get them to your office, can he get them from you? Okay.
Sure. Okay. All right. And then the other items on the list, which are various hand tools, a 2.5 ton jack. You opposed to him getting those things?
I don't have those things, but yeah, everything I have has been returned to him.
All right, let's talk about what you were awarded. You were awarded all the furniture in the house, right? How big was your house?
3,000 square feet.
Okay. And 26 years of marriage? You'd accumulated a lot of stuff. Would that be accurate?
Yes.
And you were awarded almost all of it. Is that right?
Yes.
How many cars were you awarded?
My car and every car for that the children had in their
4
possession.
cars? Is that right?
It probably was my car and all of their cars, so 5.
5 cars.
That's correct.
All right. Mr. Johnson was awarded 1 truck, right?
That's what Mr. Johnson had told me he wanted. The
Was
truck.
this- Okay. All right. You were awarded all the pots and pans.
That's correct.
Yes. Small appliances,
That's correct.
all linen, art, decorations, all of those things. 26 years of accumulation in a 3,000 square foot house. How much money did you receive from the house?
78,000, I believe.
78,000 and some change?
Yeah, I'm not sure the exact number.
And you've had the benefit of those proceeds since January of 2024? Is that right?
That's incorrect. That would be January.
2025,
Yeah.
sorry, I'm sorry. Okay. I can have just a moment. After the house sold, there was an escrow check that was received, right?
That's correct.
And that would have been for insurance, maybe taxes, is that right?
Yes.
All right. And again, you hadn't paid those payments, had you?
No,
All right. Where's the escrow check?
there was no check. It was direct deposited into my account.
Okay. And how much were those proceeds?
I don't remember. I would have to
You
look.
don't have any idea?
I do not.
They were over $3,000, weren't they?
I, again, would have to look.
Whatever that amount was, those were proceeds that you hadn't paid, correct?
That's correct.
All right. Do you believe Mr. Johnson should be awarded those items? Or that amount, the full of that amount, because you didn't pay it, right?
I did not pay it.
Okay. All right. And then ma'am, when you were before the court on April 3rd at the default hearing, the court didn't exactly have the full picture that day, did it?
Full picture of,
Well, the court knew what you were asking for, right?
that's correct.
Okay. But the court didn't know that Mr. Johnson had paid several thousands of dollars. In fact, 4,000 plus
He was not here that day. That's correct.
between the date of separation and the date of the hearing. Is that right? That's all, Your Honor. $94,000.
Yes, I did.
You heard that.
That's correct. Yes, that's correct. I do.
Y'all separated in 2022
That's correct.
after he was soliciting prostitution, correct?
That's
He
correct.
frequented massage parlors and picked up hookers and paid with marital money to satisfy his sexual desires. Is that correct?
I'm unsure of how far he went with that, but yes, I have proof that he did solicit a prostitute.
And I asked him on the witness stand the last time, when he was testifying in the last hearing, before we adjourned about that, and he admitted it.
Yes,
So you felt like you had a legitimate reason for him to leave the marital residence with don't you have 4 girls?
I do have 4 children and yes,
That,
yes.
okay. And did you discuss with them? I know a couple of them are here now today. Did you discuss with them their father's propensity to seek sexual fulfillment outside the marriage?
They were there in the home. Yes, 2 of them were.
Okay. And as a result of that, they understood that was going on, and he did not have any type of meaningful relationship with those kids during the time of the separation, did he? Oh, no, ma'am. She raised it. She said, oh, didn't he come and pick up the kids and carry them? And didn't he do this? That was the questions that Miss Salinas asked, and I have an opportunity to explore that. Your Honor, exhibit, thinking about the softball, she raised the issue about his $94,000 and how much that was for the children. So I think the book's open.
Well, this is basically rehashing what's already been testified to, but it arguably would come under what fact that some of the questions of what he's being given, what he's asking to be given credit for. So I'm going to overrule the objection. Just limit it to the direct issues about what he's asking credit.
After the separation, who paid for all of the kids' food and clothing?
I did.
Who paid for all of the maintenance to their vehicles, and to their gas, their school fees, going to the movies, going to the ball games, getting their hair done, buying prom dresses, applying for colleges, doing all of that? Who paid for that?
I definitely bought all the prom dresses. Now, a couple of them worked. They would pay their own gas. I paid Lauren's gas until she got a job.
Mm-hmm.
I paid their food unless they buy something themselves, but yes.
Who cooked and cleaned and maintained the house?
I did. I cut the grass at the home.
During the course of your marriage, again, we've gone back and he's talked about the embezzlement issue about 2 years into your marriage, maybe 2 to 3 years into your marriage, correct?
Correct.
And and after that, there was a check kiting scheme.
That's correct.
And at that point in time, did you and he cease having joint accounts?
We did.
During the course of that, did he always pay the mortgage?
He did.
And did you and he have a discussion at the time of your separation when his marital infidelity had come up? Was there a discussion that he was going to continue to pay the mortgage?
It was our verbal understanding between the 2 of us that we would keep the children in the home and that they would graduate in that home. And that was not able to happen.
Okay. But then after it came to the point where you finally filed for divorce some couple of years later after your separation, and that the mortgage wasn't being paid, did you see that agreement that y'all reached was not going to come to fruition? That you were going to have to sell the house?
Yes.
And in fact, did you go to court and testify that, oh, he promised to pay until my last one graduated, which was just May,
This is
correct?
That's correct.
Instead of doing that, you just went on, we're in financial straits and we need to sell the house.
That's correct.
And did you make attempts to list the house for sale?
Yes.
Within 30 days of the order being entered, when you were represented by Ms. Crabtree, did you get a motion, or did she notify you that he had retained counsel to try to set aside the default?
Yes.
And again, I know you're not familiar that default was filed. And are you familiar? Did you appear before Judge Suzanne Lockert-Mash for the final hearing?
Yes.
For the divorce? And again, I took over representation after the motion to set aside was, and did you understand the rotations of the judges so that it was hard to get back? We had to wait until she came back into court.
Yes. And when I would meet with realtors, they were unsure of the legal because of the motion to set aside, because it did say to sell the house, but they were unsure what would come out of the motion to set aside.
Between April and when we went to court in October, did you attempt to try to contact realtors to see what you could do?
Yes.
Were you waiting for the court to determine whether or not there was a valid
what we were going, yes,
order or not? When
Yes.
we came to court, we found out some things, didn't we?
Yes.
Did he file bankruptcy?
Yes.
Listed the house for the bankruptcy?
Mm-hmm.
And on the date that he brought that, did you discover, did you ever authorize him to sign your name to a secondary, you had the primary mortgage, then what we'll call the pool mortgage. I'll rephrase. I'm sorry, I'm trying to get through some foundational stuff. What type of mortgages at the time of the divorce did you have?
Just the one.
Did you just had one mortgage or did you have two? Primary mortgage and a HELOC or a pool loan?
Yes, there was a pool loan.
Okay, was that a lien against the house?
Yes, there was.
So you had two mortgages.
Mhm.
When we came to court, did you find out there was a third?
I did.
And again, what did we find out when we came to court?
That, there's a new deed of trust on our land that, had my signature forged and notarized on it.
It wasn't a good forgery, was it?
No,
Did you ever appear before his aunt? Do you remember what her name was?
her name is Misty, and no, I did not appear
Did you
before
ever
her.
call her and authorize her to notarize your signature?
No, I did not.
You've heard, we questioned him and you've heard he's invoked his Fifth Amendment privilege against self-incrimination, indicating that he did in fact forge your name.
Yes,
Was that mortgage paid off at the time of the closing to the sum of $20,125.54?
it was.
And again, you saw, and again, I apologize, I don't know the exhibit number, but we produced that in there and there was a statement wherein you weren't responsible for any of that. Is that correct?
Mhm.
And you're expecting that to be paid back to you.
Yes,
Had he not gotten that, you would have received at least half of that amount back.
that's correct.
Do you know what that amount was used for?
No, I do not.
Did you understand through his testimony that it was rolled back in and the mortgage company made him do that to keep it from going into foreclosure?
That was his statement.
So are you asking to double dip to ask for all the mortgage payments he failed to make? And the lost equity because he didn't make those payments?
Yes,
You're just asking to be paid back according to his forgery and his aunt's complicity in doing that.
yes,
And you're wanting all that money back. Is that correct?
Yes.
Not just half?
that's correct.
And again, during his testimony, did he produce, I may have missed it, but I want to ask you, did he produce anything showing what his income for 2023 and 2024 was?
He did.
What did he produce as his income for 2024? A W-2?
He did. I do believe he had W-2s.
But again, all of those bank records that he put in, and I'll just a couple of.
Yes,
May I see the exhibits with his bank records?
I mean, I believe you questioned her at length about her income.
And-
I think it's within the scope of cross-examination or redirect rather
It's
that
the biggest.
she can get into. Let's take our mid-morning recess to let you go through those records. We'll stand in recess for about 15 minutes.
Okay. I'm good right now. Well, no. Okay. That everyone. Or name?
Bruce, no way of,
He produced a 1099, I mean, a W-2, but he didn't produce any other documents or records. Is that correct?
that's correct.
And we were able, and through a subpoena that Miss Salinas subpoenaed, he produced his bank records during the period from 22 through mid 2024, I believe. Let's see. The last record being January of 2025. And those bank records indicate that he was making more money. There were more deposits than what his paycheck shows. Isn't that correct?
Yes.
Such as in August. When did he quit making? You talked about your agreement that he was going to make the payment until for that. And in you filed for divorce, I believe, in October
Of 23.
When did he quit making the payments on the mortgage? Would that have been sometime in August?
I think it's July. I had no record. I had no way of getting records from the mortgage company. So I
And
do
whose
believe it
name
was
is the mortgage solely in?
his.
Okay. So again, in August, if his bank records show that he deposited, he had credit deposits of $25,000 plus an additional check of $2,700. So he should have had more than sufficient funds to make the payments for $30,000 or $25,000. The next month, he deposited $16,000 plus an additional payment of $625, excuse me. Following month, his bank records that had been introduced as evidence showed one deposit of $3,339 and then other deposit credits of $11,441. And these records that he produced into court shows that he was making far above what his salary was with where he was working. Isn't that correct?
Yeah.
Now, this impacts you about the name when Mrs. Crabtree was representing you, that she had an error in the name. And do you recall what that was? Was it just his middle name?
Just his middle name. That's correct.
What is your ex-husband's now middle name?
Bruce.
And what did Miss Salinas put it on there?
Bryce.
So B-R-Y-C-E instead of B-R-U-C-E.
That's correct.
Does he go, what is your husband known by commonly out in the public and in business?
Troy.
So has he ever known as Bruce Johnson or Bryce Johnson?
No.
Again, that was the error in the name. It just went from Bruce to Bryce.
That's correct.
Correct? You did receive a copy, even though Miss Crabtree was your attorney at the time. Did she provide you with the motion that Miss Salinas filed on his behalf?
Yes,
And again, were you ever able to see the summons? There was some difficulty serving him initially.
yes, that's
I
correct.
think there had to be what's called in the legal terms an alias summons. The sheriff's deputy from Montgomery County tried on at least three occasions. And they could not serve him initially when the divorce was filed back from October 16th and the initial summons. An alias summons was issued in November the 16th, and he was actually served in person on the 21st.
That's correct.
And not only did you rely on the fact that a Montgomery County Sheriff's deputy filed an affidavit with this court or a return summons stating that he physically in person handed your divorce complaint to Troy Bruce Johnson.
Yeah.
And did Mr. Johnson file through his attorney a statement with this court and an affidavit signed by him or a motion signed by him stating he actually did get service on the 21st of November?
I believe it is stated in that motion.
And in that he purposely stated he didn't take any action because he thought you were supposed to bring him paperwork to sign.
That's correct.
Okay. Did you ever discuss bringing him paperwork for him to sign?
No,
So he had actual service on the 21st of November and he failed to file a responsive pleading, correct?
that's correct.
At that point in time, did you rely on your attorney to go forward on the default?
Yes,
Had you told your attorney, again, who was making the payments on the house?
yes,
Did you have any way at the default to get copies of how much was owed on it?
I had no,
Did you have intentions to sell the house?
yes,
And was that reflected in the court order and what you testified
Yeah.
to?
yes,
And again, at the conclusion of his proof, when he testified, did he put forth any proof about his inability to pay what was court ordered?
no,
He brought his W-4 or W-2 and bank records, correct?
that's correct.
Do you recall him testifying anything about how much he paid in rent, how much he paid in utilities, how much car payment, how much insurance, anything like that on the direct examination prior to him closing his proof? He did not put on any proof about what his expenses or his ability to make the payments that were set forth in the divorce decree, did he?
No,
You were married in 1998, is that correct?
yes,
And was there a period of time that you did not work outside the home?
that is correct.
And how many years was that?
I'm going to say approximately 8 or 9.
8 or 9 years. And were you a homemaker and raising 4 children at home?
Yes,
During that period of time, were your finances such where you were able to do either an IRA or Roth IRA or any other form of retirement?
no, I did not.
And how old were you? You went back and got your nursing degree, started school in 2010.
I started classes in 2005, one class here, they're just prereqs, and then nursing school 2010 and graduated 2014.
And do you recall, how old are you, ma'am, if you don't mind me
I'm
asking?
46.
You're 46.
Yes,
And so about 9 years ago, you went back into the workforce.
yes, correct.
Okay. And so you lost a significant amount of time, did you not, in retirement planning?
Yes,
Were you relying on the fact that your husband had a retirement 401k that was going to benefit you when you retired?
yes,
And you expect half of that account?
yes.
Was it discussed with you at any point in time, hey, I'm having financial difficulty, this is what's going on, I need to cash out this 401k?
No, it was not.
Okay. And again, looking at those bank records, and if you look at what was put there, he had significant income other than just his employment.
Yes,
Was during the course of y'all's marriage, did he have this, again, as he classifies it, hobby, maybe IRS says it's a business, but did he buy and sell collectibles?
he did. He
Um,
also prepared taxes for people.
okay. And he prepared taxes for people.
Mhm.
And so was that a significant income that he produced during the course of your marriage?
Yes,
In fact, during this embezzlement scheme that he undertook from his previous employer, the Comfort Group, wasn't that who it was? How much was he accused of stealing?
I do not recall.
Do you recall that he sold some of the they were collectibles and satisfied that and paid them back when he was fired?
Yes, we took a U-Haul full of collectibles to Atlanta to sell to pay back the debt.
Okay. And so again, these are some of the collectibles. He's been in and out of the house. And has he taken these collectibles
Yes,
throughout the time of your separation?
yes,
Has he ever provided accounting for those collectibles?
no,
Did you ever ask for one?
no,
So these collectibles that he sold back in sometime in 2001, 2, whenever this thing, you think they were significant value?
sure, yes,
I mean, he had Star Wars collectible sign things. You saw some of the lists
yes,
that he put values on.
yes.
And were those equal to that? And the collectibles, in your estimation, things that he does that, do they typically increase in value as opposed to decrease in value?
Yes.
And your household full of furniture that you've had for years and years and years and raised 4 children on, do you think that the value of that was equal to all the things that he took out of the house?
The furniture was old. Yeah,
I mean, do you have a solid mahogany queen,
No,
you know,
no.
dining room table that you imported
no.
from
I had the bed we
France?
had for 19 years.
It's stuff you've had for 19 years and raised 4 kids
Yeah,
on.
yeah.
And again, when he moved out, did he buy new stuff for his apartment?
He did.
And to your knowledge, did he make room and do anything to where your kids could visit over at his apartment?
It was a 1-bedroom apartment.
And Ms. Salinas asked you that did you tell the court that he was making some of these payments and doing things? In fact, when you went to get your divorce, did you know that he had committed a felony by forging your name and implicated his aunt in a felony by notarizing?
No, I was unaware of that.
Okay. So were there certain things that you didn't know that were happening when you disclosed things to the court? Is that
Yeah,
correct?
yes, the bankruptcy was one as well.
When the car got wrecked,
Yes,
Ms. Salinas was asking you about that. Did you and he talk about the car being wrecked?
we did.
Was he involved in the conversation with the payout on the?
I notified him that they had sent me the check and I had deposited it, and he said, okay. I think my words were, they sent me the remainder. His answer was okay.
Okay. And what did you do with it?
I deposited it.
Okay. Now, the escrow check, again, we introduced at the beginning of your testimony, we introduced just a summary sheet of the judgments that he had, and credits given to him was $3,960.63. Was that the insurance refund check?
Yes,
And again, you've given him credit on what your synopsis that we handed into the court of that amount. Is
that's
that right?
correct.
And not even just half that amount. You didn't get $7,000 back, did you?
No, I did not.
But again, if that escrow got paid during the year that he wasn't making the payments, is he really entitled to that? Because how that was paid in 2024 was from the proceeds of the forgery that he did. Is that correct?
Yes,
Did you pay? Well, excuse me, let me ask you this question first. Was your mortgage, in your mortgage, was the insurance escrowed into the mortgage, or did y'all write a separate check?
no, it was all into the,
So whoever was making the mortgage payment was paying the insurance payment.
that's correct.
And so you got it do you know when it went into effect? Obviously, it was sometime mid-year, but
Right.
you got a refund.
Right, that's
And the
correct.
closing was when?
January 7th.
So y'all had prepaid up and until 2025 sometime.
Correct.
And again, do you know you went to court to get the default when? April of
April 2024.
Okay. And in March of 2024, he borrowed some $20,000 plus under a forged signature. And you heard his testimony. And do you know where that money went? Did it go directly to the mortgage company?
I do not know.
No. So some portion of that logic would say would have been paying the escrow.
Possibly, yes.
Now, again, he had 0 days with these. Did he ever spend the night other than what he testified? I think he said 3 occasions. I think he said there was he came to your house.
Right.
And not just 3 days, 3.
I believe there was a question of her about credit on the child support calculator, wasn't it, for days? I don't think that question was asked.
Well, he, on his testimony, it was asked, and on that, and she
Well,
has
let's just clarify. Child support guidelines make it very clear that a day to be given credit for includes a 24-hour period. If that was not the case, he doesn't get credit, as unfair as that seems, because I cannot circumvent or preempt the child support guidelines. He is entitled to a credit for a day when he has the children for a 24-hour period. That is the definition that's given to us under the law, and I don't always agree with that and have argued against it as a lawyer, but it is the law. So we're really kind of getting academic about it. If he didn't have 24 hours period with the children, then, or an overnight, with 24 hours, and we don't have a day to give him credit for.
Do you believe that the testimony that you offered in the proposed division of assets was fair and equitable given the totality of the circumstances of your separation, affording who was paying what, and the totality of the facts of your divorce?
Yes.
When you discussed it with Ms. Salinas, were you explained about what division of assets was based on?
I'm not sure what you're asking me.
Well, when you filed for divorce, did you understand that the judge had to make a fair and equitable division of assets? You filed for divorce, but you did not, you were working, you did not ask for an alimony payment.
I did not.
And then even though there was fault decided in your final decree, in looking at the final decree, I don't recall that you asked for attorney's fees. You asked for attorney's fees in your complaint, but you did not ask for them at the final hearing.
That's correct.
You simply asked for your health insurance, when your health insurance was canceled, the payment of those bills.
That's correct.
You testified to that on a direct examination.
Yes.
On how that came into fruition.
Yes.
And were those reasonable and necessary expenses?
Yes.
To your knowledge, was there ever a discussion between you and him notifying you that he canceled your insurance?
I had to call him. I tried to get prescriptions filled, and that's when I discovered I had no insurance.
And according to the breakdown that he offered in his exhibits that he was submitted into court, it didn't cost you any more. He had employee family, correct?
That's correct, and he's had it for years.
Whether the family was 4, the girls, or 5, the children and you, there was no savings, correct?
That's correct.
And again, to this date, have you received, pursuant to state law, notification from him or his attorney that your insurance was terminated?
No.
And again, albeit you weren't going through a divorce at the time.
Right.
Did you ever get notification from Cobra? Are you familiar with whether or not that, or did have any conversation with him when your insurance was canceled? Were you offered?
No.
And retroactive support, again, he filed a bankruptcy petition.
Where we have the mics that are going on our sound system, so let's see if we can.
Did you receive correspondence from a Brian Lee Hill, or an attorney, about the filing of the bankruptcy?
It would appear to be the case.
Well, Your Honor,
And if he declared bankruptcy, it was dismissed at a later date.
He filed it on the 28th before we went to court on the 30th.
And then it was dismissed.
And then it was dismissed not until December.
Well, but the question, I guess, would become his filing for bankruptcy, other than the issue of credibility and going to the issue of his financial wherewithal. Is there any relevance to the fact if it didn't affect the loans or
Judicial admission,
pardon?
the judicial admission,
Still in the home. We did not.
I'm sorry, yeah, the judicial admission of what I was getting to the point of the judicial admission of he put what his child support obligation was. And it was not a disputed claim. It was just an admission on his part.
Well, isn't that more properly a question for him rather than her? I mean,
Well,
you can recall.
he can recall him. That's it.
I think. I'm going to sustain your objection as to it being outside the scope of read or write. I am going to allow Ms. Roberts to recall your client for any purpose that she has, and then we'll deal with any objection. I don't know why that's making that noise.
I don't, I will back up, just set up the answers.
The only reason, Your Honor, if I could, in also the secondary, what I was questioning her on the child support at that point in time, I was getting to the judicial admission. The only other thing that I wanted to put the bankruptcy in is that she received notification of an automatic stay. And that is directly on point with what Ms. Salinas asked about why didn't you sell the house? And why didn't it go forward? So
It would appear
again,
to be relevant on that one limited issue.
right. So again, you received from Brian Hill, who we found later, it was your ex-husband's bankruptcy attorney. Is that correct?
That's correct.
And did you receive notification specifically putting you under a federal court order of what we call an automatic stay?
Yes.
And did you understand that you could take any action in selling any property that was listed in that bankruptcy?
Right.
And was the house listed in the bankruptcy?
It was.
We received this, there's not I'm sorry, Ms. Salinas, I'm looking, 10/28 of 2024 is what it says on the date that was filed. I don't have the envelope when it was forwarded. Let me get over to the certificate of service. I don't know that there's one on here. It's been a day since I practiced bankruptcy. The order of dismissal was March 6th of 2024, Henry Hildebrand being the trustee. 25, that's when it was finally dismissed. But when she got the notification, there's not a certificate of service. It just shows that he signed it on October 28th of 2024, but there's not a certificate, and I'm sorry we didn't keep the envelope. So you received this notification. We knew about it when we came to court on the 30th, correct?
That's correct.
Ms. Salinas asked you about how much money you got from the court. The court order said that the proceeds were to be divided, the equity was to be divided equally. Is that correct?
That's correct.
So did you receive the exact same amount that's been deposited with this court pursuant to the October order that's being held, some 78,000 and some change?
That's correct.
Did you have to find a new place to live?
I did.
And was your child still in school
She
at the
was.
time of the sale? So in January of her senior year, you had to relocate.
Correct.
Who had the responsibility of getting the house clean and ready to sell?
He.
At the point, when did you put all of his things outside for him to retrieve?
It was the 7th, December 7th, I do believe he was supposed to come. He came with a cop and the children were there.
But prior in April, you had made arrangements, correct?
Yes, and he did not come and said it was going to rain.
Okay.
I also let him know that day that I wasn't putting his things outside until he let me know so that nothing got damaged. So I didn't hear from him again until court.
Okay. But on April 28th,
he did not.
After he received the final decree, did he contact you and request to be able to come get his things?
No,
There was
the
a-
27th, he called the 28th and said it was going to rain. So he knew he needed to get his things.
Okay.
He had already arranged to pick them up.
So y'all had an arrangement and then he refused to comply.
He said it was going to rain. He would wait.
And then did he ever make another attempt to come
Not
get him
until court proceedings.
and it wasn't until after we were here in October?
That's correct.
And did you try to cooperate and have those things available?
Yes.
And did you think that the division that you made, with you getting your 19-year-old furniture and him getting all of his collectibles and his mountain bikes and his canoes and all of those things that was for him and benefited him, did you make any dispute about him getting those?
No.
And you think that that was a fair and equitable division?
Yes.
You asking the court pursuant to what we submitted into court, are you asking for 1/2 of the total retirement in the amount of $28,076.36? And that does not include any interest that would have accumulated. That was what he got in 1/2 of what he received.
That's correct.
Or, excuse me, 1/2 of the amount of the balance of the account. Is
That's
that
correct. That's correct.
Your medical expenses, and again, did you produce and have the exact amount of $4,422.38?
Yes,
And he was ordered to pay those.
he was.
He did not.
No.
Did they go into collections?
Yes. No, I set up payments on them.
Okay, and you had to pay those, is
I
that
did.
correct?
I
It
did.
didn't damage your credit. You could have let them go into collections and sued for damage to your credit, but you mitigated your damages, did you not?
Yeah.
And again, retroactive support, $26,016.
Robert, just so that I can follow along, are you referring to the exhibit that you made of that?
Yes, Your Honor.
Do you happen to recall what the number?
No, Your Honor.
With it, I just have to, these are the exhibits, so I have to check.
And it would have been probably 23 or 24, I believe. I think I only produced a few exhibits, and I apologize. I didn't bring my notebook up with my list of exhibits.
Go ahead, I'll find it in a second.
So again, the retroactive support, $26,016. Did you previously work at the child support receiving the District Attorney General's Office, Child Support Division?
I did.
And did you know, Miss April Miller?
I did.
And with her assistance, did she run the guidelines for you?
She did.
And did you produce those and give those to Miss Crabtree at the time of the hearing?
Yes.
And were those produced with the income that you had knowledge of?
Yes, that's correct.
And calculated that accordingly to the tune of $26,016.
That's correct.
Now, you did not have any information about his insurance, correct?
That's correct.
And he had not had any days with the children other than on occasion when he carried your daughter twice to an overnight ball and one time when you were gone out of town.
That's correct.
And you put 0 days.
That's correct.
Again, earlier I asked you, he got served with the complaint for divorce.
Mhm.
And the complaint for divorce clearly stated that you were asking for child support. At any point in time from the time that he was served in November until the final hearing in April, did he produce any documentation as to the cost of his health insurance?
No.
He had the ability to do that, correct?
Yes.
Okay. And during that period of time is when did he also, and I'll recall him on that, sorry. And you think the child support calculations are correct and you're retroactive from the date of the separation of 26,016 is appropriate?
That's correct.
You don't think that there's any issue of manifest injustice for you getting that money?
I am willing to give him the credit for those direct payments.
Again, I'm going to get to that. But
Okay.
these are the judgments that were done. Is that correct?
Yes, yes.
And so then he didn't pay child support.
No.
You could have filed a contempt petition against him and asked that he be jailed after the divorce was granted. And even after the October hearing, when he dismissed the motion to set aside and your divorce was granted. There's been no request for a modification. He didn't pay any child support. He had a payment due in November.
He paid right when we went to court, right around the court date of October. And then I got another payment around the court date in April, and that's the only child support.
The only payment you've received is through the child support receiving agency.
That's correct.
And they produced documents where he made 3 payments, one on November 31st and 2 on November 11th. Is that correct?
There were
There were three
three,
payments that right before we came
yes,
to court.
yes,
And when you received them on October 31st and then two payments on November 11th.
yes, that's correct. That's correct.
Then right before we came to court this time in May,
Yes.
he paid another three payments.
It was 2325, I think.
But that would
Yes.
constitute three
Yes,
child support
that's correct.
payments.
It was one, yes,
Lump sum total. And you give him credit for that on our worksheet and so reducing the amount that he paid instead of the 26 that he owed you in retroactive support, or excuse me, in current support, you're giving him credit on the current support. So he owes you current support of $6,975. Is that correct?
yes,
And then the $20,125.54 for the criminal act that he undertook.
that's
Is
correct.
that right? Now you produced, and I didn't give.
Ms. Roberts, let me interrupt you and make sure I'm clear on this. This 20,125.54 is the amount secured by the falsification of a second mortgage, third mortgage,
That was the amount that was paid out at closing.
to pay off the third mortgage.
Yes, sir.
Right. And you're saying that she should be awarded the entire
Because
$20,000 rather
because
than,
the proof that was submitted, he forged her signature
understand that.
with the statement saying she's not responsible for any of this. If you look at the closing documents.
Look at it.
Mhm. It's not just half, is because had she signed it, she wasn't responsible for any of it. And what we're not doing is double dipping because we didn't come back and ask us, as down on the bottom, we're not asking for any of the missed financial obligations where he was supposed to pay $2,257.39 a month in mortgage payments and $550 on the HELOC. We're not trying to go back and double dip on those and say the equity was reduced because you didn't make those payments.
Right.
Now, you did go back and again, you produced a sheet that I didn't give to them, but you totaled out the payments of monies that he paid for volleyball fees for Lauren, soccer and backpack fees, cross country for Meg, when he paid some grocery bills and different things like that. And you're willing to give him credit for $4,157.50,
Yes,
which is above and beyond what the normal payments where
Yeah.
he benefited your children, basically.
yes,
And you're willing to give him that credit. And then then also you kept the entirety of the refund check for the escrow.
I
for
did.
And that was for insurance. And you were giving him credit for $3,960.63.
Yes,
But you believe that you're entitled to both the 58,000, the 6,900, and the 20,000 minus those two payments, those credits. Is
yes,
that correct?
that's the half of it.
No, 58,000 is one half of the Vanguard, correct?
No, 26 is.
Well, one half of the Vanguard, your medical expenses and the retroactive support is the $58,114.74.
Okay, yes,
Current child support from the time that the divorce was granted up and until May of 2025, when your daughter graduated high school,
yes,
is $6,975. He would have owed $11,625. You gave him credit
Yes.
for the 6 payments he made. So the total he owes you for current child support, the new arrearage, if you would, $6,975, correct?
correct.
And then the total amount of the post-judgment, the post-divorce debt of $20,125.54.
Correct.
That totals $85,615.28. Credit for the 4157 and the 39.
Yes,
There's $78,000 on deposit. So effectively, you're looking to take the majority of that. Is that correct?
yes,
And you believe that's fair enough?
yes,
And you've incurred attorney's fees
yes.
to bring this matter to court, and how much attorney's fees have you paid?
I paid $5,000 already.
Thank you, ma'am.
Mhm.
You testified, sounded like your husband solicited numerous prostitutes. Isn't it true that he never once met up with you?
I know that they had plans and it's in writing. I do not know if he went. I do have the text that he Had a plan.
And had there actually maybe been a massage that had been scheduled?
He admitted to what he did. He said he did it. He said that it was a massage parlor that he contacted, but yeah, I mean, I have the apology that he said he went down a rabbit hole he should have never done. He apologized to us, the way he treated us, the way he talked to us.
Remorseful.
He was
And
and very angry. He left that night. The children and I were in fear of our lives.
there was never any evidence that he met and solicited with numerous prostitutes, was there?
Numerous, no, but I do know of one.
No.
And he also said this was his second time in some of the texts, so I'm not sure what he meant by that.
Okay. All right. And you were asked about Mr. Johnson's income from collectibles and those types of things. You hated him trading and having a collectible, kind of a passion for collectibles, didn't you?
Caused lots of lies and deceit, yes.
Well, and it cost a lot of money, right?
I am unsure. He kept all those things a secret from me most of the time.
And isn't it true that he lost more money with collectibles and those types of things than he made money?
No, I would say no.
No. All right. The bank records that your attorney referred to, though, showing money coming in, there were no questions asked about money going out for those collectibles, were there?
No, there were no questions of that.
And you know from your years of being married to Mr. Johnson that there was plenty of money going out to buy new collectibles and to sustain that business. Is that true?
Again, we did not have joint accounts, but I do know he would do multiple PayPal, this, or multiple avenues of receiving money. So
And he would buy and sell, right?
yes, he did.
So in order to have a clear idea of what was being made, you'd have to know what was being paid as well, right? Is that right?
Yes.
And isn't it true that you and he had been trying to reach an agreement regarding terms of the divorce?
I don't, no.
No, you and he never talked about terms.
I mean, I would say, you know, he did tell me he wanted the truck. He wanted the kids to stay in the home. He agreed with that.
Do you think it would be unreasonable for him to state that he was anticipating that you were going to be sending him papers, whatever those papers might be?
No.
No.
He also at one time said he would drive Uber before I had to move the children.
And are you asking the court to order support that should have been paid from the date the divorce was entered to now?
Yes.
Have you filed anything with the court asking for that?
The support of,
Since the divorce was final in April to now, are you asking the court to award that even though you've never filed any petition?
current child support was ordered.
I understand, but there's been no new filing in regards to support from the date the divorce was final, has there? Well, I just want to be clear that you're, okay. But that's part, I want to make sure that I understand. That's part of what you're asking for in your calculation. Is that right?
Mhm.
Okay.
You wanted to withdraw that so she can file a contempt, or you want to let it just come out of it?
Clarification, Your Honor.
And as often is the case, the response is that we're cutting you a break by not doing that. If you don't like that, then we'll do the other, which is much more severe. So
No, I understand, Your Honor.
this is, I just point that out for the general clarification of your client that you might want to talk to him about, which is better in his interest.
I will, Your Honor. And then one other thing, if I may approach them.
Complaint for absolute divorce. Yeah. Mhm.
She asked for what?
An award of retroactive support, child support.
Um, it just says adopt the parenting plan. I do believe it was on the parenting plan. The Yeah, I do believe that 26, is that, no, I do believe it's on the parenting plan. No, it just says to adopt the proposed parenting plan, which that's included in.
Marked exhibit.
25.
And then finally, you don't dispute that the address and, the addresses and the names were inconsistent in the original filings with the court.
I do not.
That's all you're.
Roberts. This is the complaint, the last exhibit.
You read what number seven says,
For general relief,
and also after we did, stipulate number 25 that was served on your then husband. Can you read the top? Notice, what does that say?
notice of statutory injunction pursuant to TCA 364106D.
And again, if you could, if I can, again, for the record, read under Tennessee Code annotated section 36106 subsection D, it reflects that upon filing this petition for legal separation or upon and upon personal service of plaintiff summons on the respondent and or upon waiver of acceptance, if this restraining order goes into effect. An injunction restraining and joining both parties from transferring, assigning, borrowing against, concealing, or in any way dissipating or disposing without the consent of the other party or an order of the court of any marital property. Nothing herein is intended to preclude either party from seeking relief, expending money you're restrained from, do you know whether your husband sold any assets during time of separation and continued before testimony? He sold and bought stuff on eBay, sold things on eBay with a marital asset.
Yes,
Did you see the contempt sanction against that?
no,
Did you want to get this over with?
yes,
All right. He's restrained from, borrowing against any marital asset, any marital property. Did he borrow against marital property?
Yes.
Did he have your consent?
No.
Thank you.
Thank you, ma'am. You may step down. You may call your next witness.
Yeah, if I could call briefly, Mr.
Mr. Johnson, if you'll come back to the stand, please. Stand and raise your right hand and be placed under oath.
Yes.
Mr. Johnson, regardless of whether your middle name being Bruce rather than Bryce, you were served with a complaint for divorce. Is that correct?
Yes, ma'am.
You actually got fiscal service, correct?
Yes, ma'am.
Sheriff's Department came out and handed it to you.
Yes, ma'am.
It was a legible document that you were handed, correct?
Yes, ma'am.
And how far did you go in school, sir? You have a college degree
Yes, ma'am.
and you profess to be an actuarial. You know,
I'm actually in finance, but actuary kind of is what I do in my job.
but you're not an actuarial. You don't have,
I'm not a degree or certified actuary.
you're not certified.
No, I measure risk at the
Okay,
insurance.
even though you testify, that's what your job is, but when you said you were an actuarial, that was a misstatement, correct?
Yes.
And you did,
Degree. I'm not a degreed
okay,
actuary.
because again, I was Googling while you were previously, and you have to have a certification and a license to do that.
Yes.
And you don't have that.
I do not. No, I'm
And did I misunderstand your testimony? Did you testify that you in fact were an actuarial?
I don't know if I said I was actually an actuary, but I am not.
Okay, and again,
I mitigate risk at the workers' comp insurance level at the state.
I understand that, sir, and I'm just simply calling you back to the witness stand to correct what I had written down that you
No, I
testified
am not an actuary.
as an actuarial.
No, I am not
I
an
had
actuary.
questioned you about perjury before, and you understand if you did not correct a misstatement, you could be charged with aggravated perjury.
Okay.
And I'm giving you an opportunity to
I
correct
answered.
your testimony.
I am not an actuary.
Okay. And in fact, you filed bankruptcy 2 days before we were scheduled to be in court.
Yes, ma'am.
And then you were served with a complaint and you understood it was a legible complaint. The summons was legible to you, the complaint for divorce.
You're talking about before bankruptcy now?
Before
We're
bankruptcy.
rolling back? Okay, yes,
Okay.
ma'am.
And did you read it?
Yes, ma'am.
Okay, so you understood you had 30 days from the date that you got it to file a response with the court,
Yes.
correct? And you elected, being a college educated individual who prepares people's taxes, who works in the finance industry, that mitigates risk, as your testimony was, as you elected and chose and made a informed decision not to respond to the divorce complaint, didn't you?
Well, I was waiting on what Stephanie was going to do.
Waiting on what she was going to do.
Yes, ma'am.
At what point in time did she tell you she was going to bring you documents? And when did she tell you specifically, sir, don't worry about the 30 days?
Well, she did not never tell me about the 30 days.
And you never reached out to Miss Crabtree's office, did you?
I did, but she told me she could not give me legal advice.
Okay, so you did reach out and she told you that she couldn't give you legal advice.
Yes, ma'am.
So you were informed by adverse counsel to you that she couldn't give you legal advice, and did she go on and tell you needed to speak to an attorney if
No.
you needed legal advice?
She did not tell me that. She
Okay.
said she couldn't do it for me.
Okay. Did she tell you at any point in time that don't worry about the 30 days?
Miss Crabtree?
Uh-huh.
No, ma'am.
So neither your then wife, now ex-wife, or Miss Crabtree or any other individual told you to disregard the legal documents that you were handed, did they?
No.
And you made an informed decision not to respond.
To wait, yes, ma'am.
Okay. And then you got the copy of the paperwork, albeit later in April, after the hearing was at the 1st of April. You got the paper sometime,
Of the final decree?
final decree.
Yeah, that's what I received.
Like on maybe April 27th, your ex-wife recalled that you contacted her on the 27th to come pick up your stuff.
Yes, ma'am. I received that because the post lady said didn't have any postage on it. And I happened to be standing at the mailbox bank when she handed it to me, or I wouldn't have even gotten that.
But you got it.
I did.
Okay. and you opened it up
Mhm.
and you read it.
Mhm.
And you contacted Miss Stephanie Johnson
Did.
and saying, hey, I need to come get my stuff.
Mhm.
Because that's what was spelled out in the decree
Yes, within 10 days.
within 10 days. And so you were like, hey, I just got it. I need to come get it.
Mhm.
And so she said, fine, correct?
Yes.
And then you called her back and said, never mind, it's going to rain.
Yes, ma'am, because I had a lot of paper stuff that I didn't want to haul, and I had something to haul it over.
And then you never came and asked for it again or made any attempt to get it until after the October.
Well, once I filed the motion to set aside, I didn't want to mess anything up. I didn't want to step on anybody's toes or anything like that. So I just basically just backed off.
At that point in time, after you talked with an attorney,
Yes, yes.
then that's when you said, look, I'm not going to force the issue because I'm asking this to be set aside.
Yes, ma'am.
And you understand that your attorney asked your wife, well, the court order said to sell the house, the property, and you got to sit in the house from April until it got listed.
Mhm.
Could she not have the same opinion that you had is, hey, there's a motion to set aside, don't know what's happening with it. So I can't sell the house because you're asking to be set aside and relieved of that obligation. Isn't that correct?
Yes, ma'am. But
So you want to hold her to a higher standard than you held yourself?
I just wanted to pay for the house that she was living in.
Okay. But you had all this income coming in.
No, ma'am, I collected money and went out. It was not income. Income's different from collections.
Well, again,
It's a cash-based business. It's not accrual based.
okay, so you're a cash-based business now, and you understand you're under oath.
That's what it is.
You understand that you have just said, we spent countless minutes the last time we were here where you said, no, it's a hobby, and now you've admitted it's a business. So can you pick a horse and ride it?
Well, cash-based business, cash-based hobby, it's cash-based, it's accounting. How about that?
You said you had a cash-based business, correct?
I use cash basis to account for that stuff.
Okay. Well, you use the word
But I
business,
have-
not me.
I have filed it as a business for 2 years. Yes,
Okay. And did you direct, and you got served with a complaint, and you understand that you were specifically ordered not to encumber any marital assets. I had your wife read the provision.
Yes, ma'am. If you're talking about my collectibles, they would not be considered assets. They would
No,
be
I'm
considered-
talking about the fact that you forged your wife's name.
I never agreed. I never said I did that.
You never said you did that, but you never said you didn't.
Exactly.
Okay. You've invoked your Fifth Amendment privilege because it would incriminate you.
Yes, and I've been accused of it several times today.
Okay. So are you denying that you did that?
I'm not saying one way or another. I'm
Okay.
invoking my Fifth.
Did you have a conversation with your aunt?
My aunt Wynn.
Well, when you borrowed the $20,000.
Did I have a conversation with her?
Mhm.
I went to her house.
How, you went to her house. Did Stephanie ever go to her house,
No.
house with you? Did you ever produce paperwork to Stephanie showing that you were getting an additional $20,000?
No, ma'am. And again, was not getting additional money. It was a partial claim that was taking the back payments and putting them to the back of the loan. There was never a cash check, money in my account.
You never discussed that with her, did you?
No, ma'am, I didn't, because I knew she wouldn't sign it.
But you went through and you got that money.
In order to keep them in the house, I did.
Okay. And you never saw her sign that document?
No, ma'am.
And your aunt never saw her sign that document?
No, ma'am.
And when you appeared at your aunt's house to get it notarized, Stephanie's name was already on it?
No, ma'am.
It was?
No.
Who signed it?
I'm not going to say. I'm not going to say one way or another. I'm invoking my Fifth Amendment.
But it wasn't her?
It was not her.
And 2 days before we came to court on your motion to set aside, you filed a federal bankruptcy petition.
Yes, ma'am.
And you had copies of the amounts that Miss Stephanie said you owed her.
Yes, ma'am. I turned my divorce decree into my attorney.
Okay. Did you disclose the third mortgage on this bankruptcy?
Yes, ma'am.
Sure.
They run my credit.
Who ran your credit?
Mr. Hill.
Okay. I didn't ask what Mr. Gill did.
You just asked me who ran my credit.
No, well, I asked you, did you disclose the third mortgage that you got? And you said,
Mr. Hill.
they ran my credit.
Yes,
And I
ma'am.
said, I didn't ask you that. Did you disclose to Mr. Hill that there was a primary mortgage there was a HELOC, and then you got a second.
I think at the time,
You didn't, did you?
no, this is 24. Are we talking about 24 or 23?
You filed bankruptcy
In 24.
on October 28th of 2024.
Right, okay, yes, ma'am. It should have been
In March of 2024, 1 month before before the divorce went final,
Right, okay, yes.
you acquired an additional mortgage lien against the real marital property
Yes.
of some $20,000+.
Yes, and that
correct?
was included in my bankruptcy.
Okay. And who was that with?
Lakeview Mortgage Services, or Loan Care, maybe it was.
Loan Care LLC, secured for $4,463, secured for $14,207, and secured loan at $367, $352. You have 3 listed to Loan Care LLC.
That must have been how they broke it down for him then.
What was the HELOC on? Who was it to?
Lafayette Federal Credit Union.
Lafayette,
That was the swimming
to
pool.
the tune of $69,132.
That was the swimming pool.
And again, Salinas. You understand, federal bankruptcy court submitted it to the court under penalty of perjury, stating that it was correct.
I never went to a federal court
You filed the bankruptcy.
with my attorney.
All of the debts that you owe, correct?
They were the ones that put it all together. Yes, ma'am, I guess I did sign it.
May I approach?
Yes, ma'am, I am, because it was in my divorce decree and I sent it to him. I know exactly what it is.
Asking to change something in relation to the court. $26,016, because you have to have support on. You swore that you owe that.
What?
Now you're saying you don't.
I did, because it was in my divorce decree. I had to put it. Mhm.
We're under code of bankruptcy petition, and you owe those two, but now you're asking to get out and get it. And he knew you owed these because they were in the deferred.
Excuse me.
But you're not down here to where it says Stephen Johnson. Not put you, now you owe to Stephen Johnson. There were 3 obligations you owe to Stephen Johnson. One was to work for 1/2 of the 401k. One was for permanent bill, and the third was for retroactive support, correct?
Yes.
But then when you list the Stephanie Johnson in your bankruptcy petition, you said it's an unsecured debt, and you put NA, which is not applicable, so you're not scheduled, you didn't say you owe her.
Okay.
So you're saying that you didn't swear to package of the support, you didn't have public either, or degree, but you didn't put the 2 other names. We're only got. Did you get fraud with bankruptcy court?
Pardon me?
Did you commit fraud with the bankruptcy court?
No, ma'am. I don't
Because
think
you
so.
knew you owed that money under the final decree.
I left it up. I didn't, my attorney did that. I didn't go backwards and check every single number with it.
So you didn't check to make sure it was right?
I just thought that they would do it right.
Okay.
I'm not a bankruptcy attorney.
And your wife isn't a divorce attorney either, is she?
I'm not sure how that's relevant.
Well, your attorney has asked her, did you go into court and did you testify to this and you testified that? She testified, I relied on my attorney.
Okay, but she
You're
asked,
on your attorney, right?
right. But she was asked directly.
And your testimony was, is that the reason you listed this unsecured, this retroactive support was not that you thought you really owed it,
It was in the decree.
but then what you owed to the decree to Stephanie Johnson, you didn't list. Just a little inconsistency there, sir, don't you think?
You say so?
And you understood that by filing this bankruptcy, your attorney, an automatic stay went into effect.
Yes, ma'am.
You understood you stopped the sale of the house.
Well, at that time, I didn't know the house was listed.
You didn't know the house was listed in October?
I didn't know the house was listed until I came to court on October the 28th or October the 30th.
October the 30th, 2
30th.
days after you filed
I
bankruptcy.
didn't know the house was listed. I didn't even know they had moved out.
But you knew you had a court date coming up when you filed.
On the 28th?
Well,
Yeah.
you filed on the 2 days before we went.
Yes, ma'am, because they were fixing to foreclose on.
And that was an attempt, and you were explained that that would stop these proceedings in state court.
Stop which proceedings?
These proceedings, we couldn't go forward on the 30th because you filed bankruptcy and an automatic stay went into effect.
I filed.
And the judge, Judge Lockett Mash, myself, your attorney, all were under, and your wife, all were notified, and we were under an automatic stay. Will you explain that, sir?
I did that to keep the house from being foreclosed on.
Because you weren't making the payments.
I had gotten behind on the payments.
And you could borrow the 20,000, try to catch it up
Back in March.
back in March, and then you still had made no payments.
Well, I made a couple. I made one in July, and I made 2 or 3 payments after that.
Okay.
But then again, I'm also paying for my house.
And you didn't file to dismiss your case until December 6th
When the
of
house,
2024.
when they said they had a contract on the house, and that would be when Bronner McCoy said it would be better, that if I'd got that dismissed, I went ahead and told him, hey, I'm not going to go forward with it.
And you didn't lift a hand to go get that house ready for sale, cleaning it up, moving stuff out.
I was not allowed in the house
Well, again, the one time you were allowed to go there, you decided not to pick up your stuff because you didn't want to,
because she wasn't there. It wasn't, we
your
were,
stuff was there.
it was, but it wasn't on the agreement that we agreed to.
Well, again, nothing further, Your Honor.
Mr. Johnson, I'm going to show you a receipt on a.
A house payment receipt from First Financial Bank where I paid the loan care,
And when was that dated?
July 30th, 2024.
Were you attempting to make payments?
I was doing the best I could. Nobody was helping me with my rent, my electric bill, my water bill, my utilities. I was doing my own stuff and then doing theirs also.
And were you unable to make the payments each and every month?
Yes, once my inventory from my sports cards was depleted, I didn't have any other way to go get money.
And when you filed the bankruptcy petition, was it solely to avoid the house going into foreclosure?
It was just to keep the house from going into foreclosure, yes.
And you filed the bankruptcy proceeding when? Was it 2 days prior to
I
the
think it was the
October?
28th is when I got the final pages, but I had talked to him, Mr. Hill and Vera, maybe a month before. Because I knew that the house was, I didn't know the house was going up for sale. So I was like, we're going to lose this house if I don't do something. And that was at that time, the only way I knew to be able to keep the house, because I could sell it through the plan.
And if the house, so you filed a chapter 13, is that right?
Yes, ma'am, it was 100% too.
All right, so the house could have been sold if the bankruptcy had continued even?
Yes, ma'am, the court would have just had to approve it.
Okay, all right. But you dismissed the bankruptcy proceeding some 6 weeks after that, is that right?
Yes, ma'am. When I heard that the house had a contract on it, and Bronner told me it would be better if we got the bankruptcy dismissed to get the house sold, and we wouldn't have to go through the federal courts for them to approve I think what I understood, they had to approve the real estate agent, then they had to approve the contract, and then they had to approve the sale, and then they had to approve the disbursement of funds. Well, that was going to be a mess according to Bronner. So I said, well, I'll just dismiss it. If the house is going to sell, it's the only reason I'm here.
And the house did sell?
Yes, ma'am.
Okay, but when you filed, you said you didn't even know that the house had been listed, is that right?
No, ma'am, I didn't know it had been listed. I didn't even know they had moved out.
Okay, all right. But up until October, it had not been listed, is that right?
I'm assuming so. I didn't think it had been listed.
All right, Your Honor, may I have, Johnson, what is your address?
My
Your
current
address?
200 Southampton Place, apartment 1-105, Clarksville, Tennessee, 37040.
Apartment 1-05.
Yes, ma'am.
James Street, Portsmouth. And what address? What apartment?
Apartment 1105
One.
-10. Yes, ma'am, because we have 20 buildings in our unit, each one of them, building 1, building 2. So that apparently went to building 11. Yes, so it's not that we, it is incorrect.
And then, sir? Yeah. The address.
Yes, ma'am. 1-105. I actually received a call from Stephanie.
That's already been made it's part of the court file. That's the one. That was my point, is this part of the court file?
In the next one, it is what it says, it's just about address correct. Not is on the back of the thing, which or. So that I understand.
Here's the court file, so the back, I've already turned it to the back of that summons, shows the service.
Okay. Right.
Yeah.
Yeah.
Yes, ma'am. Yes, ma'am. As a matter of fact, Stephanie had called me late in October and said she had filed for divorce and they had been trying to serve me several times. And I'm like, I'm here. I work from home. I'm here all day. I never go anywhere. Just knock on my door. And I never received that knock. When I told her that the address was 1-105, because that happens a lot. They run all those numbers together and then building 11 gets a lot of my stuff. As soon as I said it's 1-105, then I got the papers.
Then you were served.
Yes, ma'am.
All right. And so you were served on November 21st of 23. And you were asked to read, or Ms. Roberts read into the record, the automatic injunction. Let me ask you, did you drop your wife from your health insurance prior to being served with the divorce complaint?
Yes, ma'am.
Okay. And did you withdraw your 401k money some 18 months prior to the divorce being filed?
Yes, ma'am, in order to make sure the bills got paid.
All right. Then I want to move to the
January 3rd, 2024.
yeah.
I never got that. Okay. Right, I didn't know.
You finally did, in fact.
Yes, ma'am. Yes, ma'am, we have a bank of mailboxes that our mail person comes into and delivers to everybody in West Palm. Yes, ma'am. Apartment 1105. There's no dash. It's apartment 1105. There is no dash after the one, so I wouldn't have received that even if it did have proper postage on it. Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am.
Want them marked as a collective exhibit? You want them
And
separate?
they can be collective. And sir, I believe you said that you received the divorce decree some 3 weeks after it had been entered. Is that right?
Yes, ma'am, because when I got it, I panicked.
Your Honor, that's all I have.
When you were served with this summons, you said you read it. I think you testified to that earlier. Is that right?
Yes, sir.
And did you read this part? It says, to the above named defendant, you are summoned to appear and defend a civil action, parentheses, divorce, filed against you in Chancery Court, Cheatham County, Tennessee. And your defense must be made within 30 days from the date this summons is served upon you. You are further directed to file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. In case of your failure to defend this action by the above date, the judgment by default can be rendered against you for the relief demanded in the complaint. Did you read that part?
Yes, sir. I read the whole thing.
So you knew that when you didn't file that answer within 30 days, that a default judgment could be rendered against you.
I knew it could be. At that time, I had gone, when I figured out I wasn't going to get, I thought I was going to get papers kind of telling me what to do, but I never did.
Why did you have that impression?
Because I've never done this before. I didn't know what was going on. And then I talked to Holman and Holman, and actually had a consult with them. And they said that I probably had missed the window to file the complaint, but that I needed to wait and see what I got.
Who told you that?
Holman. They're a men's attorney out of Nashville.
Holman and Holman?
Holman and Holman.
That's a law firm?
Yes.
And they told you after you've been served with a complaint to just wait and see what else you got in the mail?
They said that I would receive something in the mail. And when I got that, to use
Not
that.
exactly a stellar recommendation for a law firm to advise someone who's been served with a complaint to just sit back and do nothing and wait for something else to come in the mail.
I agree.
Because what happened is that you then got a motion for default filed against you as the summons clearly indicated it could. And then the default, you're saying you did not get the default judgment motion.
Yes, sir. I didn't know when that court date was.
All right. Anything further for this witness?
Yeah, I think that's an HOLL. Cordell and Cordell. Cordell and Cordell. I'm sorry. Yes. After I got the notice. Yes.
So if you in your experience of helping people prepare their taxes, if one of them called you up and said, hey, I got a letter here from the IRS that says I need to call them, what should I do? Would you ever tell them, hey, just sit back and?
No, I would tell them,
you
if
got
they said
something?
call them, I would tell them to call.
You tell them to take some action to defend themselves, right?
Sure.
Step on. Yes, I'm sorry. Go ahead.
Brought that up. So you got served with a civil summons from Montgomery County and you knew well enough to go into make arrangements to get that taken care of, correct?
Yeah, last year, yes.
And when was that?
Last year. It was right before I had filed bankruptcy.
Okay. And then you've still got the DUI pending.
Yes.
And you were told when to appear in court on when did you get the DUI?
Back October the 23rd.
Right when you filed for bankruptcy.
Right.
I mean, we're
28, 5 days after.
5 days after you filed, you got it in October or November of October of 2024.
Yes.
And have you've done what you've been told to in that court?
It was bound over to the grand jury.
Bound over the grand jury. Have you appeared every time you're supposed to appear?
No.
Who's representing you on that?
Brian Edson,
Okay. And if you had to take funds for that?
just $1,000 so far.
Okay.
Anything else? Step down. All right, so we've reached the noon hour. We're going to break for lunch. How many other witnesses do we have? Other witnesses? All right, I'll hear you after lunch, the argument.
There's something you won't mind, a specific
You're going to have to come back after lunch if you want me to make a ruling from the bench anyway, so. Well, obviously, I'm going to need to review my notes and the files, so I'll take a little bit of a longer lunch hour to do that. Let me see what's going on with the other cases we have. We have Blanchard versus Blanchard. The divorce decree. It leaves this parenting plan as well. That leaves us with Butler versus Butler. All right, just give me a time estimate. Couple of observations about this case before I make my ruling, and one of them is that clearly this is a long-term marriage. Parties were married in 1998. From what I'm seeing in the proof, they have 4 children together. For whatever reason, Mr. Johnson has not been exercising any of his visitation. I know a couple of the children are here with Mrs. Johnson. It's unfortunate that children, even adult children, have to sit through listening to all of the dirty laundry of their parents and all of the reasons why their parents are no longer married. hopefully, Mr. Johnson, you've got adult children and you can work towards resolving whatever issues there are. To those children that are here, I would simply say you only have one father. Whatever he's done in the past, I'm going to deal with that today. But I hope that you all will all find it in your heart to try to set aside what's happened thus far and to try to come back together as some sort of a family to whatever extent you can. It's not my place to tell you that. I'm just saying it's my experience has been that sometimes when you lose a parent, it makes you more appreciative of the fact that even an imperfect parent is better than no parent at all. So I will now deal with this particular situation. In this case, I'm being asked, I think, to set aside, not necessarily set aside, but to amend a default judgment that I did not enter. If that's not something I normally would agree to do or would do, in this particular case, the motion that was set for hearing on the motion for to set aside the default judgment was set before Judge Turnbow, and then an agreement was entered because of the rotation system that we have. It was going to be 4 months or longer before they could get back in front of the judge who issued the default, so they opted to try to get something done because, if I understood correctly, the house was the main issue trying to get that sold. And for that reason, they agreed to have Judge Turnbow make some decisions in the case. Or in that order that was entered, the default went down on April the 3rd of 2024. The order that Judge Turnbow put down was not entered until, I think, November the 22nd of 2024. And I never see that date, November 22nd of any year, without thinking about the day Kennedy was assassinated, because I remember it. I was in school at that time. In any event, that order set forth the following. It is ordered to judge and decree that the motion to set aside the final decree is and shall be amended to a motion to alter or amend as it relates to the following. And then it set forth 5 different areas that this court was then required to address. One is the amount of money owed to the wife from the husband's retirement account, including but not limited to the funds withdrawn by the husband prior to the filing of this divorce out matter. And 2, the amount of money owed to the wife mother of retroactive support calculated from the date of the party's separation up to the date of the divorce. The amount shall be determined based upon the requirements of child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days each child resided with the parent. The husband and father may also request credit or offset for any marital debt payments he solely made during this time of separation. Number 3, the amount of medical reimbursement owed by the husband to the wife for the medical expenses the wife incurred after the husband's cancellation of her health insurance. 4, the amount of current child support owed by the father. The amount shall be determined based upon the requirements of the child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days each child resided with each parent. And 5, the husband's ability to pay the monthly mortgage payments as well as the monthly payment due for the installation of the swimming pool at the marital residence. And that is then that order went on to order that the house be sold at a commercially reasonable price, and that I think any portion of that would be paid, 1/2 the husband, 1/2 of the sale proceeds would be paid to the clerk and master, and that's what is on deposit. So a Rule 59 motion to alter or amend is a rule that's basically asking the court to come back in and make an adjustment or a change to a prior existing order and to make a different order or in certain respects. My understanding of that rule is that it lies within the discretion of the court to determine whether or not there's a justifiable reason or cause for the alteration of the original order. I have heard the testimony of both parties in this particular case, and it is this court's opinion that I have to base this, at least in part, on the credibility of the parties. Well, when I come to the credibility of the parties, there's really not much of a contest in that particular situation. Unfortunately for Mr. Johnson, the court makes the following findings of issues that directly bear on his credibility regarding the issues that are before the court. One is that he has been accused of and admitted to embezzlement from a prior employer. That is a fundamental act of dishonesty that, as a famous woman once said, the evil that men do lives after them, but the good is often interred with their bones. Well, what that means is that the bad things that you've done in your life that regard to your honesty will follow you around. And so this embezzlement issue is one that the court has to consider on the issue of your truthfulness and honesty when you testify before the court. The second is that there was a check kiting scheme that you've admitted to, and that check kiting scheme is again a basic dishonesty where you're kiting money between bank accounts to represent that you have more money than you do, and that has been admitted by you as well. The issue about the solicitation or involvement with prostitutes or escorts or whatever you want to call it, has been made a big issue. And this court doesn't place a lot of emphasis on that, with the exception of the fact that it does show that there may have been some dissipation of marital assets during the marriage. All of that occurred prior to the filing of divorce, and she did stay with you after those things had come out. I'm not sure if that's a lack of judgment on her part or just the fact that she's made every effort to stay in the marriage for the sake of the children. But the sale of marital items that occurred according to the testimony to help repay the embezzlement or the check kiting scheme, again, would be, in this court's opinion, dissipation of marital assets. Then we have the withdrawal of the 401k. The 401k withdrawal represents an attempt by him to withdraw the what are clearly marital funds, and that may have occurred prior to the filing of the divorce, so that it was not a violation of the statutory injunction, but still it is a withdrawal of that. And I'll deal with that as a withdrawal of the marital asset, which I think without notice to the wife, which again is a fundamental issue. But for the purposes of this hearing, one of the most fundamental problems that I find with Mr. Johnson's credibility is the fact that there's no question in this court's mind that he fraudulently obtained a third mortgage on this property. And he did so by forging or having someone else forge his wife's name and having his aunt then notarize that signature, or whoever the notary was, whether it's his aunt or some other person. That problem puts him, that transaction puts him and all others combined that are involved in that particular situation in legal peril of a criminal jeopardy, because that is basically a fundamental forgery that not only affects Mrs. Johnson, but theoretically affects the lending agencies that occurred to that. A notary public, and I will say this when my wife was my assistant in my office, and she was notarizing things, and we had some issues because she would not notarize anything unless they sat in front of her and produced proof that she didn't know them or who they were. And that's the process that you're supposed to go through, because the notary public says they are certifying on their oath in their office that they are notarizing the signature of this person and that they know them or have proof shown to them that person's identity. So this situation with this third mortgage is, in my opinion, a major impediment to this court giving Mr. Johnson credit for some of the testimony that he's made. His invocation of the Fifth Amendment, as I told him, he has every right to do that. But in a civil case, it carries with it an implication. What you're saying is, I decline to answer the question that has been asked of me on the grounds that my answer would incriminate me or possibly would incriminate me in criminal conduct. So what do I take from that? I take from that is basically saying, I'm not going to give you any information that was served to convict me, but I'm going to tell you that my answer would likely incriminate me in criminal conduct. So this court is of the opinion that I can still render an opinion and give fairness to the parties based on what I think the proof has been. Because the dissolution of a divorce and the division of property in a divorce is supposed to be equitable or fair without regard to fault. So while Mr. Johnson clearly has been at fault in a lot of issues, it wouldn't necessarily mean he would get nothing out of the divorce. So I'm going to grant some relief in this situation, and in my discretion, I'm going to make the following findings on these issues that were presented to me. Number one, the amount of money owed to the wife from the husband's retirement account withdrawn, including but not limited to funds withdrawn. According to my calculations and my notes, the Vanguard retirement was withdrawn and it was $28,076.36. Mr. Johnson, through counsel, argues that he should only have to pay her one half after the tax deduction, and this court finds that that argument is not well taken because clearly it was done without the knowledge of Mrs. Johnson. Had she been advised that he was going to do so, she would have had the opportunity to roll her half of that account into a situation where she would not have to pay any taxes on it. So I find that he owes her $28,076.36 on that, based upon that fact. The amount of money that owed to the wife or mother for retroactive support, calculated from the date of the party separation and the date of the divorce. According to the information that I've been given, the child support that was calculated at least $6,000. Look at all of these notes. I won't be able to run through everything I looked at. Not exactly the easiest thing to do while you're trying to eat lunch, to go over all of this information, but he owed child support calculated child support of $26,016. And I credit that because in the bankruptcy act that he filed, he affirmed under oath, which is a judicial admission, that he owed that $775 a month. And $75 a month is shown to be the retroactive child support, and it is going to be upheld as a retroactive amount. So there is a $26,016 in retroactive support. Mr. Johnson argues that the $94,000 that he has alluded to having paid in support ought to be, or for family expenses and so forth, ought to be credited to him dollar for dollar and offset any kind of back payment that he owed. He paid house payments of $34,149.96. But of those payments, half of that would have been his responsibility anyway. And so half of it would be attributable to her, that she would have had that obligation. So even in the best case scenario, which I am granting him some relief, I'm ordering that the amount that he would owe her would be the $17,074.98. That would be the credit that he would receive, would be only half of the amount he actually paid. So he gets credit for $17,074.98. And I am going to order that be applied because there's no other order down that would stop that. Everybody who has children owes support for their children, and they owe it from the date of separation to the present, regardless of whether there's a temporary order down or not. Ms. Salinas but pointed out there was no temporary order and no request for retroactive support, but nonetheless, those children didn't subsist by themselves. Mrs. Johnson was supporting the children and paying all of their expenses, but I'm going to credit that $17,074.98 that he paid on the house payments during the separation against his $26,816 in child support. That leaves a balance of $8,942 that he would have owed in the retroactive support. He canceled her medical insurance, and under that, I'm of the opinion that it's clearly shown she had $4,422.38 that was owed for medical expenses that she could not cover with insurance. He owes her for that because it's cancellation of her medical insurance without notice to her obligates him to pay it. On the Vanguard retirement, I've already stated that he owes her the entire amount of $28,076.36. There was a court-ordered child support obligation of $6,975. That child support order has been affirmed, as I've stated, up to this point, and it will be also an obligation that he owes. And then the fraudulently obtained second mortgage or third mortgage of $20,125.54. I've wrestled with that particular situation because clearly that mortgage was borrowed and then it was paid out of the equity of the situation. And so you can make the argument that she would only be entitled to half of that amount because half of the equity that he borrowed was up to him. But the fraudulently obtaining a mortgage in that particular situation, even if it was to pay off the things that he had let get behind, fraudulently obtaining a mortgage, forging someone's signature is such a reprehensible and illegal action that this court is of the opinion he is not entitled to credit for any of the portions paid to her. So or any of the portion that would normally have been credited to her for that the third mortgage. So in my opinion, he does owe her $20,154. I'm sorry, $20,125.54 for the third mortgage that was taken out fraudulently. That brings to my calculations $68,541.28 that he owes her with all the credits I've given thus far. The statement made by Ms. Roberts, and I may be incorrect, shows that she's crediting him payments of $4,157.50, and the insurance and equitable refund on the sale of the property of $3,960.63, which deducting those two figures leaves him owing her $60,423.15. And that is the judgment of the court that is the amount that she is entitled to out of his portion of the sales price of the proceeds. I have considered, and for the record, we'll go through these family support payments that Mr. Johnson has asked to consider. I've dealt with the Lakeview loan servicing house payment. The car payment, again, there's no court order that required him to pay it, but again, there's no order that says he's entitled to any sort of credit. In addition to the pool payments, I just simply don't find that those were payments that, there was no agreement that he would be responsible for them. So if he did so, he did so on his own. The medical bills, I've addressed those medical bills that he owed. The medical bills that he may have paid for the children were medical bills he would have owed anyway. The sports payments, I do not find that he is entitled to reimbursement or credit for payments that he made for the minor children and the adult children, or the ones who were adult, for $5,157.60. The insurance, again, through pay stub, if he maintained medical insurance on the minor children and the family and so forth, that's something that I think he's obligated to do anyway. And as a result, I don't think that he is entitled to any sort of credit for that. Neither do I find that the monetary assistance through Venmo are matters that should be credited against those things. There are miscellaneous items ordered for the benefit of the family that going through them, I simply don't find that those are things. I think it's kind of straining at everything to try to get a little bit of credit, and that comes to Tennessee Tech. I'm glad you were paying for your daughter going to Tennessee Tech, but that's something that's not court ordered. It's not a legal obligation. It may be a moral obligation, but not a legal obligation. And I've reviewed all of those, the other two, the CW pools for maintenance and the fits and turf, and don't find that those items require any sort of adjustment. So I've made that ruling. I will now address the issue of his personal property. Yes, it was ordered under that decree that he had a certain period of time to try to recover his items of personal property. In my opinion, based on the problems with the address, that I'm going to order that he can still try to recover any of those things that I found are entitled to him. I'm not going to go through every one. Clearly, there are things that she says she doesn't have. There's no dispute about his kayak and paddle or his mountain bike, or his 8-foot and 6-foot Werner ladder, which have been highlighted on this list. Those are things there's no dispute about. His class ring from 1988 If it's found, he gets it. The same thing with his gold ring that's broken. Solid gold cap from his teeth. If it's found and it can be turned over to him, I'll award it to him wherever they may be. If it's, he finds it or she finds it, then he gets it. I'm awarding him the DeWalt ratchet and socket set and the drill and impact drill and sawzall, and the work light and leaf blower, all of which I think are those items that he would be particularly inclined to use. The softball equipment, it's my understanding she says she's turned over to him everything that there was in the way of softball equipment. If there's anything else that belongs to him, just give it to him. The antique cast iron skillet passed from Elsie Mae Bradley's estate. I'm assuming that's, and I don't recall from the testimony if that's a family member, but I'm going to go ahead and award that. You get that. Same thing with the 8x10 Star Wars actors. And then these wildlife prints, will order that be done. I am not going to award him the zero-turn lawnmower because that, in my opinion, is something that she needs for the house, wherever she is. And the weed eater is the same. I will give him the 2.5-ton jack. His softball equipment bag. The Fender guitar was supposedly in the possession of the daughter. He wants to take it away from his daughter. I'll leave it up to him, but I think it should be left with her. Pressure washer. I am not sure which one of them has any use for that, but I'll award that to Mrs. Johnson. And I don't know if I said this, the weed eater needs to stay with the home that she's in. Various hand tools and so forth, I don't find that I can send him over there to let him start going through, picking up every other hand tool. And let me comment on the fact that, as has been pointed out, Mrs. Johnson received the majority of items in the household furniture and furnishing. That's true. But those items have been apparently accumulated during their 27-year marriage. Mr. Johnson, upon their separation a couple of years ago, went out and purchased items of personal property, household goods, furniture, and furnishings. Those were purchased using marital funds, and technically and theoretically, they are marital property. He has awarded all of those items, and I think that offsets any other issue. I am not going to award attorney's fees in this case because of the fact that there was some issue regarding the addresses on these notices of the motion, and the fact that I am granting some relief on the motion to amend, so therefore I'm not going to award attorney's fees. Anything that I've not addressed? We have stipulated about the trial support further. Others is adult. If it's found, it burns up in a word, something you don't know where it is.
Well,
I cannot make a finding that you're in possession of the two when you say you're going to go. I obviously intend to for me.
Yeah, 30 days now. See, contribute some.
I'm not making a finding she has them. I'm simply saying he's awarded them wherever they may be. And that's obviously if she finds them, then she must turn them over to him. The other items that are there that I have delineated, then he can pick those up within a reasonable time agreed upon by the party.
So completed the 28,000 and 76.36 for the Vanguard, 4,400. $70,000.
4157.51.
So I have total, $0.17. And again, I will dispense as there's 78,000 held clerk of the court, and I'll be.
Once 30 days, I mean, if they agree to pay it, fine, but I can't order it dispersed until after 30 days from the entry of this order of the law.
Well, and I'll be filing, I have a secondary lawsuit against him on forgery, and I'll be asking for a restraining order, trying to pay me the rest of that money now, on that suit.
Is that the notary public?
The notary, because the notary under her is liable for dollar for dollar law on what she has done, and so we modified that, so I think we have a right to see that from.
All right. Well, that's my ruling. Thank you.
Thank you.
That brings us to our final case, Butler versus Butler. Sorry, I got anything out of order. Well, you'll be lucky if you don't have food all over it. I did that during my lunch hour trying to.
Yeah, I'll be, I've got,